Services into corporate insolvency in Australia. I begin by acknowledging the traditional custodians of the land on which we meet and pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee will be conducting today's hearing in person in Canberra in the main committee room and via video conference. These are public proceedings being video streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they're protected by parliamentary privilege. It's unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It's also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. The Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and should be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request the answer be given in camera. Commonwealth officers appearing today are also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised. A copy of the order is available from the Secretariat. I remind committee members and witnesses who are appearing via video conference and who are not speaking to mute their microphones. I now welcome representatives from the Attorney-General's Department and the Department of Treasury. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
Tom Dixon, Assistant Secretary, Corporations Branch and Treasury.
Zoe Irwin, Acting Director, Corporations Branch, Treasury.
Alice Lineker, First Assistant Secretary, Courts, Tribunals and Commercial Division, the Attorney-General's Department.
Jenna Priestley, Assistant Secretary, Commercial and Copyright Law Branch, Attorney-General's Department.
I now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Thank you, Senator. I'm happy not to make an opening statement.
In lieu of an opening statement, is there anything in your submission to us for which we thank you that you think you want to draw the committee's particular attention to?
Well, in our submission, we essentially just canvass, an overview of the framework and the recent policy developments. So, given the general nature of it, I think I'm happy to let it speak for itself.
Wonderful, thank you very much. I might kick off then before going to members and senators in the room. What I'd really like to understand is what your sense of the current corporate landscape is in insolvency. So if I can just frame my questions in light of evidence that's emerged in the submissions, which I'm sure that you have read, which give shape to rising numbers of insolvency, concerns about the sector, the post-COVID realities of business in a different environment with inflationary pressures, etc. It seems it's very timely to be undertaking this. I guess in terms of the outcomes that have been described to the committee in the preliminary work that we've done, my first question to Attorney General's Department, probably in the first instance, is it a good outcome for creditors in the economy when only 1 in 14 businesses is currently filing for insolvency, compared to 13 out of 14 just letting the business be deregistered? And is it also a good idea to continue as we are when 92% of unsecured creditors get 0% return? That's 92% of creditors get 0% return in the event of a collapse. So at the heart of it, is this a functioning and fair system?
Perhaps one thing that might be helpful to the committee is if we perhaps talked a little bit about the responsibilities that Treasury has in relation to Attorney Generals, and perhaps that question might be something more appropriate for Treasury to answer, because we have responsibility for the corporate insolvency system. Attorney Generals would have responsibility for the personal insolvency system. So With your permission, would it be okay if I help with that answer?
Yes, Mr Dixon, thank you. But can I just point to the assumption that's embedded in your response that it's personal insolvency and not corporate insolvency. And one of the other things that's come up in the evidence is the data poverty around exactly what it is. So at the moment we're talking about an amorphous mass of insolvency, and we're a little bit unclear about exactly where that is, if it's micro, small, medium, enterprise or corporate. So my questions speak into that current reality.
Understood. So
Thank you.
Perhaps a way I could frame the answer is to talk a little bit first about what we see as the objectives of the insolvency system and the principles that underpin that and how that works. And then that might illuminate the rationale for why you might be seeing some of the outcomes that you're seeing and explain, or provide a perspective on how to examine those outcomes. Is that something you'd be interested in?
Yes?
So generally, one of the things that we often observe in the corporate landscape, just in relation to insolvency, is a misunderstanding around what the insolvency system is trying to achieve. Insolvency sits as one part of the regulatory life cycle. And of course, there are other parts of the regulatory life cycle that deal with starting up a business or capital raising, restructuring to avoid insolvency. But the insolvency system itself actually deals with, I suppose, the fundamental definition of insolvency, which is an inability to pay debts at a point of no return. That is, once you're insolvent and you're unable to pay debts, it's not the case that you can simply sell an asset. Like, that's not defined as insolvency. Insolvency isn't a situation where you could borrow money or you can sell assets in a reasonably short period of time. So you're dealing with the point at no return. Hanging off of that then are a bunch of principles about, well, what do you do with that scenario? And the principles that operate are those that, I suppose, go back to Harmer in the 1998 report, which is that there is a fair and orderly process for dealing with insolvent companies, that you're trying to enable both the debtor and the creditor to participate with the least possible delay and expense, that the insolvency administration should be impartial, efficient and fast. And
Can I just stop you there? If you just read that last little section that you said to me there about the fair and orderly, from fair and orderly, the Harmer principles.
yes, so a fair and orderly process for dealing with insolvent companies.
Yep.
You're trying to enable both the debtor and the creditor to participate with the least possible delay and expense.
Okay.
The administration of the insolvency should be impartial, efficient and expedient.
Yep. That's great.
And that you're recovering assets, when you're recovering assets, that should be convenient and properly applied to the payment of debts. And that there's a principle of equal sharing between creditors, with the end result that there's an effective release from liabilities for those that are involved. There are some other principles around supporting the commercial and economic objectives, and you're trying to harmonise with general law, and there are other things, but they're the core.
So can I just go to the one that seems critical in the evidence that I've read from the 55, is it still 55, Secretary, that we've received, subs? It's about 55 subs so far, and it remains open. So people who are participating or watching or want to put in a sub, we're interested in hearing from you. That the debtor and the creditor can participate.
Yep.
The thing that seems to be missing is to what end?
Yeah.
To what end? Because I go back to my statement that 92% of unsecured creditors get 0% return in the event of a collapse. So what's the point in participating in something that's going to cost money to do where you get zero anyway? It's costing you to be involved in it. So do you have a response to that overarching concern?
Yeah, absolutely. So the fundamental tension that insolvency law is trying to deal with is the downside that's involved in risk taking. So people that are trying to be entrepreneurs and innovate and produce product and foster employment. So you're trying to grapple with the downside of the risk taking while regulating conduct in a way that doesn't suffocate risk taking. And looking at the history of insolvency law going back to the 1200s, that's what it was. It's always been the tension that's existed. Now, insolvency law can deal with part of the challenge, which is to foster a smooth process, ensure that the process is understood, that it's predictable, and address the distribution of assets when failure occurs. But what we don't have are laws that prevent people from being entrepreneurs and having a go, and we don't have laws that prevent people from experiencing losses. And losses can occur for a variety of reasons, and you would see, changes in the weather. Right, so you can have dramatic weather events that can generate losses. You can have unanticipated changes in market conditions. And so out of that outcome, there can be no assets left to distribute. And that's how you can find an outcome that you're describing, which is there are 0 cents in the dollar for some people at the end of the process.
So 92% of unsecured creditors get 0. That's a lot. That's a lot of creditors who miss out.
Yep.
And that, as Mr. Pitt puts out, that could be best case. So I understand the principle of why this was established. There seems to be an important public good that's embedded silently in the rationale.
Yep.
What is the public good of insolvency? I don't know that we're really having that discussion at this point.
In terms of the public good, so what you're trying to foster. So if I take you right back to the 1200s, so when Australia's law is based off of English law, and going back to almost the Crusades, I suppose. So there's this desire that what we want to see is, well, going back to the Crusades, what people wanted to see in England at the time was the import of capital. And so one of the reasons why England wasn't seeing the import of capital at the time is there were no laws to deal with debtors that were just absconding. And so they put in very stringent laws that penalised people quite heavily if they were to abscond, if they were just a debtor that absconded, regardless of the reason that was given. And so the original rationale is that what you're trying to do is hold people to account such that you can have security for creditors, and then that security for creditors generates the desire to lend money into an economy. You get the inflow of capital, and as a consequence, you can generate economic growth. So, economic growth is the one of the objectives.
And that is a broad principle, but in practice, again, I come to that reality of 92% of unsecured creditors getting 0% return. So they are not getting anything that's being touted in those principles. They're completely missing out. And many businesses would have a long, long list of unsecured creditors, which has a flow through the economy. So I guess that kind of brings us to the core question, like what is the fit, and is it fit and proper to have the current structures that we have, given what the minimal data that we have is starting to throw up about what's going on in this space?
So essentially what you're describing, I think, is a situation where a business has made an attempt to provide some sort of good or service. The business has failed. It's tried its best, but in some cases that means that there are losses that the business incurs and there are no assets left, or very few assets left. So the insolvency system deals with the point of failure. So what it tries to do is say, well, given what's in front of us, what can we do to make the best of the situation? It doesn't.
But who is the us in that sentence, Mr. Dixon? Because what's happening is, if you look at the figures from ASIC, is the deregistration of businesses is just happening by ASIC. People are just pulling down the shutters and walking away. They are not declaring themselves bankrupt. They're not declaring themselves insolvent. They're just moving on. Now, the director identification number is going to deal with the situation or change the landscape, at least for those who have directorships. But for those without directorships, what's the point of engaging with insolvency practitioners?
Well, One of the key roles of insolvency practitioners is not just to look at the distribution of assets, but also to determine if there's been any wrongdoing that's occurred. So they actually also have a regulatory function. So
But that's good for us. That's good for the public.
Yep.
What's in it for the business?
Well, the business, at a point of insolvency, it's reached that point where it's not able to continue. It's reached the point of no return. It's not in a turnaround situation. It's not in a restructuring situation.
Can I thank you for those few words? I think at a point of no return is really important because, again, in the evidence we've received, there seems to be considerable debate about who determines when a business is at a point of no return. And I think there's a case study here from ASBFAO that I want to read into the record to get your response, because I think it highlights not what's happening with all insolvency practitioners, but this is what businesses are experiencing, sharing and talking about and thinking about in terms of what's happening with engagement of an insolvency practitioner or advice about what's the state of my business. So this is the case study on page... it's under recommendation 8 in ASBFAO's submission. A small business had entered an insolvency administration. They've got to that point, assuming that they can't. They're at a point of no return. With assets worth $1 million. The practitioner had initially advised the small business that the cost to liquidate the companies would be around $60,000. However, half a year later, these costs had increased to over $500,000, over 50% of the value of assets. On top of this, no disbursements had been made until that point. The small business contacted us, that's the ASBFAO, the Small Business Ombudsman, for assistance after they expressed their concerns to an insolvency association about the length of time taken and the costs involved. We also wrote to the Insolvency Association seeking clarification on the liquidation processes. The association responded that while there were some minor deficiencies in how the practitioner operated, everything was transparent and no changes were made. There was nothing to be done about the fee increase. This case study demonstrates the high costs of liquidation and the lack of certainty regarding fees. That is a common understanding of what happens when perhaps the ATO triggers, it's a DPN, is that the correct?
A director penalty notice?
Yes, a DPN.
That can
I just want to make sure. Yeah,
yes,
so
some
that can
cases
trigger.
be a trigger, yeah.
Right, or the bank might trigger because it's a secure creditor, and the process can happen very, very quickly, and somebody's not familiar with this, an insolvency practitioner is brought in, as in this case. I don't know about my colleagues, but frequently this is what's advised to us in terms of insolvency. Now, added to that, insolvency practitioners talk about how important the work they do, often unpaid for micro and small businesses.
Yep.
But then we hear about distortions in the fees that are charged then of companies that are seen to be big enough to be able to pay extraordinary amounts. So again, I go to my question. Is the current insolvency structure in Australia a fit and fair system, given that outline that I've just given to you, Mr Dixon?
So going to that case study that you mentioned, it's always difficult to comment on case studies without having all of the facts of the circumstance in front of you. But by and large, I would say that the insolvency system we have is not fundamentally broken, but there are areas for improvement. And there are areas where there are costs that are driven by how the insolvency system operates. In the
What
case
do you
of,
mean by that, the documentation that's required?
So in the Australian system, we have very clear processes for entities that are companies, but we don't have very clear systems for other types of entities. So, for instance, trusts. Trusts are quite a common feature of small business. And one of the things that occurs when you're liquidating in the trust environment is that you're often not able to just rely on judgments of creditors, but you're actually finding yourself in the court quite often. And as a consequence of that, there are court fees that are often charged. And if you're always going to court and there are always these high fees charged at the court, you can rack up fees very quickly. So there are opportunities, as I say, to look at where you might want to improve the system to provide certainty in the process and to lower the costs that are incurred.
Thank you, and that kind of leads to some common solution that's proffered, just offhand, Chapter 11 and the US is a solution, but when you start to look at that, the court engagement and that and the cost of that actually create a slightly different shape of problem, but it's still a very expensive process. In addition to the stats that I've just put on the record, in the submission number 18 in our pack, which is from 2 academics, I believe it might be Murray and Harris, they not only describe the nature of return, which I've been asking you about in my repeat of that question, they give us the figures that in almost every corporate insolvency where the practitioner filed a return with ASIC, there was virtually no prospect of meaningful financial return to creditors. 18% of liquidations, the liquidator estimated there would be no remuneration, meaning the liquidator is effectively working for free.
That's correct.
Now, I think that's a really important thing to put on the record this morning as the other side of the equation for the comment from Asba Fayo. And again, I ask, is this a fair and functioning system where we have private enterprise undertaking work for free, cross-subsidising their own businesses by higher fees of those who can be seen to afford to pay for some reason, which no doubt would be putting out some of the unsecured creditors, pushing them further down the line. Is it a fair and functioning system? Because these things make me think that it's not working. And in the context of, reports, and I note the recent article in the Sydney Morning Herald by Jessica Yun, business collapses are expected to nearly double next year as experts predict that mounting costs and climbing interest rates combined with a significant slowdown in consumer spending and a more aggressive tax office will push businesses over the edge. All of this is very timely and very concerning to me. Is it fair and is it efficient?
So in terms of the question around, well, where should the costs be borne for insolvency practitioners? So
Yes.
the costs are borne somewhere in the system. So there are suggestions that we've heard that those costs should be borne by taxpayers. So the taxpayer should, or the government should provide some sort of service that helps with the liquidation of corporations. And of course, what that doesn't do is it doesn't reduce the expense, it just shifts the expense from one place to another place.
Yeah, but it's shifting. Like if we've established that insolvency is something that is in the public good, which I think was your initial evidence, and historically has been so, I'm not looking for more debts for any government, but at the same time, businesses need to be able to operate transparently in a market that responds to the reality. Again, in the sub from Murphy and Harris, they talk about the official receiver, which is the role that you're talking about, the public provider of an insolvency practitioner.
Yeah, in a personal insolvency.
Right.
Yep.
And in a public, in a corporate insolvency, what's the alternative?
So, as you correctly point out, there's an official receiver, and that's essentially a government-provided liquidation service, if you like, bankruptcy service. And in the corporate world, it's a private administration that occurs, so there is no equivalent.
Chair, can I ask just one
Please,
follow-up
yeah, and
question?
Mr Pitt has one as well.
Go to my legal friend.
Just one follow-up question, just on this. Do you reckon, and I note the comment you made, Mr Dixon, about shifting costs, but you recognise that one of the issues is that liquidators, administrators have duties which they have to discharge under the Corporations Act and generally at the law. So there is a dynamic here, which the Chair referred to, of liquidators not being able to be remunerated, but at the same time being legally required to do things in order to discharge their duties. So in that situation, the situation is more nuanced than simply we're shifting costs from this area to the other area, because the liquidators are actually required to do a heap of things under the law in order to discharge their duties, and that law is imposed by Parliament, by government upon them. Do you recognise that?
Yeah, absolutely. And one of the things that's also a feature, I should point out, is that we do have something called the Assetless Administration Fund. So a liquidator can apply to ASIC and receive remuneration for undertaking assetless administrations under circumstances.
And how many of those have been undertaken?
I don't have the statistic in front of me, but I'm sure ASIC would have that information for you tomorrow.
And how long has that been operating?
Again, because it's administered by ASIC, I don't have that information to hand, but I would recommend bringing that up with ASIC.
Just picking up on Senator Scarr's comment there, again in sub 18 from Murray and Harris, they talk about public interest work and some of the public tasks, the investigations of misconduct under S533 of the Corporations Act and related sections, the referral of offences to ASIC. That's a requirement. So although almost 20,000 offence referrals were made to ASIC each year, only a tiny fraction of cases are actually brought to the regulator. Lack of evidence, books destroyed, perhaps never kept. They cite a 2013 study quantifying the annual contribution of liquidators at over $47 million by way of unfunded work. Again, do you think this is a fair and effective system?
So in relation to ASIC's enforcement, I'd refer you to ASIC to answer questions about how do they decide to prioritise and resource cases. But you do, as you've pointed out, there are places in terms of the way things are administered that do raise questions.
They do raise questions, yeah. They're certainly raising questions for me. And some of the submitters have indicated that while in principle the construction of the law has served a good purpose, that it perhaps is no longer fit for purpose, and that in addition to the inquiry that we're undertaking to kind of get the shape and the nature of things on the record, that there's a need for a root and branch review of insolvency law, and particularly teasing out the difference between personal and corporate insolvency. So I might just go to the Attorney General's, unless you want to pick up one there, sorry, Mr Pitt.
On a separate line of questioning. So.
Oh, okay, I'm going to change topic.
Okay, sure. Just a couple of questions. Having been involved in a number of these on the wrong side of the ledger and not get paid, it was news to me that insolvency practitioners don't get paid. Everyone I've been involved with, they've got paid an enormous amount of money and left everyone else hanging with nothing. So that is news to me. Taxpayers already paid for entitlements in company collapses in any number of circumstances for extraordinary amounts. And my questions are about the trigger points. Now, clearly in small business and other entity arrangements, the bank and the tax office are the two that are closest to it, would be my view. I'd be interested in your comments about what you are seeing in terms of actions from the banks. I mean, their usual practice used to be at the moment that it looked like you're under your limit in terms of loan ratios or ability to pay, they'd increase your interest rates. Which created an enormous amount of problems for people who were struggling. They just made it worse. So there was a very large tendency not to tell the bank much of anything. So I'd be interested in your comments around that trigger point and what current practices of the banks and the tax office in particular are in these current circumstances.
So my experience really commences with the pandemic, and the anecdotes that I am aware of are largely around forbearance and actually operations outside of the insolvency system. So one of my earlier jobs in the pandemic was actually to do business liaison work, and so take calls from CEOs of companies across Australia, and they would talk about how they were making arrangements outside of the system to say, well, it looks like we're all going to have to take a haircut, so I might have to take 30% of the loss. The bank takes a portion of the loss, and say our landlord or someone would have to take a portion of the loss. So what we're actually seeing is perhaps a trend outside of the insolvency system, recognising, perhaps for the points that have been raised earlier on, that sometimes as a creditor there's not much joy in going through that system, so perhaps we could come to a more reasonable arrangement outside of it. So, so the only anecdotes really that I've heard are around, at this point in the cycle, have been forbearance now. There's a question as to whether that actually continues, and there's a question as to whether that's perhaps we're seeing a change in attitude, but I haven't got any evidence of that to report.
We haven't seen a change in profits. I mean, that they're still making plenty of money is what I'm seeing. The pandemic, I think, is a very extraordinary circumstance because it was worldwide. It cost the taxpayer a couple of $100 billion to get us into the financial position we're in. In terms of the ATO, what are you seeing and what commentary has there been around the tax office and their decisions?
So I haven't seen anything that's different in relation to the tax office, but I understand that they might be appearing. So questions could be directed to the tax office in that one.
Can I ask if you have a chance to have a look at their submission yet?
Not yet.
I might ask you to do that and respond because I think it's directly this line of questioning, but there's some pretty important developments that they've recorded there.
And just one more, and this is a very frank question. I mean, how do we do better? How is this managed better? Do you have any suggestions or recommendations?
So one of the ways to look at it is if you're focusing solely on the insolvency system, then you're looking at the part of the system where you're at the point of no return. So ideally what you'll be doing is you'd be looking at making sure that viable businesses don't end up in the insolvency system if it can be avoided. So if they're a viable business, what can you do to prevent a viable business from entering in prematurely?
And what would be the two agencies or the two entities operating in the Australian economy most significantly triggering the entry into engagement with the insolvency sector?
So in one sense, you could say that perhaps the trigger is caused by a creditor, but in another sense, you could say that the financial affairs of the entity are actually in control of the owner. And really, if the owner is able to do a better job of managing finances and affairs, but also with respect, sometimes the best manager or the best owner in the world just has bad luck. And so you can find yourself, like as we've seen with floods, there are people that are just experiencing circumstances that are just out of their control. So there are some, so in some cases, you're not going to be able to avoid a scenario that's devastating for the business. And in other cases, it can be down to just bad luck, or it can be down to poor operations of the entity involved. So there are some, but in some cases you could say there are circumstances where the owner should take a degree of responsibility for triggering the insolvency event. It's really then the responsibility of agencies then to protect their interests, given, particularly say in relation to tax, it is of interest. It is of interest to us to make sure that employee entitlements are also looked after. And so there are agencies that are involved in that, and sometimes they do have to take the steps to administer those interests. So in one sense, I wouldn't want to characterise a regulatory agency as the villain in the story that's causing something to occur. They have responsibilities that they're undertaking and trying to do that in the best and sometimes most sensitive way. In some cases, I would imagine that, as you've seen during the pandemic, there was considerable forbearance from regulatory agencies. So it's about, being sensitive to the climate and the circumstances in each case. But as you say, if you're looking for, what are the entities in the economy that are largely responsible for looking after certain interests and maybe then initiating some sort of proceeding in the insolvency space, the tax office is one of the largest, and banks are also one of the largest.
Yeah. So we've got the tax office coming in. I don't know if we've asked any of the banks or their representatives yet, but we certainly will do that because that behaviour is critical to it. I think I've had the same sort of experience, Mr. Pitt. Not recently, happily, but certainly I can attest to the truth of what you've just put on the record there. The ATO have made a couple of contextual statements While the ATO is a creditor in most corporate insolvencies, we are relatively minor initiator of corporate insolvency appointments, but they are a creditor. And at point 8 of their sub, they also say it's not been possible to accurately estimate how many appointments of liquidators are indirectly triggered following the issue of a DPN. Do we have data poverty about what's going on when businesses are close to, perhaps wobbling, maybe not at a point of no return, wobbling, perhaps a little bit more time from the taxation department or,
Anyone.
or from the bank or any other creditor could see that business trade out of potential insolvency. They could be teetering on the brink. Do we have any instruments or support services that are satisfactory to assist businesses? Because when they fail, people lose homes,
Yeah.
Mental health costs the
Yeah.
community a huge amount.
Yep.
People might even inadvertently, be triggered to take a catastrophic event and take their own life. Sadly, that is the problem that we confront.
Yep.
And every community that I know has stories like that. So this is something we need to be mindful of from an economic point of view, but it has a social impact as well.
Yep.
Again, do you think, given the nature of the sort of questions that I'm putting to you, this is a fair and efficient insolvency structure that we have in place at the moment?
So I think one of the points that you raised is the stigmatisation of business failure that occurs,
Very important
and
point.
that's a cultural difference that we have in Australia compared to jurisdictions overseas. And going back to say the Productivity Commission's analysis of this particular issue, they did make recommendations to seek to reduce the stigma that's associated with business failure. And a consequence of that, the government introduced the safe harbour for insolvent trading, which I think is, when we talk about trends, I've seen anecdotal evidence that suggests that that's, as well as the review of the safe harbour, which has concluded that that's actually operating quite well and as intended. But as you'd be aware, cultural change takes quite a long time to achieve, but we do have systems in place, as well as not just the safe harbour that was introduced in 2018, but also the stay in ipso facto clauses, which is another one of those things that can inadvertently trigger someone into an insolvency process or compound the effect of that. So those stays are also working, or in effect enabling people to avoid insolvency if they can help it. So there are mechanisms recently added to the system, as well as the simplified restructuring capability that's recently been added to the system. So there are things that have been done to make improvements in that regard.
Given that construction and manufacturing companies seem to be particularly vulnerable at the moment, with huge reach into every, city, regional and rural community, are you confident that the necessary supports are in place to manage this cliff of insolvency that's been predicted?
So in regards to the forecast, as people say, cliff of insolvencies, I've heard that forecast for a few years, and it hasn't eventuated as yet. But one thing to note is that the insolvency system that we have today was the insolvency system that we had during the global financial crisis, which, so if we're operating at roughly sort of 4,000 or 5,000 insolvencies a year now, in the GFC it was above 10. So
Yes.
we've already operated in a time where we've had double the number of insolvencies. So I would say that the system that we do have is robust, and it does cope with peaks and troughs. The question that I think that you're asking might go to perhaps the things that need to go around the insolvency system to support the individuals through the process. So, are there sufficient mental health supports? I think that's an important question. Are there sufficient opportunities to talk to advisors? The government does operate business.gov.au, which is an expert service where people can reach out and seek advice. They do have the Small Business Ombudsman that can refer them to areas for assistance. So there are a number of government services that are out there that can help, as well as private enterprises and turnaround practitioners that can actually provide some assistance.
So I do want to note for anybody who might be listening or watching that the company is entering small business restructuring according to the evidence in sub 5 from the ATO. Looks like it's risen from less than 10 in March 22 to just about 90 by September 22, so there is an increase there. The ATO states they've also observed around 20 companies using simplified liquidation measures in each of the years 21 and 22, so there is some adjustment there, and the question I suppose might be is how familiar people might be with those processes. I also want to acknowledge that the Ombudsman has some funding to support, in particular, regional businesses. So if anybody from a regional area is very keen to get support, perhaps they might want to contact the Ombudsman for that sort of support for their business. If I can go directly to AGs, do you have any comment on the conversation so far, which has sort of teetered on the edge of the differentiation between corporate and personal insolvency? Do you have any remarks about that and the way that's structured at law?
Only to note that through over a course of a number of reviews, the intersection between the personal insolvency and the corporate insolvency structure systems has been looked at and considered, but and I guess the other point is that personal insolvency looks very actively at various mechanisms to ensure that individuals avoid bankruptcy and find other ways, such as debt agreements and facilitated arrangements with their creditors. So it's not dissimilar. So no comments that contradict Mr. Dixon in any sense, but that the two systems do work in a complementary fashion.
Okay, do they deliver equitable outcomes?
From a bankruptcy, personal insolvency perspective, that would be a matter to talk to the regulator about, AFSA. They're appearing this afternoon, but we have no view on that.
So could you just sort of step out for me so I understand in layman's terms, because I'm not a lawyer, you know, I'm just an ordinary Aussie citizen who happens to end up being in the Senate, you know, so I need to understand this stuff. Mm-hmm. What do you understand currently to be the relationship between personal and corporate insolvency? The relationship.
So in respect, there's separate legislative systems. So there is a Bankruptcy Act that goes to individual and personal debt, and then there is a Corporations Act that looks at the debt of the corporation as such. In the most simplest way, that is the differentiation.
So there's two tracks, but where's the intersection between those?
So there is some intersection when we talk about small and micro businesses in terms of whether the individuals are incurring personal debt or debt on behalf of the business or the corporation.
And if you're setting up a business to innovate in your local community, like you start up a house washing business, you're fantastic at house washing, you figured out there's a really good demand, the business is growing, you employ a couple of people, your partner might not have a whole lot of high-level skills, but you know you can't afford the costs of an accountant. So you said, this is how most businesses get set up, right? Because that's innovation. They figure out a hole in the market. They get set up at the kitchen table, they get their Xero or they get whatever, and they get it going. They understand something about it. They can get access to an ABN and an ACN quite quickly. Yep. They might get good or bad advice about whether to be a sole trader or a partnership or a company but limited guarantee. They might get directorships, they might not. All of that they can just make up as they go. They don't have to do any courses, they just get started. That sounds great because you get going. But when things start to fall apart, which is a bit we're talking about, all of a sudden everybody's there watching and there's requirements and there's laws and there's rules and there's a sector that's getting money to the tune of $47 million to prop up doing work to comply with the law for regulators when they come in contact with these. Somehow that doesn't look like a really good system to me from a small business point of view. And I just want to read into the record again a little bit of evidence about personal insolvency, personal and corporate liabilities. This is a quote from the Design of Insolvency Regimes Across Countries and the OECD. And I'm interested to get your view about how relevant this is for Australia. Personal insolvency regimes are often more relevant for entrepreneurs and small businesses. Indeed, the corporate versus non-corporate distinction in assets and liabilities is often blurred for small firms, either because lenders require personal guarantees or security, for example, a second mortgage on the owner's house, or because prior to incorporating and obtaining limited liability protection, entrepreneurs typically use personal finances. Is that a good description of the complexity of the interplay between corporate and personal insolvency?
Senator, I think that's a good description.
Okay. In terms of the numbers of ABNs and ACNs, do you know how many are out there?
It's not a matter that I have data in respect of, but perhaps...
But I just guess the scale of what the potential at law issues could be, given the number of people who are entrepreneurial and who have ABNs, who may or may not be using them, because I don't think we know how many are really active. And the practice that seems to have emerged in the absence of clarity about insolvency and access to insolvency in a price point sensitive way, and with education, it means that people are just waiting for ASIC to deregister them. And we have no oversight about what's going on. Is that a problem at law, Ms Lineker?
I think that...
I'm trying not to ask opinion questions, but, you know, do you see there could be some problems embedded in such a prevailing structure?
I think that the way that the Bankruptcy Act, which is the matter to which Attorney General's Department has responsibility in respect to Corporations Act, I'll refer to Mr Dixon, but the attempt of the Act is not to navigate how businesses or individuals set up their structures. That is a different system. It attempts to navigate personal debt at the point that creditors are unable to, those debts are unable to be met. And so the system itself is about the end point, as Mr Dixon has referred before, and in that sense it actively works to try to ensure that people are able to resolve those debts, that creditors as best as possible have those debts met, and that individuals can then return as...
Ms Lineker, I agree that it sounds like you're describing the law, but on the ground, 92% of unsecured creditors get 0%, and $47 million worth of work to comply with law and regulation based on 2013. One piece of data from 2013 says that there's a shadow public provision of service for the dismantling of businesses.
Yes, I'm not sure, Senator, that the Bankruptcy Act in and of itself meets the challenge that you've set down. I think, as Mr Dixon has referred, there are a number of different structures, including the way that that businesses are set up, that individuals navigate, how they run those businesses and so on. But I would say that the Bankruptcy Act as a legal framework delivers on the outcomes that it intends to deliver, which is to try to allow people to return as fully functioning members of society without that debt, and to give opportunities for the repayment of those debts in the best way possible. So perhaps Mr Dixon, do you have anything you wanted to...
Certainly. So in relation just... you mentioned before about the management of ABNs, and do we have a perspective on the scale of the issue? So I'm aware that the ATO does have quite an active sort of management of the ABNs, and it does seek to make sure that those ABNs are representative of business activity. So you could ask the ATO a little bit more about ABN management. I think a point that is coming out of this conversation is just around the separation between the personal and corporate insolvency system. It is separate. It's separate ministers, it's separate regulators. So, for instance, it's the Australian Financial Security Authority in personal insolvency, it's ASIC in relation to corporate. It's separate, it's different courts in some cases. So, in personal, you've got the Federal Court, Federal Circuit and Family Court mostly, but in relation to corporate, the Federal Circuit and Family Court doesn't play a big role. Supreme Courts can play a bigger role as well as the Federal Court, so there's differences there. There are bankruptcy trustees. I might be using the wrong terminology, but my colleagues can correct me if wrong. But of which there are a couple of hundred. There are insolvency practitioners, of which there are about 600. Sometimes the insolvency it is reasonably common that an insolvency practitioner could also be someone that operates in the personal insolvency space. So there is maybe a degree of commonality there that operates in the private sector, but it's a fact that they are separate systems. And it does mean that if you're a small business, you might be dealing with 2 practitioners and 2 regulators. So if you are designing it from the perspective of the small business, then you might look to what other countries do. So it's quite common in other countries that those systems are combined.
And is there a rationale for that? Because in my reading, I've looked at some comparisons between Canada and the US. Just in my own personal assessment of those materials that I've been able to read, Canada seems to come up quite well. Are you aware of a comparison between Australia and Canadian jurisdiction activity in this regard?
So we haven't looked at that in depth, but we're just aware that there are a number of countries. Australia does appear to be an outlier in that we have separate corporate and personal insolvency systems.
Do you think that's just historical?
I'm not aware of why it's emerged that way, so that could be a possible explanation. It's just sort of arrived at that. But my colleague Zoe might have more to say on that.
I guess just a few points on maybe why, or you might have 2 systems. I think AFSA as the regulator might just be able to speak to this when they appear, but I do understand that in the personal space, business-related personal insolvencies or bankruptcies are actually a small percent, if that makes sense. So a larger percent are around personal debt. I don't know if that's the right word, but credit card debt or debt that's not business-related. So that would kind of be something you would contrast, obviously, with the corporate space where you assume that people who are running a company are going to be usually using that to run some sort of business. I guess another difference would be about the complexity of affairs, as you can probably appreciate. There's a lot more scope for complexity in the corporate space in terms of things like you have to have a system that can account for corporate groups and other sort of more complicated structures and arrangements than when you're dealing with individuals. So that's just a few, I guess, of the differences between the two.
Ms. Lineker, did you want to add anything there?
No, I think that's a great description. I think that AFSA are obviously appearing this afternoon, and I'm sure would welcome the opportunity to talk more about the type of personal insolvency that they regulate and navigate.
There are so many more questions that I'd like to ask, and we might need to get you back because really we're just cracking this open today. I know that Senator Scarr has questions, and so does Mr. Molino, who has joined us online. So I might go to Mr. Molino in the first instance and come back to you, Senator Scarr.
Sure. Just in terms of timing, Chair, I've got probably 15 minutes of questions, just to let you know. So
All right.
if we can, I haven't really had an opportunity yet. So, if we can accommodate that through morning tea even.
I'm happy to make an adjustment there.
Thank
so
you.
We'll do that. Dr. Molino.
Oh, thanks. Look, I really only had a couple of quick overarching questions, so I'll be on to you fairly quickly, Senator Scarr. Look, I just wanted to follow up on some of the really interesting earlier discussion around the objectives, and I found the discussion, going back to the Middle Ages, really interesting, and the observation that we're dealing with some pretty fundamental tensions here. And when you look at some of the the objectives that are contained in some of our laws, and you laid some of them out, that it's a fair and orderly process for dealing with the financial affairs of insolvent individuals and companies, that mechanisms enable both debtor and creditor participate with the least possible delay and expense, that may be impartial, efficient and expeditious, and so on and so forth. I guess my question is, when you look at some other more kind of some other international documents, like I looked at the IMF's analysis of insolvency arrangements around the world, and it had a couple of overarching goals. One was around risk allocation being predictable, equitable and transparent, and the other being to protect and maximise value in the context of businesses failing. And it did strike me that they kind of went to those broad objectives of trying to maximise efficient credit markets and also to maximising value protection. I guess I'm just wondering, do you see there being merit in addition to having a lot of the more detailed objectives that you pointed to, and there are many others, it seems that there's about 8 to 10 of them. Do you see there being merit in more clearly setting out some very high-level objectives that we could hang more reform off?
Yeah, absolutely. I think good policy flows from having very clear, clearly articulated objectives. And as you mentioned, the goals around maximising value, or if you like, protecting creditors, they're very important goals as well to articulate. And it serves as a useful guidepost for future reform if you were to pursue reform, but it also serves to explain, I think, how the system is meant to function, so that people that are operating in the system understand what the goals are. Because some people can enter the system with perhaps a different perspective around what the goals could be, and then find that their expectations aren't met.
Yeah, no, thank you. I mean, it did strike me that some of the objectives that we kind of have set out in law at the minute are useful, but they seem to be detailed and almost getting to the more operational side of things. It did strike me that if we're asking more fundamental questions around, is root and branch reform appropriate, I wonder whether, it's worth us stepping up a level at some point and asking what is it we're trying to achieve. And I guess that gets to my second question, and this is something which the Chair's already raised, which is around whether we have the right data. And I guess then it goes to that question of how we evaluate whether corporate insolvency is achieving what it's supposed to. And I suppose then you would try and get to issues like, is our credit system working well? And as you've identified, it's not just insolvency. I mean, insolvency is just one part of the life cycle. But I guess then it strikes me that, again, if we're going to get to, and we're only just starting this inquiry, but if we're going to try and look at questions of, is root and branch reform required? Like, how do we evaluate whether the balances are being struck appropriately at the minute? Like, what kinds of data would we need and what kinds of tests would we apply? Acknowledging, of course, that these are very tricky things to disentangle from all of the other laws that are operating. But I'd just be interested in your thoughts on, firstly, how do you think we should think about evaluating insolvency law? And secondly, do we have the right data to even do that?
So in relation to how would we evaluate, I think the principles that we've talked about are a good benchmark to start. The trick with data, and if you're going to talk to somebody from the Department of Treasury, we've got an insatiable thirst for data. But in this space, one of the things that you may be asking businesses to do is to hang out all of their dirty laundry at once, which businesses don't necessarily want to declare that they're a bit wobbly. They don't necessarily want to declare that they're taking advantage of the safe harbour. So there is going to be a natural constraint on our ability to have precise data to inform policy. So it's going to require, more judgment based on incomplete information. That's the challenge.
There's also an embedded assumption there that they're aware that they're in that position.
Yeah,
because,
absolutely.
Sometimes people are so busy working in their business, they don't have time to work on their business, and somebody else is making compliance not necessarily running the business. So there could be a data gap even with the best of construction of data tools. Back to you.
No, thank you. Yeah, and I think, the other, I acknowledge that point. And I was wondering whether, for example, another perspective on this is, even before you hit business troubles, like right at the start of an arrangement where credit is provided, like how is our insolvency arrangement perceived by both domestic and international creditors? Like, do they perceive that were trouble to arise, that they are going to be dealt with in a way where risk allocation is predictable, equitable and transparent? Like, do we have any kind of data around the way in which our insolvency arrangements compared to other jurisdictions are perceived by creditors, or could you infer from behaviour how it's perceived?
So there are international comparisons where Australia is ranked against other countries in terms of ease of doing business. So the World Bank ease of doing business ranking puts Australia 14th out of about 190 countries, and that would take into account, the rule of law and things like the ability for creditors to enforce their rights. That would be a part of that. There's also the IMD World Competitiveness Ranking, which puts Australia at around 19th out of a large basket of countries, 60 to 70 countries, I think. So, we do, when compared to other countries, perform quite well in terms of metrics that include elements of Australia's insolvency system.
And on those two rankings, so those are overarching rankings, aren't they? How do we perform on the subcategories of insolvency? Do they break it down?
So I believe that it may be possible to break some of that down. So I'm happy to take that question on notice and look into that further.
Yeah, that'd be useful. Thanks.
Thanks, Mr. Bellino. Senator Scarr.
Thank you, Chair. I'm going to be very quick. We've got limited time. To the Attorney General's Department first. Ms. Linacre, are you involved in terms of oversight of the Whittaker Review and the implementation of those recommendations, or is there someone here who is?
Yes, Senator, that's within my division.
All right. So could you please just give a quick overview, and I don't want to go through all the recommendations, but the Whittaker Review, as I understand it, was a review of the Personal Property Security Act, which was required either under the legislation or it was thought to be a good idea. When was that review completed and how many recommendations were made?
So the review was completed, the review was tabled in Parliament on 18th of March 2015 and had 300, hang on, I've got the number here, 394 recommendations.
And just in general terms, what was the theme of those recommendations? What were those recommendations intended to do? In general terms.
So the Whittaker Review goes into the personal property securities system, and the recommendations that came out looked at a number of different small changes to the system that would increase certainty in the system and reduce complexity for users.
Right, so the recommendations, 394 recommendations intended to reduce complexity and improve the operation of the system based on the experience of what was happening in practice, and there's been a few cases referred to in some of the submissions. Is that correct?
Yes, Senator.
Okay. Has the government responded to those recommendations that were made in 2015?
The government has not responded to those recommendations.
So
today.
we've had these 394 recommendations on the books for 7.5 years, and the government hasn't responded to them. Correct?
Correct, Senator.
Right. Has the Attorney General's Department actually done work to accommodate the implementation of the recommendations? So what I'm interested to know, you're not responsible for what the government does at an executive level, but in terms of has the work been done within the department to, for example, consider the recommendations, consider advice to the government with respect to the recommendations, potentially do drafting in relation to the recommendations?
The Attorney General's Department has been steadily working on those recommendations, has provided various briefings on all matters within the portfolio over the last several years, have not provided the current government with advice on the Whittaker Review.
Sorry, so the Attorney General's Department hasn't provided the current government
That's
with
correct.
advice on the Whittaker Review.
That's
Is that
correct.
something the Attorney General's Department's proposing to do, or do you wait
Yes,
for the Minister?
Senator.
Okay, and what's the timing on that, do you know? I don't want to keep you. I'm just interested. Something that's been outstanding 7.5 years.
Yes.
A lot of work was put into the review. Clearly, a lot of the recommendations could assist in many of the matters which have been raised. So it's somewhat frustrating. It's been 7.5 years and it hasn't been progressed to the point of the government doing a response. So do you have a timeline at all?
Senator, we are working on providing that advice, which will occur as soon as possible.
Well, it's been 7.5 years, so you can understand why he, as soon as possible, and it doesn't fill me with confidence. Do you think by middle of the year next year, is that feasible?
Yes, Senator.
Okay, thank you.
Can I ask a clarifying question there? 2015, was there ever a response to Parliament to the report at any point from the government?
Hang on, just
You know, when a report's tabled, usually there's a response tabled in.
No, Senator, it was a legislative review, so there was no requirement to table a government response in Parliament.
And could you spell out the interactions, the iterations of interaction with the previous government with regard to the implementation of recommendations and the drafting of legislation? Like, give us just a sense of what you've been doing for the last 7.5 years prior to the change of government.
I can only refer you to a response to Senator Carr's question on notice in respect of we provided ongoing advice, as is the usual approach over the course of that period.
I guess I want to see, is there a little bit of ledge done, or is there a lot of ledge that's been prepared? Seeing as 394 recs.
I think you've done quite a bit of work in this area, I suspect. Is that correct?
We have done a range of consultation over the course of the years, so in 2020. So absolutely.
Whatever you can provide us with on notice would be helpful to give shape to that.
Right.
Thank you.
Thanks, Senator.
Just my last question to Attorney General's Department, I'll move across to Treasury. Could you please take on notice, please, the recommendations for change or reform in relation to this space that are contained in the submissions of the Law Council of Australia, ARETA, the Australian Small Business Family Enterprise Ombudsman, and also in Mr Murray and Mr Harris's submission. So those 4 submissions, if you could just go through. They make a number of recommendations. I'm keen to know if there's something which the department agrees with or if there's a difference in view. Thank you.
Thank you, Senator.
Thank you. Thank you. Treasury. Mr Dixon, were you involved in the consultation in relation to the implementation of the small business restructuring and the simplified liquidation reforms?
So people in my team were.
Okay. Do you have any comment in relation to the statistics that are contained in page 11 of your submission? Any observations?
Let me get my submission.
So just for the benefit of Hansard, number of companies that have entered into small business restructuring quarterly, 5 for the March 21 quarter, 7 June 21, 8 September 21, 13 December 21, going up to 83 in September 22, total of 165. Do you have any observations in relation to those statistics?
None in particular.
Well, that...
Is there something you'd like me to say in particular?
Well, let me be frank. I was surprised that there's no observation, right? In terms of, do these statistics indicate that the small business restructuring process is a success?
So, in terms of measuring success, one of the things that I think we should bear in mind is for the entities that were involved. So, for those people that decided to go through that process, my understanding that the alternative to that would be something like a voluntary administration. And in a voluntary administration, off the top of my head, I think the Productivity Commission, when it did its report in 2015, said that 60% of voluntary administrations result in the business becoming deregistered.
Right.
For the 165 businesses who went through the simplified process, you'd have to check with ASIC, but I think about 90% actually came up with a restructuring plan. And so they actually managed to successfully navigate away from their business being deregistered, which in one sense is a remarkable turnaround statistic.
All right. Well, you're a glass half full sort of guy, which I admire. I'm looking at those statistics, and it suggests to me that it's been a bit of a flop. I want to quote to you from ARETA, their submission. Have you read their submission?
I've seen a summary of it, yep.
Okay, I want to quote from page 43 of their submission. Unfortunately, the small business restructuring legislative package has failed to live up to expectations due to the highly complex processes and legislation that have arisen from the lack of adequate consultation with the profession during the drafting phase. Like the simplified liquidation process discussed elsewhere in this submission, SBRs are simply not fit for purpose and have failed to deliver the cost-effective mechanism contemplated by the Productivity Commission and the Parliament, end quote. How do you respond to that claim?
So I don't really accept that, the claims that have been made.
Can I ask you, we've got limited time, can I ask you to take that on notice perhaps? If Treasury could take that on notice, I want to move on to the simplified liquidation process and provide a formal response, because that is quite damning commentary from ARETA. ARETA also complains with respect to the consultation phase and say that their submissions weren't adequately considered in terms of the consultation phase. I want to move on to the simplified liquidation process. And again, we've got statistics here in table 2.2 of your submission. Use of simplified liquidation pathway, March 21, 12, June 21, 11, September 22, accelerating through 7. 59 companies have used the simplified liquidation pathway. Again, no observations are provided in your submission. Do you have any observations with the success or otherwise of that simplified liquidation process?
Certainly. Just to get back to your previous comment just in relation to simplified restructuring, because I think it applies to both, that in relation to how that scheme operates, it is a simple restructuring and simplified liquidation process for simple affairs. It's not intended to replace the insolvency system. It's meant to only cater to a very particular subset of cases, and there are eligibility criteria that have been established for those two simplified systems, and those eligibility criteria are important because what they're trying to do is, first of all, only enable simple affairs to be considered, because we are stripping out quite a lot of the typical regulatory processes that you would go through. And you don't want to end up in a scenario where you're inviting people to misuse and abuse those simplified processes. So we don't want to be enabling phoenixing or enabling misconduct.
I understand, Ms Dixon. I've only got 2 minutes, right? So I haven't got much time. So I want to put to you a statement in relation to the simplified liquidation process. This again is from ARETA, and bearing in mind there's only been 59 uses of the simplified liquidation process since March 2021. And this is what ARETA says on page 46 of their summary. It is evident that the simplified liquidation process is actually less efficient and more costly than a full creditors voluntary liquidation process. The fact is that only 59 creditors, so their statistic matches with yours, the fact is that only 59 creditors voluntary liquidations have adopted the simplified process since it commenced on 1 January 2021. For context, this represents a mere 1% of the 5,862 creditors' voluntary liquidations commenced in this period. The failure of the simplified liquidation process is attributable to poor legislative drafting and a poor information campaign conducted by ASIC, end quote. Again, it's damning commentary on this process. Can you understand why I'm looking at those figures and I can't come to any other conclusion that it's a flop?
So, first of all, people can choose the process that they want to go through. So if somebody wants to go through this process, they can, the simplified process, and if they want to go through the full process, they can do that too.
But Mr Dixon, the whole purpose of this was to introduce a system which would be more accessible and easier to access. And when I look at these statistics, they are damning. And from your answers, there appears to be absolutely no recognition whatsoever that there's a problem here.
Sorry, well, if I could
Do you want to take it on notice and come back?
I think my answers would actually be able to articulate why if I actually was given the opportunity to give you an answer, Senator.
Right, I'm short of time, so it's not. I'm not being disrespectful to you. I'm short of time. I only had a few minutes, but I just want to make that point. I'm happy for you to take it on notice, come back and give a more fulsome answer. But I must say, when I look at those statistics, it's hard to come to a conclusion other than it is not working as intended. I'm very keen to get Treasury's response in relation to the recommendations that have been made by ARETA, which have been made by the Law Council of Australia and that have been made by the Australian Small Business Ombudsman to potentially reform the processes. Some of the silver lining in the cloud is it's thought that with some reform it could improve the processes. So if Treasury, if I could give you an opportunity to give a more fulsome response and to respond to those proposed amendments. Is that okay, Mr Dixon?
Thank you, Senator.
Thank you.
So there'll be something coming in writing there. We'll look for that with interest. As I said, it's an hour. We're just kicking off. There's much more to be discussed, and I expect that we'll call you back before us. I know the practice is, perhaps at the beginning and perhaps at the end, but the job that it needs to be done, and if we need to get you back in the middle, expect to be able to do that, and we'll try and make sure that we have sufficient time to prosecute it live.
And I know you've got answers. I've run out of time, so sorry.
Great. Would it assist you if we gave just Mr Dixon a couple of minutes to put anything on the record?
If we can. I was told we had to.
I'm in the hands of the committee. We happy to proceed through the break.
Well, Mr Dixon, can you see how I look at those figures and read those submissions from ARETA? And I was sitting in the Senate when these reforms came through, and I agreed with the policy objectives, but I look at the reality, and it seems that for reasons that the professionals who are engaged in this space are making decisions not to go down the simplified liquidation pathway in particular, and that poses the questions as to whether or not there could be reforms made to the simplified liquidation process to make it more attractive.
So, Mr Dixon, 3 minutes, max.
So if you look at both the restructuring and the liquidation pathway that's available, so just on that data, so you saw, as you pointed out, there's been a rapid increase in the uptake of that over time.
From a low base.
From a low base, but it doubled in the September quarter.
Yeah.
To my mind, it's hard to say, and I would be reluctant to say that a sign of a great system is that Australia is experiencing lots of insolvencies and the statistics are really high. That would not to me be a sign of a healthy economy. So in one sense, looking at the numbers, perhaps that there's two sides to that coin. But in relation to the simplified liquidation pathway, we do acknowledge that there are criteria that are in place that are trying to prevent abuse. And you are trying to only target certain simple affairs, and we are acknowledging that there is feedback that we're receiving in relation to that, and we understand that, for instance, the $1 million threshold is one of the sticking points that people often raise, and the question is whether that $1 million threshold is appropriate, particularly in relation to the liquidation pathway. Another anecdote that we've received is that from the point of view of a liquidator, there's very little incentive for a liquidator to go through the simplified system because the remuneration possibilities in there are low. And so it's actually perhaps in the interests of some of the players in the system to actually encourage people towards the fuller liquidation pathway. So there are a number of different incentives that are operating in the system. I think I've met my 3 minutes.
Yeah, I think you're getting close to it. And perhaps that response indicates the complexity in relation to how insolvency is being paid for, by whom, and questions about the intersection between those who can pay, cross-subsidising those who can't pay, and perverse incentives in the market. In fact, it's described as market failure in a couple of the articles provided by our researchers, Murray and Harris, and can I point you to one of their submissions to the committee? It's an attachment, I think, to submission 18 that describes market failure in this regard. There are seriously many more questions that we didn't get to today, so expect that we'll come back to hear from you, and given the questions that we've asked and anything you think that might be additionally helpful for the committee, invite you to make a supplementary submission as we continue on with our investigations. Thanks again for being here and coming up the hill to appear in person. We always appreciate that a great deal. We like it better than when you come on a television screen. So thank you, and can I wish you all the best for this season. Hopefully there's a bit of peace and a few less disasters, and we can all have a bit of a rest and reset and come back in the new year.
Great.
Thank you.
Thank you, Senators.
Thank you, Senators.
I now welcome representatives from the Productivity Commission, and I understand that information on parliamentary privilege and protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
Thanks, Chair. I'm hoping you can hear me.
We can, Mr Brennan.
Great, thank you. That's better than last time. So, Michael Brennan is my name, I'm the Chair of the Productivity Commission. We can't hear you, Ros, sorry.
Ms Bell, we might need to unmute yourself.
For the record, it's Rosalind Bell, who's the Acting Head of Office at the Productivity Commission, so hopefully Ros can join in due course.
We do need to check and hear that she's online, because we might need to take remediation activity if she's not. So Ms Bell, can you speak to us and give us your name and full title? Still not working? Okay, we'll just take some advice from broadcasting. Should we ask Ms Bell to disconnect and reconnect? Oh, sorry, Hansard. Where's our broadcasting? Somewhere up the back there? Yep. So should we ask, can you give us a signal, thumbs up? Disconnect and reconnect? Yes, please, Ms Bell. If you're still listening, disconnect and reconnect. We'll test that when we see her again. Thank you, Mr Brennan. And I invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions. And this session is designed to complete at 11:15, when we will be joined by Asba Fayo. If you can give us a little flexibility, we might need you till 11:25.
That's fine, Chair. We're kind of entirely in your hands, and I don't have much of an opening statement other than to condition expectations a bit about what contribution we can make, and I feel particularly guilty given you clearly had excess questions for the Treasury, and now we're on. We'll obviously try and add as much as we can. Our main involvement in this area dates back to the 2015 report that the Productivity Commission did on business setup, transfer and closure, which had a subset of which dealt with corporate insolvency issues and personal bankruptcy as well, but it was a small part of a larger piece. Since then, we haven't had much involvement in this space. So whilst we've in general kind of followed developments, including the legislation of ipso facto moratoria and safe harbour provisions and the more recent changes announced by the government in 2020, we haven't really been close to this space particularly at all. So I'm happy to see where we can help and perhaps in relation to some broader perspectives. But I don't want to overpromise in terms of our grasp of the detail. I've endeavoured to read up on a couple of the submissions that have come to the committee just to get a feel for the contemporary debate.
Thank you, Mr Brennan. I just want to note that we've been joined online now by Senator Louise Pratt from Western Australia as well. She's undertaking work and care at the same time by the looks of things. Ms Bell, are you with us yet? No. Okay. So if I can, in terms of your observation and your reading of a couple of articles, what was of most interest to you, Mr Brennan, in the materials that you looked up?
Look, it was probably reflections from stakeholders on the benefits of a couple of the things that date back to the 2015 report. So particularly the ARETA submission. I had a quick look at the Quarter-Mentha submission as well. Seem to reflect a view that the safe harbour provisions are working to reasonable effect.
We're getting a bit of commentary there. Is that coming through from broadcasting or from somebody else? Broadcasting, do we have Ms Bell with us yet?
Good morning.
Yes, we do,
Great.
and we hear you as well. So, Ms Bell, do you want to give your full name and the capacity in which you appear today?
It's Rosalind Bell. I'm Acting Head of Office in the Productivity Commission.
Thank you very much, and appreciate that. Thank you to broadcasting and Ms Bell and your trustee assistant, whoever that was. Mr Brennan, back to you. ARETA, Quarter-Mentha, anyone else?
Yeah, look, of the views that, well, I've had a bit of a look at the HIA submission and the bankers and a couple of the others. Just noting that broadly it seems that the legislative change brought about from memory in around 2017 that dates back to the Productivity Commission report in areas like ipso facto and safe harbour seem to be working more or less in terms of having the desired effect. A little bit more of a question mark over the take-up of the most recent changes in terms of the small business restructuring, which was the subject of Senator Scarr's questions just now. But I think also kind of, the submissions that I've read seem to reflect a sophisticated view about what it is that we want from an insolvency system, namely to balance the desire for restructuring to occur and for businesses to be given every chance, but at the same time not to be so naive as to think that it's the role of the regime to minimise insolvency, that insolvency and business exit plays a very important part in maintaining the dynamism of the economy, ensuring that it's an innovative and constantly changing economy. And whilst there's an element of pain associated with financial distress, sometimes business exit is an important way that we get, economic growth through innovation, different business models, and particularly in some industries, that is a mechanism by which innovation and productivity growth occur.
Thank you very much. And I'm sure that you'll be well versed in terms of those submissions to give a bit of perspective. I'm going to go straight to Senator Scarr for questions.
Thank you, Chair. Mr Brennan, in terms of the Business Setup, Transfer and Closure Inquiry Report, is there any outstanding recommendations that were contained in that report which have not been implemented? You spoke about some of the reforms which have been implemented. I'll come back to some of those in a minute, but I'm interested to know if there are any recommendations in that report which were not implemented or not wholly implemented, which might still be worthy of consideration by this committee to potentially give them impetus.
Mr.
Sorry,
Brennan,
I think you're on mute.
You're right. You're quite right. Sorry about that. So, Senator, I believe that there are, but rather than hazard to identify exactly where all of those things are, I might take that on notice. We don't have certainly for that report, we haven't had a kind of ongoing tracking process to determine which of the recommendations have been taken up and which not. But we could certainly have a go at that and try and provide that back to the committee as to where we think there's unfinished business from the recommendations we've made. Ms Bell, I'm not sure whether you've got anything to add to that.
No, I think it's probably best we take that on notice because a lot of the recommendations that we made in that report have been, parts of them have been adopted, and there are sort of some variations, I think, in how they've been adopted and implemented. So we would need to look through them and work out which aspects are still remaining to be taken up.
Okay. I think you heard, Mr Brennan, some of the interchange I had with Treasury in relation to the small business restructuring, the number of companies that have gone through the small business restructuring process, and also the number of liquidations that have occurred through the simplified liquidation process. The numbers are provided there in Treasury's submission. From the Productivity Commission's perspective, how should we be judging the success of a simplification process? So it would seem to me, from a high level perspective, when I first saw these figures, to me that suggested that, well, maybe the process isn't simple enough. Maybe the process has been made too complicated for small businesses. Therefore, participants in the market, professional advisors are simply defaulting to the processes that were already in existence rather than going down the simplified track. And that's something which should be a red flag in terms of assessing these processes. So I'm interested in your view from a productivity perspective as to how we should assess the success or otherwise of so-called simplification processes, including in this space.
And for context, your own report indicates, the productivity report that is, 2.6 million businesses registered as operating in Australia. So that's context for those numbers.
Yep.
Yeah, so I, like you, Senator, was struck by the extent to which and I confess I hadn't seen the figures until I looked at the ARETA submission, but it's not just the fact that these numbers are low in absolute terms, but they're low as a proportion of insolvencies in aggregate. So my first reaction is that reflects that take-up is pretty slow. Now, maybe this is something that's going to, you need to allow a bit of time, and perhaps, given that these provisions started in early 2021, maybe we need a little bit more time to judge. But it's a very sound principle to, in light of any legislative change, to review progress and to make refinements as one goes. And several of the submissions that I've seen before this committee suggest ways in which some of those, or the directions for some of those refinements as to how how it could be simplified. So I too felt that, whilst you never know quite one never knew quite what to expect when these changes were announced in 2020, the take-up on both the simplified liquidation and on the small business restructuring does appear to be low, noting too that the small business restructuring was sort of part of a general push to, if you like, balance Australia's insolvency regime to give a little bit greater weight to restructuring and recovery as distinct from, a perception that the system has, compared to international peers, had a pretty strong focus on creditor rights. So to the extent that was the intent, I would say that the small business restructuring numbers, as I've seen them presented in submission before the committee, they look pretty low to me.
And the simplified liquidation numbers, I think they're even worse.
Likewise, and I did note the ARETA comment to the effect that the simplified process looked more complex, or was in practice more complex than the original process or the standard process that is designed to supplement. So, and I note Mr. Dixon's comment on perhaps the incentives around remuneration that might be at play in that, but all of that suggests to me that, yes, as always, review would be, it'll be timely at an appropriate point to review, and perhaps this is a good time to do it in this process with a view to recommending some simplification, some further simplification or tweaks.
Okay. I want to go to a more substantive, higher level question. That is, a number of submissions we've received talk about root and branch reform, potentially looking at collapsing, if I can use that word, the personal insolvency regime, namely the Bankruptcy Act, with the corporation insolvency regime into one bespoke insolvency regime that applies to everyone under one agency, and to follow the path that some other countries have taken, including Singapore. From your perspective, from the Productivity Committee, and I look at, so let me go back a step, I look at that task and it appears an extraordinarily large task to undertake that sort of reform process. So you need to ask yourself whether or not the resources and the time required to do that outweigh the benefits or vice versa. And from my perspective, you also need to assess whether or not there are ways in which you can modify the existing system to make it more productive, more efficient and effective. How should we be looking at competing those? How should we be looking at assessing those competing priorities from an economic point of view? Because it's easy for this committee to, maybe not easy, or all recommendations this committee will be well considered, but it's one thing for us to make a recommendation, other people will have to actually implement it. How should we be assessing what's involved in terms of, on the one hand, improving the existing system without engaging in a root and branch reform, as opposed to root and branch reform in this space?
So it's a very good question, Senator, and I too have been struck by that, the view that we suffer as a result of having effectively regimes that have parted company in key ways. I just note when we looked at it in 2015, it wasn't our recommendation to move to a unified legislative structure and a single act or necessarily a single regulator. And we said at the time that we felt that the benefits of that would be marginal. So one lens through which one might look at it is to think, well, what has changed potentially since 2015? Where might one look for change? Now, one or two submissions have made observations about the platform work and the gig economy and whether that's effectively a game changer that brings the corporate insolvency and personal bankruptcy worlds yet more closely intertwined. That's a possible candidate, though I note that the platform economy, notwithstanding one entity going into voluntary administration from memory recently, it's a pretty small part of the economy overall. So whether that's a big enough change to warrant a change of view since 2015, I'm not sure. So I think there is a case for caution. I think there's the question about whether or not the intermediate step of just trying to get greater consistency between the two regimes is a better solution than trying to bring it all together under one act and a single regulator. And of course, bringing it together under a single regulator sort of presupposes that it might be, potentially a different regulator to ASIC, which is what we have now. All of those things involve a fair bit of bandwidth. It's pretty resource intensive to make a change like that. So I think the threshold, has to be pretty high. So I guess I'd be looking to what has changed in the last 7 years that would make for a different conclusion to what we reached when we looked at this last.
My final question, before I hand over the call, is in relation to the obligations and duties upon liquidators to undertake certain work, and in many respects they're required under the Corporations Act to undertake certain work, and it could well be that the assets in the liquidation are so small that work isn't necessarily justified from a purely economic view looking at the corporate entity, but it's an important work from the perspective of the overall system, the economic system, and maintaining confidence in the system. How should we look at making sure that the work that needs to be done to ensure the efficacy of the overall system for the greater good, as it were, is actually being done by the right people with the right expertise, and that work is recompensed so that you don't have a situation where things simply aren't being done which need to be done because the money's not there in the liquidation.
And on that, Senator, in particular, you're focused on the work that liquidators or administrators do effectively on behalf of the regulator by investigating pre-administration behaviour directives and that's
correct.
Where they're almost exercising a sort of regulatory function. I mean, at the risk of disappointing, I guess it's not clear to me that there's an obvious answer, but I'd want to reserve. So I might even take that on notice and kind of reflect on it a bit further, if that's all right. Clearly, the implication is that at the moment, in relation to the long tail of relatively low value external administrations and liquidations, there's effectively a bit of, there's not a lot of money being made, and to some extent that's being cross-subsidised by other work. Is there an alternative funding model for that, or is there any relaxation of the ability to earn. I mean, in some cases there's not, because the sort of amounts available under the administration just wouldn't even recompense the administrator. So, you know, is there an alternative funding model? I'm not sure. There'd probably be a high threshold for, you know, something that was a more direct fiscal or public support for that.
And Mr. Brennan, maybe the answer isn't funding the work, but maybe it's there being some sort of recognition in terms of legal obligations which are being imposed, that in circumstances where there aren't the funds to do that work, then liquidators shouldn't be obliged to do that work. And there's an inherent economic inefficiency in that regard, don't you think?
I think so. You know, again, looking at the submissions, and that's as I say, best guide for me, not having remained up to date in this area, but I think that is probably the first place to look.
Okay, thank you.
Thank you. Can I just jump straight on that one? 20,000 reports to ASIC and very, very few actions. Is that a sign of a system that's not working, Mr. Brennan? That's a lot of work, 20,000, you know, separate engagements with businesses. We're not clear whether they're corporate or personal, but 20,000 reports and very few actions. So there seems to be a lot of churn there.
Quite possibly. I mean, it probably, again, not wanting to be cagey about it, but it probably is a question best put to ASIC. I don't really have a basis for saying one way or the other whether that's an inadequate response or, you know, roughly reflective of the level of risk. I don't know whether, Ms. Bell, whether you've got anything to add on that.
Could I just ask, as a non-lawyer, you know, how much of the law requirement to fulfil the obligations go? If you're an insolvency practitioner and you're doing the right thing, you know, like there's a lot of really good people that I've spoken to who are in this industry, and you know, their business model seems to be to cross-subsidise, and they meet small businesses and they're trying to help people who are at a desperate point sometimes in their lives, where their house is on the line and maybe their marriage is collapsing as a result of the financial pressure they're under. These practitioners are bearing the emotional burden of that, as well as the cost burden of that, reporting on 20 occasions to comply with their requirements once they're engaged, to report to ASIC. And what's the outcome of all of that? I mean, very few prosecutions, but also the cost of doing so. With what I'm trying to understand, where's the benefit? Where's the public benefit of that investment of time and resources? Like, where's the productivity gain in the current structure? Can you help me understand that?
Well, not really, other than to say I think it's a fair question. I'm just not close enough to the detail to know, you know, what underlies those figures and whether that's, you know, a reflection of a kind of a, you know, too little enforcement going on the basis of the reporting that's coming in, or whether the reporting itself is excessive, or whether it's easy for ASIC to require that on another party because they're not bearing that cost directly. I think those are all important questions to pose. It's probably, I just don't feel qualified to express a view on them.
Okay, so as the Productivity Commissioner, in your report in 2015, you state what I believe to still be the case in Australia, and I'm open to you correcting this if it is no longer the case. The vast majority, over 90% in brackets, of new businesses are micro businesses with few, less than 4 or no employees. Median age of business owners at 47 years is older than the general workforce, is increasing faster. Majority of business owners are male, female owners are becoming more prevalent in new business. Is that the shape of the current growth in new businesses and micro businesses still today?
I believe it is, Chair, but again, I might just take that on notice to confirm that there's not been a dramatic change in those trends.
Okay, Ms. Bell, can you assist with anything there?
I believe that's consistent with the pattern that's continued. As Mr. Brennan mentioned earlier, there has been a rise in the gig economy, which would tend to increase the number of micro businesses as a proportion of overall businesses. But typically, most of our businesses in Australia are small, and increasingly there's a lot that are micro as well. Of course, new businesses always start off micro and then grow bigger, so that's another specific pattern.
Okay, so in terms of innovation and capacity to get into business, we have a pretty easy access scheme and ABNs, and we're going to ask some questions of the ATO and also of ASIC about, how many are active and what's the deregistration process. It seems a lot easier to get into business than to get out of business, whether that's to close down your company because you're no longer using it, or there seems to be a few requirements around that. And it's even more complicated if you have a trigger event, such as a bank making a claim against a business at any point of time, or if you're the ATO and you issue a DPN order. Have you got, in your research for the 2015 report, and if you've got any more research up to date, have you got any awareness of the triggering of personal or corporate insolvency by either the banks or the ATO?
No, again, I would have to go. I'll take that on notice as well as to what the proportion. We probably did have some numbers at the time in 2015 about the proportion of insolvencies that are triggered by those external events, either a ATO action or a secured creditor, or versus other things. To your point, just on by way of context on the question of it being easier to form a business than to close one, I think that's true, and you can understand why that would be the case, because by the time it comes to shutting down a business, there are a number of other stakeholders involved, including creditors, shareholders, employees, trade creditors, etc. The formation of a business, we do in Australia, on international surveys, we perform pretty well on that question of how easy is it to form a business. If by forming a business, the point is to register for GST, get an ABN, register a business name, etc., that is a pretty straightforward exercise that can take a few days in Australia. Longer if you've got a physical premises and you need council approval, or you need various other forms of state or local licensing, etc. That's where the delays in new business entry tend to come in.
You talk in your submission also about a small group of these businesses being entrepreneurs and genuine innovators, and you make a point that it's less than in other jurisdictions. Do you have an idea about why that is the case, and has it got anything to do potentially with insolvency, creditor risk, current practices in the insolvency sphere? Is there any intersection there between those things?
Sorry, this was from the 2015 report.
Yeah.
You were saying?
Yeah, so your entrepreneurship levels in Australia are low, and you say that just as not all new businesses owners are entrepreneurs, so too not all new businesses are startups, newly created businesses that are innovative.
Yeah. Look, again, I might ask Ms. Bell to expand on this. Not all small businesses are necessarily big innovators. You get some sectors where new businesses form and they're highly innovative and disruptive, but often that's not, there are industries where that's not necessarily the case. Of course, innovation comes in a range of forms, I suppose, and there are, we might think, for example, of sectors that have a lot of business entry and exit all the time, like the restaurant, cafe, accommodation sector, and you might think, well, new entrants there. It's not like they're doing sort of capital I innovation in the sense of R&D or scientific advance and that sort of thing. But in many ways, that is the channel through which innovation occurs is new entry. So it might be sort of micro innovations around just trying out something a bit different, having a slightly different business model, having a slightly different, a cafe with a slightly different theme or pricing structure or offering. So much of the innovation in the Australian economy kind of is of that sort of more everyday form, I guess. And, those industries that are characterised by a high level of business entry and exit, typically that's the mode by which they're innovating. Ms. Bell, did you want to add anything to that?
Yeah, so as our report stated, innovative new businesses are a very tiny proportion of all new businesses in Australia. The ones that are called startups in a traditional, they're creating some totally new idea, new to the world business opportunity. One thing that we considered in the 2015 report was potential stigma, I guess, around failing as a business owner. In Australia, it was seen to be quite high associated with business failure, whereas in some other countries, it was more acceptable as an entrepreneur to have a go, have your business fail, and then be able to access finance to start up again. So some of the reforms that we recommended around personal insolvency in the 2015 report were directly aimed at reducing the stigma and the consequences of some entrepreneurs failing, with the idea of making it more acceptable for some of these entrepreneurs to have a go, fail fast, if you like, and then try again with less consequence in cases where there were no legal issues that they had come across in their business.
Okay. Do you have any insight into how the potential for insolvency, whether personal or corporate, might impact the innovation sector? Because you talk about regulatory response and reform in your report. Is there sufficient regulatory adjustment to foster innovation for those businesses that seem to be fewer in number than other jurisdictions? I guess the question is insolvency law as it operates in Australia a brake on innovation?
So one thing that we noted in the report, for example, was that going through insolvency processes for a business in Australia is a very long and complex process. I think liquidation was the fastest of those processes, but even for that, it was something like a median of over 500 days to go through that process. So that's a significant potential break in the system in terms of you're not failing fast if it's taking 500 and something days to wrap up your business.
And that's the fastest methodology, liquidation.
So
to be clear, describing the reality, like today I could get an ABN, get going, get a business, get things moving. But when I want to wind it up using the current legislative structures, it would take 500 days, over 500 days to liquidate.
Plus all the fees that go with
it. Using the structures that existed in 2015, whether they have speeded up with the reforms that have been introduced since, I don't have knowledge of.
I don't have detailed knowledge either, but based on the submissions we've received, I don't get the sense that there's been a radical change or improvement as a result of any of the changes that have occurred at this point of time. Because you are the Productivity Commission, can I ask you for your view on how effective and how efficient a 500-day liquidation process at some cost is in the Australian economy? Mr. Brennan?
Yeah, well, I would say that's, as we pointed out in 2015, that seems excessive for the median, and that was the median. Then there was a tail of liquidation processes that were longer still. So I think it is reasonable, to your question before about how is it that the insolvency regime promotes entrepreneurship. I guess a couple of indicators are, firstly, what is the length, how quickly, once it's clear that a business isn't going to succeed, or that liquidation or winding up is the right path, how long and costly is that process? And to the extent that time can be minimised, that's clearly a positive for entrepreneurship and the incentive to start businesses overall. I guess the other thing that, is much harder to measure, it's intangible, but people you talk to, around the world, it's very real, is just what is the sort of entrepreneurial culture, what is the culture that attaches to business failure in general. So notoriously, in the United States, business failure is quite accepted. It's not necessarily met with the same stigma or shame that might be reflected in Australia. And to some extent, I think efforts to bolster the arrangements that apply to restructuring, like the small business restructuring arrangement. We talk about Chapter 11. It's not really Chapter 11, but the idea that there'd be a greater focus on business recovery as distinct from getting what you can for the creditors probably goes to that cultural issue a bit, and it's a hard thing to measure, but to the extent that we can remove some of the stigma associated with having started a business and it not succeeding, and allowing people to discharge their obligations relatively quickly, that does seem to be a positive for the overall incentives to take risk and innovate.
So in your research into the field, you became aware of, how the ecosystem operates. You note about the role and power of receivers and unsecured creditors, that a secured creditor currently has the power to appoint a receiver or take possession of a large component of a distressed company's property security, potentially to the detriment of restructure plans and other secured and unsecured creditors. Has anything changed?
That is one of the things that I'll have to take on notice in respect of Senator Scarr's question, in terms of what legislative change there's been in relation to that.
Now,
Sorry, Chair,
typically, thank you for taking that on notice. Typically, who would the secured creditors be?
Ms. Bell, did you have a view on that?
I would suggest they'd be financial institutions.
Okay.
But yeah, presumably it's a lot of it is like
Banks.
equipment lease and that sort of thing. But again, I could be wrong about the extent to which it's traditional banks versus finance companies and that sort of thing. So yeah.
But for small businesses, they're quite often requiring the owner's home as security against a loan to the business. So, in many instances, I think that would be more common than, loans on equipment.
And where that is the case, which to my understanding of small business is predominantly the case, the risk of actually seeking assistance to support your business and find out perhaps it might be in a state of disrepair means actually risking the roof over your head and your children's head. Are there more sophisticated structures elsewhere that embed less risk in these micro and small businesses taking on the opportunities of starting up a business?
So in another one of our inquiry reports, Competition and Financial Systems, one thing that we examined in that one was the way that the risk weightings that banks are able to use on small business loans as opposed to personal mortgages, and recommended changes in that so that banks were more able to lend to small businesses without requiring a mortgage on the owner's home. I think some of those changes might have happened since, which could make it more possible for banks to lend based on things other than assets other than the owner's home.
It would be really good to get a bit of an update on that. And, if you have any insights, and certainly there's questions we should ask the banking and financial sector with regard to that, because I note in your report you indicate that compared to the UK, where about 8% of companies had receivership as an option. It was about 16% of Australian companies entered insolvency having a receiver appointed, double the number. Are Australian companies, small businesses, subject to a more aggressive engagement from financial providers than other jurisdictions?
I don't think at this point in time we've got comparison with Australia versus other countries on that.
Thank you. If you can provide on notice any further information, of course, that would be helpful. Going back to the time spent winding up companies, in your report on page 26, Business Setup, Transfer and Closure, you talk about not only the number of companies, but the different types of companies that insolvency practitioners are appointed to. And I just draw your attention, if you can, to that $1 to $250,000 company liabilities. That was nearly 50%. 250,000 to less than $1 million, 30%. 1 million to less than 5 million, around 15%. 5 million to less than 10, down to about 2%, and over 10 million looks like about 3%. Reading the scale there. You make some recommendations about the differentiation of a necessary response, and it's not based on, to my reading, whether is corporate or personal, but it's about the size, or is it based on corporate versus personal? Can you help me understand that graph a little better?
So I think one thing that's coming through in that chart is that the vast majority of businesses at the time that they are appointing an insolvency practitioner have become quite small. Now that chart is by liabilities, but similarly, something like I think in 2015, about 40% of businesses at the time that they appoint an insolvency practitioner are essentially assetless. And something like 80% of them have less than 50,000 in assets. So the time spent to wind up a company is essentially almost disproportionate to the amount of assets and liabilities that are existing at the time that they're going insolvent.
So can I ask you the question that I put to Treasury and the Attorney General's Department? Given the shape of what we're describing here and what's reported and what appears to be continuing based on the other submissions that we've received here in 2022, is the current system functioning and fair?
So in 2015, one thing that we recommended was that a distinction be made between very small assetless businesses and the way that they are able to wind up, and larger companies that still retain assets at the time of becoming insolvent. Some of the reforms that I understand were introduced recently pick up some aspects of that, but as the initial question asked at the start of this session, we haven't monitored and kept up with the extent to which the reforms that have been introduced in recent years have picked up all aspects of the what we recommended in 2015. It's sort of quite a time has passed, and the government has introduced a number of aspects of those recommendations, but not necessarily all of them.
Do you have a view, thank you for your answer, Ms Bell, do you have a view about how Australia's insolvency law framework can better support restructure and business turnarounds?
Chair, I'd answer that by perhaps going back to the import of Senator Scarr's question earlier about, having a good look at the impact of the changes that were made starting from 1 January 2021 in relation to small business restructure, because that of late has been the sort of signature initiative to shift the emphasis of our insolvency arrangements in the direction of supporting restructure and recovery. noting that the take-up appears, at this point at least, to be pretty low. So whether we've got that balance absolutely right, I think probably remains a question, I think it's fair to say. But, you know, that's me kind of sticking my neck out in uncharacteristic ways, because we haven't really looked at this in detail, but just noting that the take-up, as per the comments made in submissions to this inquiry, is pretty low. Whether that rebalancing has been achieved to the extent envisaged seems unlikely.
I'm trying to get my head around the tension between cleaning up and doing what I think you said in your opening statement was giving businesses a chance to exit as necessary, and the expectation, I think, in the general public that the appointing of receivers or an administrator or going through liquidation is to make sure that money keeps going around in the economy out to unsecured creditors, not just to secured creditors. Is it meeting that community expectation that's embedded in the principles for the establishment of insolvency law?
Well, I think on several key indicators, Australia's performance is pretty good. So when you look at things like, as we did in 2015, and I don't think these figures have changed a lot, the proportion of the dollar received by creditors, it's pretty comparable with other, peer economies. The time taken, whilst probably too long, it's not necessarily hugely out of whack with all the. From memory, we were comparing ourselves a bit to the UK and probably New Zealand, a couple of other. I'll check that again and take it on notice. But we had a series of metrics on which you could sort of judge the overall system, and the Australian system kind of performed reasonably well. But there was a strong tone in the submissions and in our report that Australia, and to an extent New Zealand, were kind of outliers in probably placing greater emphasis on creditors' rights than on the emphasis on a business having an opportunity to get itself back on its feet. And the counterpoints always raised about US Chapter 11 bankruptcy, we said then that we didn't think that was appropriate. I know that the submissions to this inquiry say that remains the case. But the small business reconstruction or recovery initiative was really about trying to have some kind of debtor in possession model that would allow smaller businesses to kind of work their way out with the support of a small business practitioner. And yeah, whether that's having the desired effect, the take up at this point seems pretty low.
Yeah, so the small business practitioner, if they're a potential insolvency business, perhaps that's describing putting the fox in the hen house. Certainly that's how some businesses over the years that we've been taking evidence in this committee have described it. I know that Senator Pratt has some questions. Could I ask you to take on notice, and you've just mentioned the United States Chapter 11. It's often thrown around as we just need to set up Chapter 11. You remain pretty clear in your evidence this morning that it's not justified and unlikely to be beneficial. Could you take on notice up to 2022 a statement on why you think that framework wouldn't work in Australia? And also if you can give some consideration to the use of restructuring processes in Australia and United Kingdom comparing to those of the United States and Canada from a productivity point of view with regard to insolvencies, that would be helpful as well. And my overarching question is it a good outcome for creditors and the economy when only 1 in 14 businesses is currently filing for insolvency compared to 13 out of 14 just letting the business be deregistered passively? And when 92% of unsecured creditors get 0% return in the event of a collapse, we may be in line with our comparator countries. Are we in line with Australians' understanding and expectations about what's happening in the unsecured credit that's moving around in the country? Senator Pratt.
Thank you very much, Chair. Can I ask the Productivity Commission what they might be picking up in other areas of your work that's relevant to this inquiry? So, for example, are there trends and innovations in other areas that mitigate against poor insolvency outcomes? So for some examples I can think of are project banking accounts, for example. How do you think directors' numbers will go in terms of playing a role to see repeat poor performers? If we start there, and then I'll follow up with some further questions.
Yeah, look, across other bits of work that we do, and this is noting that we haven't, as I say, really revisited the issue of insolvency and bankruptcy per se since 2015, but we are obviously involved in doing other bits and pieces, as Ms. Bell mentioned, the report into competition in the financial sector. Another bit of work that we have done of late was just to look at small business access to finance and this critical question about the extent to which there's potentially debt capital available that isn't secured against the family home or some other real property, or but is more lent against cash flow. And we probably went into that project with a hypothesis that this remained a significant problem and that there was a significant access to finance issue in Australia that wasn't shared by other OECD economies. We perhaps came out of it with a slightly more benign view that there is substantial change going on in the industry, kind of almost down to two slightly divergent models. One, some business bankers who are investing heavily in the human relationship to kind of be able to fully understand a business and have confidence, therefore, about lending against cash flow. But other new operators who are increasingly using algorithms and data to, at relatively low cost, be able to make judgments about the creditworthiness of a business and therefore have some confidence about extending credit. I mean, that's a development that I think, to the extent that that continues and that technology enables that's a pretty important and significant development in the space, because it might mean that you've got you kind of less distress around particularly where the family home is concerned, where that's the asset.
Well, better investment decisions to start with. Yeah.
That's more accurate lending. Yeah.
Anything else? So, for example, you noted particular trends in relation to referrals, for example, into a small business practitioner, and that the take-up is low. People might be, one hand, afraid of getting referred in there because they think it will trigger an insolvency. But should we be paying more attention to lead indicators for businesses that need support, like the non-payment of superannuation? And what's the data around that? And do we have enough regulators and government agencies really looking at, for example, tax, super, underpayment of wages, and other things that might headline where a business is heading towards failure?
It's a good question, Senator, and I'm not sure of the answer to that. So in principle, those things are potentially useful sources of intelligence. The extent to which we're making use of that and making that information available potentially to provide insights. I mean, I guess you'd have to think through, to whom is that information available?
Well, it's the non-payment of super, you could change the law and, have a stronger culture around that, but then perhaps it wouldn't be quite it's a philosophical question as to the extent to which businesses should have a practical right to hang on to that capital for period of time instead of paying it to their employees. And likewise with a whole range of other entitlements that end up being the liability of government. The business does go under.
Yeah, and you're proposing almost, is it an early warning sign that could be provided to the directors themselves or to the business proprietor themselves to say, are you sure
Well,
you've
I
got these under
suspect in
control?
most cases they already know that it is an early warning sign. The question then is, do you use that as a trigger for insolvency, or do you use that as a trigger to support a business back out? Or do we keep ignoring it and just let nature take its course? It seems like we're wasting information, valuable warning signs for what's really going on in the business.
I think that's quite possible, and I shouldn't, I won't, hazard a view because it'll be ill-informed, but that seems logical. I note that both in our report, but in submissions to this inquiry as well, there's a bit of a reference to the fact that the incentives and the tendencies of directors of large entities quite different to those of small ones. So with part of the intent of the safe harbour provisions was to address the fact that for large entities, directors had a bit of a tendency to go a bit too early because their biggest fear was a breach of directors' duties for insolvent trading, whereas at the smaller end, there's probably a greater reluctance because that's not the thing that's motivating them. The thing that's motivating them is much more likely to be the loss of the family home or indeed the stigma associated with voluntary administration or liquidation, business failure. So at the lower end, at the smaller end, it's probably more about prodding some businesses into having a think about where they are positioned in reality.
And how do you propose? Have you got some thoughts about how government could support that? I think we're a bit slow, for example, sometimes to react to where that support should go. So, for example, we've seen an uplift in insolvencies in construction, which is one of those industries where you'll typically get them anyway, but there's been lots of trends in the economy that would indicate that, labour shortages, supply chain stuff means that pressure's going to get turned on there. Are there other mitigating things that we can and should look to, for example, on a sectoral basis that say, right, do we just stand by while we know this is more likely to happen in construction currently, or can we look to more sectoral interventions to try and mitigate and create more stability so you don't get cascading insolvencies, for example, like we see in construction?
Yeah, I think it is a good question worth thinking more about. I mean, construction, I think from memory, when we did this report in 2015, it was something near a quarter of the insolvencies were in construction. That just reflects both the fact that it's got a high preponderance of small businesses, and it's a highly cyclical sector. And I note again that some submissions noted with the HIAs kind of reflect that that's kind of, we're sort of in that world now with rising interest rates and rising costs, etc. We're at greater risk of higher insolvency in that sector. I mean, I think your basic direction is right, that the provision of information, some of which now sits with government, there are some innovative things being done in terms of the tax office and the Bureau of Statistics kind of identifying from single touch payroll data and that sort of thing, having some ability to benchmark firm performance within a sector and provide a bit of information back to firms about where they might be positioned in terms of their own performance. And I think that specifically may or may not be useful, but that does kind of illustrate the potential use to which public data can be put that still preserves privacy and the sort of integrity of the data,
Password.
but might provide a bit of a public good. So that.
And how do we flesh that out, really? Has anyone done any work in that space? It's pretty hard for a parliamentary inquiry just to go, right, either we say someone needs to go away and look at this, or we've got to gather some more evidence.
Yeah.
Ourselves.
So we might take that on notice as well, what we're aware of.
Yeah.
And the ABS itself might also be a useful source of up-to-date information on where they see that going. Yeah.
Can I ask about other market interventions, if you like? The Productivity Commission's traditionally been fairly conservative and market-driven in this respect, but I notice, for example, Western Australia now does project bank accounts for government tenders. That's where the principal will pay money into the project bank account and disperses funds according to the head contractor's assessment, which means if the head contractor goes under, you don't get cascading insolvencies. Are there, to what extent could government procurement and some of the technology methodologies that are around today, clearly you can only do that now because of the different technological landscape, that we might be able to stabilise some of the, stabilising the payment system, for example, to prevent cascading insolvencies. There are also payment schemes now where, for example, you'll put your sick leave and your holiday pay into a fund like IncoLink that is a portable entitlement. What can we do in payment schemes, for example, that mitigate against some of the risks for creditors that will impact on the greater economy?
Yeah, I would have to find out a bit more about the Western Australian scheme in that respect, and I'm not sure what other states do in respect of their procurement for major projects and that sort of thing. And you're right, there are some schemes, particularly in areas where there's a fair bit of movement across employers, in some portable leave schemes, that sort of thing, which actually require a payment into a central scheme. That probably wouldn't work for every industry, but they do work, I guess, for industries that have a relatively itinerant workforce.
If you could perhaps take on notice, if appropriate, having a look at some of those schemes. I think, you get your good practitioners tend to use them because they like the mobility in their workforce. But you might still find that, there are, to what extent there's an association between a company that is more likely to go bankrupt, but that is also a company that is not meeting its statutory obligations for workers' entitlements, etc.
Mm-hmm. Yep.
Thank you, Chair.
Thank you, Senator Pratt. And Mr Pitt has a question.
Just one brief question. The threshold was increased from $2,000 to $4,000 for the ability to file. Does the Productivity Commission have any view on whether that's still an appropriate level given the increases in the cost of just about everything? Obviously, that's $4,000 plus your legal fees to put someone through.
Yeah, I would, Senator, have to take that on notice. So that goes back to the recommendation we made back in 2015, and what has happened, to that threshold since. I would have to check on that.
Well, I mean, 100 times 4,000 is a significant amount of money, but if you don't have much out and you get put up for a $4,000 account, you can tend to fall over pretty quickly because confidence is everything. And the moment anyone even thinks you can't pay your bills, you lose your 30-day credit, and then everything's on cash and you're toast. So you'd be interested in your view.
All right, we'll have a look. Thanks, Senator.
Thank you.
I'm in the House of Reps, mate. I work for a living. Thank you.
Oh, sorry. Yes, I'm sorry. Yeah, right, my mistake.
I think I need to rule on that. My goodness.
Yeah.
You should indeed. You should indeed, Senator Scarr.
I'll resist.
Okay, in the interest of harmony, can I just go to a couple of final questions? With regard to the Whitaker report, did you have any engagement with Treasury or the Attorney General's Department in design of legislation that we know from evidence this morning was prepared but not advanced by the previous government?
Not to my knowledge. So I'm pretty sure no, but I'll come back to you if there's any change to that.
Okay, thank you. Just regard large and small entities, you made a distinction in your response to questions from Senator Pratt about the motivations for engagement, directors' breach of duty for the bigger players going in quite quickly. But the directors' responsibilities, even though the scale might be different, for small entities and large entities are the same, but there's a degree of personal investment that's not classified as personal insolvency, yet actively is personal for a mum and dad company with, you know, literally mum and dad, or dad and dad, or mum and mum being the directors. You talked about the motivation there being most motivated by the loss of home or liquidation in the kind of way that Mr. Pitts just alluded to in his final question. That brings me to the question about the historical separation of corporate and personal insolvency, the different language that is embedded in those processes, the different sense of risk, shame, practice that's embedded in that. We've had a few suggestions that it's time for a root and branch review. You know, is the separation of that legislative frame here a historical artefact that belongs to another time, appropriate when the Harmer report was undertaken? Is it time now, given the evidence that we're receiving, and perhaps will be informed by what's described as a cliff of insolvency that's on the horizon, is it time for a root and branch review of our current structure of insolvency law that better reflects the integration of corporate and personal bankruptcy that's in effect in play?
Yeah, it's kind of, I don't know whether it's my place to recommend that there be a root and branch review. I do note that is a persistent theme that is coming through in the submissions to your process. I mean, to the extent that, Senator Scarr asked earlier about the question of whether we should have a single piece of legislation, single regulator, that in effect was not our view in 2015. And so I think the question that we would pose is what has changed since then that would militate in favour of going down that path. Some submissions have raised things like gig economy and other things that might suggest that now's the time to revisit that question. But there is the kind of more intermediate option of just trying to identify where there are inconsistencies in the bankruptcy and the insolvency regimes that could be ironed out to some extent. I don't think I'll really proffer a view on whether it's time for a root and branch.
I think one thing to keep in mind is that at least in 2015, and it probably hasn't changed significantly, business-related factors were responsible for about 20% of all bankruptcy. So there is a sizable proportion of bankruptcy, personal insolvency, that's not related to business activity. So in the event that a decision was made to combine the personal insolvency and the corporate insolvency frameworks, there would need to be substantial different arrangements for those situations, the 80% of bankruptcies that are not related to business activity. So, they might be related, for example, to an individual's marriage breakdown or, gambling or, consumer activity. But there is a lot that's not corporate related.
Thank you for that. In your report, you just speak at one point of time you make a recommendation really about a streamlined approach. You talk there, your model was to avoid the delay and cost in insolvency. You said that is due to the process involved in the creditors approving and challenging the practitioner's fee. And you recommended that fee structures for small liquidations be determined through a tender process by ASIC. An assetless administration fund was mentioned there. We've had evidence that a huge degree of $47 million in 2013 was estimated the cost of the cross-subsidising of insolvency practitioners in doing the administrative work necessary to comply with the law for any company that they might be engaged with, or any business, whether it's a company or otherwise. How's it all going in that space? You know, like how things are funded. Is it working? To what degree do you see your recommendations having been implemented effectively? I know you discussed some of this with Senator Scarr. Is it wise? Is it appropriate to have a cross-subsidising model of private industry for public good? I know it's how we do it. The question is it good, and is it sustainable? Sorry, there's a bit there. I'll just invite you to respond.
Yeah. Do you have a view on that, Ros?
I think one thing that we recommended in 2015 was that to the extent that additional funding was required, there should be consideration of increasing the annual review fee for company renewals. So the assetless administration fund, I think, existed already at that point in time. And I think at the time it was not a sufficient amount of funds from memory for the activity that was required. In general, you would be looking to avoid situations where there is a substantial amount of cross-subsidisation, particularly where you have public and private interests. But it's a matter of there are public interests who actually funds those public interests, and it's not always a situation where it's appropriate to push that back onto taxpayers at large either.
So we're in the tricky space of the work getting done and who should pay for it and mechanisms to pay for it to allow that exit that you described as a key requirement. In fact, this is what you say. The Commission recommends that the fund be, this is with regard to the assetless administration fund, the Commission recommends that the fund be renamed the Public Interest Administration Fund, reflecting the public rather than the creditor interest in most small liquidations. And the additional revenue required be raised by increasing the annual review fee charged by ASIC on Australian company number renewals. Is that still your solution to the cross-subsidising problem?
We would need to look at how things have changed with the regulatory arrangements, particularly in relation to the small business liquidations that have been brought in since then, because I don't know how that's impacted on the funding of these.
Can I just indicate in an article by Jessica Yon called Serious Red Flag, Insolvency Experts See Increasing Collapses in 2023, that there's a really pressing public need for some clarity about what might occur. I think the market's talking. Insolvency practices are preparing for this uptick by hiring and upskilling existing staff, digitising their processes. What is the, and maybe you need to take this on notice, does the Productivity Commission have a view in the current economic circumstances about a likely increase in insolvencies and the satisfactory or unsatisfactory nature of the prevailing ecosystem into which that will be feeding?
Chair, I don't think we've got anything by way of, prediction about where insolvencies might go, though, again, I just note submissions have pointed out that some of the conditions in the macroeconomy are probably suggestive of some pickup in insolvencies, noting that insolvencies fell during the pandemic. So,
because
some
of the
pickup,
change of regulatory requirement.
in part that, but even once those were removed, it did appear that there wasn't quite the expected uptick, and that largely reflects, I think, the level of government stimulus combined with a range of other concessions, from landlords, from...
Yep. So a
the
bit of
tax
fat in the
office,
system that was not normally there.
Yeah.
Yep.
Yeah, so we saw business exits generally and insolvency specifically falling and not rising as one might expect during a recessionary period. Noting what I mentioned earlier about the construction sector, for example, other submissions have demonstrated that there are some portents to suggest that insolvencies might rise. And I note too that there is a couple of submissions that have noted that consistent with the fall in overall insolvencies per 100,000 companies over recent years, the profession itself is a bit smaller than it has been at times in the past. So that goes to your question of, what's the state of the ecosystem? But it's hard to make predictions. I mean, we all in 2020 predicted that there would be probably an uptick in insolvency due to the pandemic after the temporary relief from directors' duties for insolvent trading once they expired. Didn't happen, so it's hard to predict.
Thank you. Any further thoughts you have on that, I notice would be great. And of course, I expect there will be some questions on notice further to this from the Secretariat. We'll try and give you a Christmas break though and push the date for response out into February so that people actually can do a little bit of mental health repair in this first non-COVID summer for a long time. Hopefully we get a bit of sunshine as well. Not too much to cause fire.
That would be great.
All righty.
Apologies, Chair, that we're not as up to date on many of these issues post the 2015 report, but we'll endeavour to take those questions on notice.
We're glad that you're here, and as I said, this is only our first hearing, so we're sort of fact-finding and trying to establish the ground. We may well recall you, and if possible, it'd be great to have you in person, but thankfully we've had a very clear line today, so that hasn't interrupted our inquiry. Can I thank the Productivity Commission for their evidence today? I now invite representatives from the Australian Small Business and Family Enterprise Ombudsman to come to the table. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
Yes, Chair. Bruce Wilson, Australian Small Business and Family Enterprise Ombudsman.
Hello, Chair. Miss Alexandra Horton, Director of Policy at the Australian Small Business and Family Enterprise Ombudsman.
Hello.
And my name's Katie Grajdanikova. I'm an advocate in the ASBF here as well.
Could you just say your surname one time for me again?
Grajdanikova. My apologies.
Grajdanikova.
Yes, that's it.
Okay, all right, that's fantastic. Thank you very much. I now invite you to make a short opening statement, and at the conclusion of any remarks, I will invite members of the committee to ask questions.
Thank you, Chair, and you know of my height, I can only give short addresses. We welcome the committee's inquiry into corporate insolvency in Australia. Insolvency can occur in companies of any size, but it is particularly devastating for small and medium-sized businesses who face unique challenges. Over 99.6% of Australian businesses are small businesses through the lens that we apply, and I'd point out that's fewer than 100 employees is the mandate we have. We know they often have less cash flow to mitigate against disruption. We're often underinsured and have fewer legal protections and tactics than larger corporates. Compared to big corporates, smaller businesses also have fewer tools and resources and less time to get across the full suite of legislation and regulation in relation to business management, including awareness of insolvency processes. Small business and personal finances are also uniquely intertwined. This blurs the line between personal and corporate insolvency. A small business can become insolvent for numerous reasons, and they can often find these reasons to be outside their control. Entrepreneurs with great ideas may not always succeed the first time. In fact, many of our greatest companies and inventions were started by people who didn't succeed at their first effort. Yet the current insolvency system is not sympathetic to honest failure and genuine prospects for recovery of the business or the business owner. The life cycle of a small business should include a simple early exit strategy should the business start becoming unviable. Small businesses need access to more timely advice that is written in plain English on insolvency and restructuring processes. It's also vital that enterprising men and women have access to trusted advisors with the skills necessary to manage business viability and to highlight early concerns regarding the solvent nature of the business. May I suggest the committee consider ways of improving the uptake of small business restructuring provisions? The 2020 reforms were a welcome initiative, but remain complex and expensive, with only 70 debt restructuring processes out of a total of 4,912 insolvency appointments in 2021-22. Chair, all we are saying is to give restructuring a chance. I would submit that it is also important for the committee to give thought to ensuring small businesses have better access to debt hibernation in the event of future natural disasters or other catastrophic events such as pandemics, so that they are better able to pursue a credible restructure, save jobs and rebuild. Such a program would include a freeze on tax and other fees, as well as government financial and specialist advice support. It could be triggered by shocks beyond the control of the business and provide the option to hibernate their business debts, to pursue restructuring and to continue trading. The program could also include tools to allow businesses to assess their viability and assist with future planning. These measures are key to a healthy economy and to driving and supporting entrepreneurship, innovation, competitiveness and productivity. Effective insolvency processes balance the needs of all parties whilst being timely, affordable and effective. Creating an insolvency framework that adequately incorporates the unique characteristics and needs of small businesses would assist productivity growth and provide for a dignified and cost-effective experience for small business exits, while preserving the entrepreneurial spirit so that they have an opportunity to try again. Thank you, Chair.
Thank you, Mr Bilson, and I just invite you to table that opening statement.
Thank you,
The
Ma'am.
Secretariat might grab that from you when they can. And I'm going to go to Mr Pitt for the first line of questions.
Well, thank you very much, Madam Chair. And I'm sure you heard the question I put to the Productivity Commission earlier. I'd be interested in your view around that threshold for being able to put a company up for insolvency. And secondly, I see your comments around trusts and the proprietary limited companies, or whatever the format is, being tied to them. I understand the point that you're making, but I wonder if you have any view on how that could actually be done, given that it's an entity, a person, which would be insolvent.
Thank you, Mr Pitt. The law basically says we've got the oil of an enterprise and the water of an individual. In the space we operate in, virtually everything is salad dressing. It's a combination. There's 2.5 actively trading enterprises, about 950,000 are incorporated.
Did you say me 2.5 million?
2.5 million, sorry, I left the little denominator off the S. So the vast majority aren't incorporated. There's a range of other structures, and many of them inherently have that blend, that mash together of business interest and personal interest. And then even if you are incorporated, some of the broader policy settings force that anyway. About just under half of all small businesses accessing finance for their business have their home on the line. So there's a finance practice to create that interconnection. In areas of tax, and I heard Senator Pratt mention earlier about super contributions and the like, the tax office can activate director penalty notices and make business liabilities a director's personal liability. So we see that moulding together, that blending quite often, and that's something that we think is really worthy of consideration by the committee. There are international examples where they don't make such a distinction, and that we've drawn attention to some of those in our submissions. As for the trigger point, it's a world of pain if it's activated at a low number. And we also know even if that activation does occur, there then can be consequential impacts, preferential payment arrangements. a small business that's not in trouble but has been trading with one that is, may get a fairly heavily worded, very legal demand by an insolvency practitioner to cough up the payment they received for goods and services provided sometime earlier, suggesting that they should have known that the business they were dealing with was possibly in trouble. Now, I don't know how they'd have that situational awareness, but I think, as the Chair pointed to earlier, and in other questions, one business's challenges then becomes a contagion across a number because of the way in which those powers are activated. So the trigger for that kind of experience seems very low.
So just to come back to the question on trusts, so companies as trustees for trusts, I can see the complication because you can use a company as a vehicle to do pretty much anything. Many businesses keep them separate to the family trust or how that might operate or how they put it together. But given that the company could be put through as an operating business and it'd still be a trustee for a family trust, do you have any view on how that could be addressed? Because I don't really see at law, I'm no lawyer, but I don't see how you could do anything about an entity being put into insolvency. And I get the complication, that the trust's assets then have to be sold and restructured.
Well, it's the same with independent contractors, partners. These all run into those same challenges. I guess what we were trying to do was surface international practice where they've sorted that out, and suggest that might be worth the committee's consideration.
Okay. Thanks, Chair.
Senator Scarr.
Thank you, and thank you, Mr. Bilson, for joining us today. I wanted to, in the first instance, talk about the small business debt hibernation program that you're talking about. So, in what circumstances would that be triggered? And I'm asking in the context that there are small businesses on either side of the equation, right? So there's the small business that's going into hibernation, inverted commas, but there's also the small business that's relying upon that other small business paying its accounts so it can continue operating. You talked about the contagion effect. So how would the small business debt hibernation program work in practice?
Yeah, it'd be similar to what we saw during COVID. An external event that's had profound impact on the economy, whether it's the economy as a whole, a region or a particular sector. And at that point, like we saw during COVID, I suppose, Senator, some of the spears were put away. People were given the opportunity to take stock and to map a path forward with different kinds of assistance. So it'd be that kind of event. We wouldn't recommend it be automatically activated in every circumstance where a small business runs into some challenges. This is about those catastrophic events outside the control of the business that really no one could anticipate, and that there is a need to take stock and map a path forward.
Okay. I don't know if you heard some of the questioning in relation to the Department of Treasury Department in relation to small business restructuring. Provisions that were introduced in the 2020 bill effective January 2021. I just want to quote from your submission, which I think addresses some of the concerns I had looking at the numbers presented by Treasury. Quote, while the intentions of the Corporations Amendment Corporate Insolvency Reform Act 2020 was sound, this legislation is also complex and expensive for most small business insolvencies. Its uptake remains low, with 70 debt restructuring processes in 2021-22 out of a total of 4,912 insolvency appointments, or 1.4%. Uptake increased to 83 in the September quarter of 2022, but still accounts for only 4% of corporate insolvencies, end quote. Two questions. What should success look like in this space? So at what level could we look at the figures and say, okay, well, we've actually hit the mark here in terms of the small business restructuring reform? That's the first question. So what does success look like? And secondly, what are the sorts of things we need to tweak in the system to achieve that success?
Yeah, super question, Senator. The success in our view would look like it being an early consideration on the table that should be worked through before the decision is made to wind up a business. Now, percentage-wise, it's a little hard to predict because it's a case-by-case example, but what has been shared with us through our consultations with small and family business industry associations and the insolvency practitioner world is that the simplicity isn't as simple as it was thought, the cost effectiveness isn't as cost effective as was thought, and that there are a number of gates before you can access it. So on simplicity, there's still some complex steps to be gone through, both by the law as it requires it, but even it's been shared with us that insolvency practitioners, to make sure they've fully exercised their full diligence, are often asked to do things in addition anyway that sort of mitigate against this cost-effective, more responsive model. They do that for public liability insurance, or if I could use the phrase white tape, business is imposing it on itself. For example, you may be a major creditor, a secured creditor, or perhaps the tax office or someone like that, and someone's talking about using a restructuring provision. What's shared with us by the practitioner is they're then saying, well, what are my options? How do I weigh up that mechanism against a more traditional insolvency or VA arrangement? So the practitioner is saying we're still being asked to do the other work while creditors weigh up which path to pursue. So it's not just the work that's imagined with the restructuring process. So that's one example. Number two, there's certain criteria, and I think Senator Pratt touched on them earlier. If you have to have certain payments up to date to be able to qualify for it. Now, in some cases, and I think the point was made earlier in your discussions, some of those payments that are needing to be up to date are actually early indicators that something's not going very well, and that if the business was in good shape and had all of those obligations, its PAYE withholding contributions, super guarantee payments and the like, then they may not be in quite the degree of trouble that they anticipated. That is, there's some capacity in the business. So that's another challenge. The third thing that gets raised with us is that if you, and I'd encourage you to inquire if you haven't already, of ASIC about who the practitioners are that can actually exercise this mechanism. You've heard that old saying, if the only tool you've got's a hammer, every problem looks like a nail. Well, the vast majority of restructuring practitioners are insolvency practitioners. And you wonder to what extent that skill set lends itself to a different lens about business recovery, business growth, business building. That's a bit different from being an insolvency practitioner. So there's also that mix in it as well. Encouragingly, I think in the last month there's been quite a step up in utilisation. So there's also an issue around the practitioners themselves knowing what's required of them. And I think some of the creditors are getting better experience about interacting with it as well.
So that requirement for small business owners to meet all their tax and employee entitlement obligations prior to being able to access the system, is it correct to say the issue then is, well, you actually need some advice to restructure, to go down this path, because that's one of the issues, that's one of the red flags. So if you can't access the system, when that red flag's raised, it almost makes the process for, at least for some companies, nugatory, because you just can't access it.
Yeah, it does risk of running into itself. And the other thing too, and this is a conversation we're having with the tax office, for whatever reason, someone might have a tax debt, but if they're on an agreed payment plan and they're meeting those undertakings, surely that's the kind of discipline and commitment to meeting your liabilities you'd be looking for. So it's those sorts of things, Senator, that we think could do with some fine-tuning. But your point that you alluded to earlier, our strongest point was how do you get that advice, how do you get the financial know-how in the mix early enough so that there are resources in the business to support a restructuring. One of the things we've touched on in our submission, I'm sorry, Chair, I'm probably diverging a little bit here, but the stigma around being insolvent and those interconnections that the Chair spoke about with your house being on the line and all that, our sense is that encourages people to think about restructuring very late in the piece, very late in the piece, when it's often too difficult to bring about change. So how do we get earlier advice? How do we get people thinking about the future of their business with the financial know-how to see trends, to understand certain ratios are tracking the wrong way, and to be realistic about future prospects so that they can then take steps in a more timely way rather than have it at the last minute before metaphorically the business hits the wall?
Sure. I'll just ask one other area of questions, and that's in relation to personal properties securities register. So in a past life, I've had experience in insolvency situations where, in particular, small, medium-sized businesses have had equipment on, say, mine sites where the company's gone into liquidation or voluntary administration. There's been all sorts of issues in terms of them rescuing their equipment, getting their interests recognised. So interested from your perspective, in particular from a small business perspective, the issues around the current system relating to personal property securities.
Yeah, we were very active making contributions to the Whittaker Review and encouraged by a number of the recommendations. I mean, the technology that sits around the register is quite outdated, and some of the search functionality needs a degree of precision that almost renders it challenging. You need to be able to get the VIN number precisely right. The type, the description needs to perfectly match. Those things are quite challenging, and people have been better able at registering interests rather than removing them. And we've seen some challenges there, and including equipment finance companies that happily leave those registrations there when there's no longer an interest they have in the equipment, knowing that if someone seeks further finance, they'll search the register and see let's call it a dwindling registration, and that financier can say, "Oh, I understand you're in the market for some finance."
So just on that point, just on that point,
yeah,
it's so from your perspective, you're saying it's not a housekeeping issue. It's actually a business. Maybe I'm naive.
It's a lead generation tool.
It's a
business tool.
It's a business tool.
Yeah,
right.
And a customer retention strategy, as my colleagues pointed out. The lead generation value of it is seen, not spoken about a lot, but it's infuriating for businesses that want to canvass other financing options, and they find there's a dangling registration in the PPSR that alerts a former financier to their interest, and then they're on the phone.
Right. And can you give us, I think there are a few examples referred to in your submission where the current regime in terms of personal property securities is delivering very problematic outcomes in the context of large liquidations.
Yep.
Can you draw that out in some more detail?
Yeah, the challenge is, and when the case studies we've shared with you have come through our call centre, through our assistance service, so they're real life examples, and these are where someone unilaterally starts to recover assets and they pick up everything, not just the ones that over which they may have an interest. We've had delivery vans where there's been equipment finance over one, and then someone's come in and picked them all up. And then on-sold them at a very cheap price. And we're saying to the financier, I said, hang on, you've just flogged someone's van and then sold it for a song. How do you expect to remediate that error? No contest over one of the pieces of one of the vehicles, but did you have to get them all? And they're very difficult conversations as everyone looks to blame each other for it. So that's the kind of example where the PPSR hasn't quite lived up to its billing, and then those involved in recovery actions have taken a more inclusive approach to the assets that they've picked up.
Right. Well, possession's 9/10 of the law. That's
well, and when it's on-sold, Senator, you can imagine the transport company having, my van might have been worth, according to the Red Book, 22 grand. It got sold for $3 as part of a liquidation sale, and then they're 4 steps down the track, and the business owner's saying, "Well, where's my van?" It gets pretty difficult.
Okay. So you think some of the recommendations coming out of the Whittaker Review should address some of those issues?
Yes, sir.
Okay, thank you. Thank you, Chief.
Thank you very much. Can I go immediately to the Whittaker Review? It's ageing. At 2015, we had some evidence this morning that Treasury and the AG's department were involved in preparing legislation for the previous government that never really saw the light of day. Were you involved in the consultations around the delivery of that unseen legislation?
Consultations, yes. Not on the legislation itself, though, if I could draw the
Okay.
distinction. I think we were unaware that there was legislation being drafted, but we were very proactive in making it known. We thought some of the recommendations should be gotten on with. So that's been the level of our discussions, highlighting a number of the recommendations we thought that were more pressing than others.
So have you got any sense of the cost to business of the failure to act?
No, not really. It's more that kind of example that Senator Carr was alluding to, where the good intention.
Scar.
Oh, sorry.
Senator
geez.
Carr's, I have a lot of time for Senator Carr, so I won't take that as an insult.
May I apologise to you both if for that.
Well, that's the other approach.
Sorry about that. Yeah, just where the utility of it and its ambition wasn't being met, and in some examples where it was being used for purposes other than for what it was designed.
Okay. Did you see any of the draft legislation at any point?
I certainly haven't.
No one in the agency did?
No, ma'am. No.
Okay. Are you aware from your consultation with the sector, were other entities involved in looking at that legislation? Was there other consultations that you're aware of?
In our consultations with our policy forum, no one's mentioned being involved with it. Our focus was very much on getting the technology behind the register updated so that that level of absolute precision that was needed in the search and identification function was a little more accommodating. That was our main focus, and in terms of our policy forum, we got head nods for that, particularly people involved in the equipment finance space.
The cascading or contagion effect has been spoken about a little here. I was interested in your hibernation suggestion. Did you present that as an option, a policy option to the previous government?
No, well, it was included in an earlier report from the agency, so the previous government would have been aware of that.
Okay, and you said that it was important for businesses to be able to access this sort of freeze. One of the things you said would be on tax. To be clear, you're saying a freeze on tax, but ultimately repayment once the business recovers. How commonly does that occur?
Well, the tax office has been, during COVID, as you would be aware, Chair, in a support and assist mode.
Yes.
So they've been very accommodating, and so long as you stayed in touch and recognised there were obligations that you had and even had a payment plan, they've been very accommodating around those things. And generally the tax office's disposition is to be accommodating. They're not legally obliged to be that way. So it's good that they are that way, but it's very much a discretionary thing of the tax commissioner and the team at the ATO. I guess what we were looking for was having that recognised as a fairly standard operating approach at the tax office. They tend to do that in areas of natural disaster and the like, and that was why we thought we should highlight this practice and see whether it could be embedded as just the normal way that agencies operated after a catastrophic event.
So have you had a chance to look at the ATO's submission to this committee?
I haven't as
Can I
yet, no.
suggest you do that, and I invite you to respond to that?
Thank you.
Because they do indicate somewhat of a shift in tenor as the economy starts to return to normal. That being said, there still is some significant knowledge acquisition in light of what we've just been through with COVID. So
Just on that, ma'am, I just disclose I co-chair the Small Business Stewardship Group with the Tax Office. So some of those governance decisions, prioritisation conversations are had through that group, and that's how the shift away from support and assist to a more regularised arrangement. We've been interested in where they're prioritising that work, reassured that the focus is more on debts arising pre-COVID that have been there for some time, and for taxpayers for whom they haven't heard from a lot. But I imagine that will move its way through the debt book over time.
Right. Okay. What do you think the impact of that will be for small businesses?
It'll be very challenging. A couple of things that I think were touched on earlier, and I'm just going to use the name to correct myself that Senator Scar alluded to. There's a range of things. The deferrals in tenancy arrangements, in leases, well, there comes a time when the landlords are looking to have those made good. Some of the banks have been very proactive in working closely with their customers. Some have had deferrals, others have restructured their finances. That's not going to last forever. And also with the tax office coming in, there is a prospect that you'll have a number of those issues coming together at one time. And for some businesses, and I'm thinking to illustrate the point, businesses in the CBD that are used to certain volumes of foot traffic to drive their business. If that foot traffic's not there, yet you've got more lead in the saddlebag from these deferred payments and the accommodations that have been made your way, that's a really challenging time. So we've been urging people to take stock of that, to maybe use, even after Christmas, to really have a long, hard think about that. But the other challenge, Senator, is Madam Chair, is that with some of those lease deferrals, what was a part of that arrangement was an extension of the lease term. And so as you would know, a commercial lease, you can't hand the keys back and walk away. You carry the liability of that tail. And in some instances, that tail is longer and heavier, with the business that you're in maybe having lesser prospects than pre-COVID, and that's a very distressing time for small businesses. And as my colleague Ms Horden pointed to, Treasury released a report yesterday about the mental health of small and family business owners, and it's stark reading. And even through NASBO, I know, ma'am, you've been a champion of that. I think off the top of my head, and I'd have to check, I think 40% or plus of those events causing the anxiety and sense of overwhelmingness relate to these financial issues. So it's a character building time and a real distressing time for many small and family business owners, as they think not only about the enterprise, the personal assets that are interwoven, their identity that's part of that story, but also the livelihoods that rely upon that business. That's an awful lot of responsibility to be carrying at the moment.
Even if it's a micro business, which might have 4 employees, that's still 4 families that are engaged in that.
Well, and also if you're thinking about self-employed businesses, one of the critical risk factors is key person risk when that person is the one that's generating the livelihoods. And if they're feeling a sense of overwhelmingness or distress around these financial circumstances, they are the haymaker, more or less, and if they're not in a great place.
Which is why this inquiry is important. Ms Horden, did you want to add something there?
Well, just a point about the Treasury's report yesterday, which is an excellent report, and I'd commend it to you. And forgive me if I get the number wrong, because it was just yesterday, but I think it said that in excess of 50, it might have been 54% of respondents said that the primary reason they didn't seek mental health care was because of the cost of it. So if you've got businesses that are getting towards that insolvent position and they know they need help, but they're not seeking help because they can't afford to get the help, that's a really serious situation.
So that's personal help in terms of their cognition and capacity to think and anticipate and continue to work and trade and maybe move from closer to insolvency out of that. Yeah. Which is happening every day with many small businesses. You would agree then, based on your evidence there, with the report from Jessica Young 2 days ago, this December 11 report in the Sydney Morning Herald, that insolvency and company restructuring specialists are bracing for bigger workloads, with businesses poised to bear the brunt of a stinging financial hangover predicted to hit in the early months of 2023. This will engage people with the insolvency laws of this country. I've been asking questions about the appropriateness of the separation of personal and corporate insolvency. It seems to be very muddy for a significant number of Australian businesses who are operating with directorships but are ultimately very small or micro businesses with personal finance embedded in it. Yep. I'm advised that 20% of the failure of businesses is from business decision making, but the debts are wrapped up by practices such as marriage breakdown and the separation of assets, I suppose, gambling, consumer activity, weather and misadventure. is, given the shape of all of that, right? Crisis on the horizon, very significant numbers of small businesses embedded, which is the entire community and economy across the entire country, regional, rural, everything. Is the current structure of corporate and personal insolvency law meeting the reality, literacy and capacity of the shape of our businesses as they are today? Or do we need to undertake a root and branch review as was done with Harmer? Is it the same then and now, or is it different?
I'd argue the first answer is no, ma'am. I don't think it's fit for the current circumstances. And if it's not a root and branch review, it needs to be something like that, would be my suggestion. We've seen models, and Katie's done some excellent work looking at international examples where the Canadian model stood up as one that we were attracted to. You've alluded to that, and I've tried to characterise the salad dressing that is reality. Even if you do set up yourself neatly as an incorporated association, there's many commercial practices and in fact government and regulated behaviour that'll blend them for you anyway. The number of homes that are the collateral for business loans, personal guarantees, all these sorts of things, and then director penalty notices and other areas that will become a personal responsibility through a corporate lens. This is the way business operates in Australia for the vast majority of small and family businesses. That seems to be lost on the law as it currently sits, so that there is scope to improve that. And Kate, do you want to add why we thought the Canadian model had certain features that you thought were attractive?
I think this is your recommendation 5, applying the international best practice. If you could speak to that, Ms. Grajdanikova, correct?
Yep, that's correct.
Because you've also put something in there about Chapter 11, and we've kind of got pretty negative feedback on Chapter 11 in the submissions and today again.
Yeah, while Katie's getting her material together, the Chapter 11 thing gets thrown around.
Yeah.
We just think it shifts, and you were talking about the Productivity Commission report earlier, which I'm quite familiar with. The Chapter 11 does shift responsibility and an onus, in my mind, a little too far away from the it puts the debtor or the business a little too much in control, and so it's just a calibration. I'd be thinking about something Chapter 11-esque without going all the way to Chapter 11. The information is that if creditors felt we had a full-blown Chapter 11 in Australia, they may be less inclined to lend. Right now, we'd like to see more lending to small and family businesses, not less. And if it went too far towards that US model, very legalistic.
Yeah, court and costs seem
very
prohibitive.
expensive, and creditors are not always certain on their footing. That may have a chilling effect on lending, and we don't want to see that. We think there should be encouragement for lending to small and family businesses, not new obstacles. But sorry.
Okay, thank you.
Yeah, I'm happy to come from here. Thank you, Mr. Bilson. What I did discover from the research is that internationally, in the United Nations Commission on International Trade Law and other insolvency panels, you have countries like the US, Canada, UK, and Singapore ranking very high as being quite effective. But Australia isn't. And I think that sends a powerful message. We focused on Canada because I guess the things we really like is that in Canada, they assume the honest debtor rather than somebody has intentionally done something bad in the system, and the Canadian regime is designed to give a fresh start. We also like that following the bankruptcy process, this is followed by credit counseling in Canada, and this focuses on that rehabilitation so that business owners are less likely to repeat the problem, and provides those business owners with skills to support entrepreneurship, to make sure they do have a chance for a fresh start. And as Mr. Bilson and yourselves have correctly pointed out, it does provide that singular legislative framework for personal and corporate insolvency, because there are a lot of linkages between personal and corporate insolvency, particularly in the small business space. So Canadian system is something worth looking at alongside with the UK system and perhaps Singapore as well.
Thank you very much. I referred to a case study earlier. that you had in your submission that I think often gives... let me start again. Many small businesses have no interaction with liquidation, with the sector, and you actually raised the question, and I think this is a very good one, who are the practitioners that could help a business in recovery? Because the skill set for helping a business that doesn't want to disclose its dirty washing at the same time as being protected by the current structures, looks like they've got to get a liquidator in, basically somebody who's an insolvency practitioner.
Yeah.
The skill set match isn't quite what it should be. And your particular case involved a company that had assets worth $1 million when it entered an insolvency administration, told it was going to cost $60,000 to do it, and then ends up with $500,000 removed for the insolvency practitioner before anybody got paid. So I wonder how much that's also speaking to the cross-subsidisation, and I've only got that 2013 figure of $47 million of insolvency practitioners propping up the public work that they're doing, providing 20,000 reports to ASIC about which nothing's done. So can you talk to me about that ecosystem and what's going on there and why businesses, seem to be frightened about engaging?
Yeah, well, there's probably three reasons for the fear. One is these stories are too common, where the beneficiary of a business in trouble, once engaged in the insolvency process, people sort of wonder what's the outcome for people. Well, let's use the word stakeholders, not just secured creditors, but business owners that have put their life into it, employees that love to see the business going, and investors. They're kind of wondering, well, where's my spot in this conversation? At times when significant proportion of residual assets end up going to the practitioner. We held a practitioner roundtable, Chair, where we had a very good discussion with insolvency and restructuring practitioners, and they were quite adamant about what the problem is. They're asked to do a whole bunch of stuff under the law with businesses that don't have the capacity to pay them. So when they find one that's got a capacity to pay, it's almost like a gold miner. They've found a seam of gold. And so that kind of behaviour goes to the point that we were making earlier.
So the current law structures you're telling me there are distorting the commercial practice.
Yep.
It's described in some of the submissions as market failure.
Yes, ma'am.
Yet we're hearing from Treasury and the Attorney General's department that, everything's okay.
Now, they may have a different lens on it, if I could respectfully put it that way, but that's not what we're seeing. And there's some academic work done by Michael Murray, who did some work. I think we might have flagged that to Dr.
We've
Turner.
got Murray and
his team.
Harris, yes, we've got them coming in this
He did
afternoon.
a PhD piece of work saying, well, where's the public trustee equivalent for small businesses, where there's many of them that have nothing going on, no assets, nothing to be seen here. Where's the neat, tidy close, wrap it up? I mean, our concern is that even with 7,000 insolvency processes, but we know mid 70,000 exits of businesses from the economy. What's happening to those in between? Now, not all exits under the ABS numbers are business failures. They might have been purchased, acquired, merged, that's fine. But there's tens of thousands of businesses that just fall off the perch. And we don't know what happens to them. We don't know what that blending of business interest and personal interest is meaning for their future life, for their families. How are people's interests properly closed and the business wound up? For many times the number of businesses then are actually formally closed through the insolvency process. We're not sure what happens to those people. And so what Mr. Murray's work was about was, is there a really, streamlined, not much going on here, nothing been trading, no one's owning anything. Can we just tidy it up like a public trustee equivalent for the business community that then would see that public good of tidying up that business handled that way, and then the insolvency practitioners could focus in on the ones that have got assets and cash. where they can actually focus on the work that's before them. Part two is the practitioners remind us of the formal reporting obligations that they have to service as part of their licensing and part of the law. They do that, and they're not entirely sure that there's good utility in that work. I mean, is ASIC well placed to review all those reports? Does something happen with them where they might identify a concern around directors' conducts, or are they serving any good purpose? And so
they're serving compliance with the law requirements for registration.
Yes, and as part of the Act, they have to produce certain reports and exercise and show they've exercised certain diligence and judgment. They're happy to do that, but that costs time and money. And where there's very little asset in the business, they do that because the law requires them to do that. Their professional indemnity insurance requires them to do that, and they don't get paid for it. So when you see a business that's got some resources in it, you can imagine how attractive that might be.
Can I just put on the record, I think we should use the public trustee as a good example of anything.
Yeah, and I understand there's different experiences in different jurisdictions, but the idea that there's thank you, Mr. Pitt. I should have been more sensitive to the federation there, but that kind of institution that just deals with the work of cleaning up these businesses where there's nothing to be done with them, just to formally close them. Mr. Murray's PhD thesis teases that out, and it draws on the point you were making, ma'am, about the fees and the work done that's unremunerated, and then how is that dealt with other clients.
And I will seek to understand from him what is the benefit of cleaning up if the cost of it is so high. Is it better to do nothing than clean up?
Well, and that's his central point, is that it is so expensive. A lot of people will just not do it and just let the business atrophy, and over time the ABN will be cancelled and kind of just fade away in a regulatory sense. But what's happening to the entrepreneur, the business owners, people with, expectations about the business? There's no clean discontinuation.
And I guess is that a good or a bad thing? I just want to ask a clarifying question. The case that we've been talking about with a business that had $1 million in assets, nobody getting any money until $500,000 had gone to the insolvency practitioner through the liquidation process. Is this an outlier case, or is this the business model revealed?
I don't think it's exceptional. I don't think it's...
Is there any data on this?
Not really. We only get the ones that are really unhappy. So through our assistance service, it manifests itself as a grievance where we get asked to assist where we can, and then we'll get involved. And that may involve liaising with the regulator, the industry association itself, because there is a little bit of self-regulation around the practitioners. There is some process to flag whether you've had a bad experience or not, but people aren't always happy with that process. There's a number of these.
I don't know how you'd be happy if your business was being wound up at any point of time, frankly. That's got to be hard.
Right. But I mean, look at that example. If there's $500,000 in fees going out and creditors are unhappy with their return, imagine if you'd spent 20 years of your life building that business and you saw an outcome like that. Even some of the fire sales. I mean, I use the argument that this process shouldn't be about harvesting the organs of a business that might have a hay fever sniffle. It's about the proportionality of it, and to see assets sold at prices that represent a fraction of what they're actually worth. I mean, those sorts of things are devastating to business owners on top of the...
Senator Pratt wants to ask some questions. Can I ask you to take on notice the triggering of an action by banking or financial institutions or any other lenders, including equipment providers through financing, and the ATO with a DPN? If you have any data or insights into that, how critical that is in terms of small business engagement with this sector, and what structural response is available or not available at that point of the trigger that might be appropriate to help businesses survive, if possible, and all the jobs that come with that.
Yeah, just on that really quickly, the ATO and the major banks' posture is very fundamental to this, because if you're going to propose a restructuring plan, if either one of those two parties aren't on that program, it's not going to happen. So we have asked through that small business stewardship group with the ATO saying, well, what's your practice? How do you view a restructuring proposal? And they rightly said, look, we haven't had that many yet, and it's very much case to case. If it's a business that's got a good record of meeting its obligations and they just happen to hit choppy waters, that would bring a receptive appetite. If it's a taxpayer who has been notoriously unresponsive over an extended period of time, well, that's a different story. So because they're so critical to whether a restructuring plan will get off the ground, we were just keen to understand the governance.
I guess the question of notoriously unresponsive to the ATO and
Yep.
very effective business might be two different
Well,
things.
and that's right, because you would know, Senator, from your earlier inquiries that if the ATO is not up and about, it's often viewed as a bit of a cash flow advantage. Now the ATO has new tools; they're just starting to exercise them. Like the ATO can list someone on a creditor monitoring scheme. There's a number of them around. That law wasn't in place some years ago.
Yep.
So your advice might be, look, pay your trade creditors, because they might nominate you one of these creditor monitoring schemes, or stop supplying you. The ATO, can't put you onto those schemes. Well, they can now. You're better off paying those and massaging the others. So that's changed a little bit as well. And the tax office has recently instigated some credit monitoring listing processes, and they can share with you that did generate different behaviour. So people were clearly thinking they could, maybe defer or slow their tax.
Which bird is the loudest chirping
Correct,
one, to
correct.
be fair?
And
Senator Pratt's got some questions, so can I go to her?
Thank you very much, and thank you, Mr. Bilson, and to your organisation for the excellent submission. We were talking earlier about some of the triggers to be able to access support, which I think included the fact that you need to be up to date with your superannuation payments. Does that mean that system is intrinsically designed to assume that if you're not up to date with your superannuation payments, you are going to be insolvent and that you don't deserve support? Or is this, can we unpack that a little bit more about what you think it should look like? Of course, while I would hope putting the onus on being able to support people's superannuation payments.
Thanks, Senator. And the point you made in the earlier conversation about it not really being their money is a very sound observation. It's the employee's superannuation unless you pay it. And similarly, if they've had pay-as-you-earn withholding tax, well, again, that's not their money either. So I think that's the ethos behind the current framing of the law.
Yeah.
I guess my thought would be that if, as part of the restructuring plan, there was a credible approach to ensuring that those payments are made, I would have thought that would have been an attractive attribute of a restructuring proposal. The alternative being, no, we won't give you a restructuring proposal. We won't support, the aspects of the business that are an ongoing concern. We'll just wind you up. I just wonder where that leaves people, employees, and the tax office and others. So I guess it's a weighing up that if, as part of the plan, those fundamental obligations will be met. My thinking was maybe that should be something that's accommodated, not simply shut off by a gate that says, well, you're not up to date on these things, can't use it. So that was the thinking, Senator.
Well, no, and I at first glance, I'm inclined to agree with that thinking, because in effect, it at least has some prospect of those superannuation entitlements, for example, being paid, as opposed to someone losing those entitlements entirely. So you would,
and I guess on that, I would imagine if we're talking about the posture and disposition of the tax office, to be receptive to a restructuring plan, I would have thought, a plan to settle those matters would be a fundamental element that they would weigh. That'd just be how you'd operationalise it, I would imagine.
So in effect, I think your words were, if you are up to date with those measures like super and tax, then it's going to be an indication that your fundamentals of your business, it really does show why there's such a small number of a small use of that scheme.
Yeah, you're in better shape, you would think.
Can I ask if you've got any observations around the use of the fair entitlements guarantee in this space? I have noticed, for example, that Avato had been allowed to to restructure and in effect become insolvent in one arm and use the fair entitlements guarantee in order to save another part of the business. I thought at the time that was pretty unusual and, puts a significant liability on the taxpayer for redundancies and unpaid holiday pay, etc. There are, I guess, a lot of businesses that pass on a lot of accumulated entitlements without, from one business to another. And you recall we amended the Corporations Act some time ago to say you couldn't trade a company and trade away or dissolve those obligations in doing so. But nevertheless, that obligation doesn't always, it does seem to be fudged in lots of ways because in some instances they're pretty large liabilities. I don't expect that we can solve that overnight, but we also know at the end of the day, when a company does go under, there are some fairly large accumulated entitlements that are at the bottom of the creditor's pile, and the system seems almost to be designed that way because we haven't really got a way of dealing with the weight of those very large accumulated entitlements. Do you have any observations in that regard? I know it might well be something that affects big business more than small, but equally I'm sure there are small businesses that have very long-term loyal employees that could do with more support in how they deal with accumulated workers' entitlements, obligations.
Nothing specific, Senator, and I'm not familiar with the case that you mentioned. We've had, I suppose, two touch points in this space where there's been a business transferred and the new business owner was under a misunderstanding that would wipe some of those things. And from our point of view, it's a little bit of a broken... Well, it seemed like, just what were you buying? You're buying all of the business? It was... What bits you like? It was very curious, but it did go to a central theme of our submission about the importance of trusted advice and going into these things eyes open. The only other thing, Senator, business.gov.au website's quite a channel, a funnel point for business inquiries, not just to the Commonwealth. It's got some state and territory lenses on it. Our data team, who are really talented, have produced a natural language analytical tool to run over the commentary. So not just to look at what boxes are ticked about the concern, but actually to analyse what the business owner themselves is saying. And this issue comes up where there's a pleasing attentiveness to concern around their staff when they're asking about how do I close a business and how do I make sure my team are looked after. So they're the only two touch points, Senator, and other than that, I'm not sure we've done any work or any analysis beyond the, the broader issue.
No, that's fine. It's still very relevant for the framing of these issues. You've talked a little bit about better use of data and data systems. Who should be in charge of that? Because it's, it's AFIC data, it's super data, it's tax data, it's bits of state government data. Is there anyone doing a good job of that currently, and who should be responsible?
Yeah, we were, well, I must confess that it's probably reflects on my character. I was a little excited hearing you talking about this before. I suppose you hear about, fintech, regtech. I keep championing something called AHA Tech, which is insights that you can derive from data that's within our systems. One example, I think it was, I'm just saying it to be cheeky, it could have been Senator Scarr asked the question, but there was an observation about the tax office's data. The tax office runs a range of benchmarks that they run over business returns, income tax returns, to sort of identify where there are returns that look very different from what's expected. Those benchmarks go to perhaps composition of the business operations spent on accommodation, on staff, on supplies, on those sorts of things. Now, I have for some years been urging the tax office to share that data with small businesses. So, when they've lodged their returns, the tax office runs their benchmarks over it. There seems to be nothing of great particular reason for further investigation. Why not send a note back to that hardworking small businesswoman or small businessman saying, thanks, you've lodged your return. We think it looks in order. Here's roughly where you sit in relation to businesses like yours in our benchmarks. Your accommodation costs are 14%, your colleagues are 9%. If you're in Canada, it would be 3%. There's a discussion for another day. To give that insight, not saying what's right and what's wrong, but just to enable that business to see what their peers are doing, and that may be a useful way of prompting the kinds of questions we like to encourage about, well, what is my business future? Where can I make gains? Are there others that are doing things differently to me? So we think there's some scope for that, Senator. We're also active on the business register.
What's the response?
Sorry.
What's the response of the ATO?
Might make this a last question, Senator Pratt.
Yeah, I mean, they recognise the value of it. Right now, it's probably more difficult. I think, and again, the ATO are better placed to explain what the ATO is doing, but the last COVID era makes benchmarking particularly challenging. They're probably going to need to reach back to pre-COVID to get some of those benchmarks populated with, more regular, normal data. But, they're certainly not unfamiliar with my views on that because I stalk them about it, frankly.
Yeah, and just lastly, Chair,
Yes, ma'am.
a peak in insolvencies, there was data from COVID where we were expecting a much higher peak earlier. Is your submission essentially saying that peak is still to come? Or is it simply a different set of economic trends that will trigger that?
Yeah, in the ordinary course of business, there's 7,000 to 8,000 insolvency businesses, insolvency business clients a year. COVID was way under that. So we're imagining there's a bit of a stock of businesses that will be needing to be dealt with. The insolvency practitioners themselves are not saying they're inundated right now, but they recognise that there's some changes in the system. We talked earlier about the tax office and its shift in posture. That's likely to generate some changes. But also, you know, the big banks have actually done some restructuring with their clients during COVID. And particularly with property values going up, that collateral, that all-important collaterals, actually grew, and so that was helpful for some small businesses, and banks have reshaped the origination with them. You know, we're seeing different things in the property market now that may cause a change in their disposition as well. So we think there's more to come.
And so how should regulators respond to that change instead of that set of trends?
Senator Pratt, we need to.
Thank you.
We need to drop to lunch, and I'm sure
Thank you, Chair.
we actually have more questions on notice. So can I just say that that concludes this session of the hearing. We will be back this afternoon. Thank you to all witnesses who've appeared and to my colleagues for their great questions. Responses to questions on notice should be provided from the ones today by the 20th of January, if possible, and ones that will follow this by mid-February. We may indeed get you back in the course of the inquiry. Thanks again for all senators to date. We're going to suspend for a lunch, and I propose that we return at 20 to 2 to give everyone a proper break, and we will shorten the sessions this afternoon. Our intention is to still complete on time. Thank you.
Thank you, Chair.
Will you please state your full names and the capacity in which you appear today? And I now invite you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
Michael Murray in a private capacity. Thank you.
Professor Jason Harris in a private capacity.
Great. Who's going to kick off?
I will.
Thank you, Professor Harris.
Thanks for the opportunity to appear before you today. The terms of reference for this inquiry cover a broad range of topics within corporate insolvency, but we suggest that they should be qualified by several issues. First, the terms do not include personal insolvency, but this is an essential issue for small business where corporate and personal finances often overlap. Second, there's very limited data on how our insolvency system operates, and this limits our capacity to properly evaluate its success or failure, including outcomes of different procedures, the cost and duration of insolvency appointments, and what benefits creditors receive, if any, from the process. It's helpful that submissions of government agencies to this committee, such as from ASIC, provide some previously undisclosed data, but it's a shame that we only see this data when there's an insolvency inquiry. We note that much of this data does support some of the arguments that we make in our written submission. Several submissions raise issues about which Mr Murray and I have expressed concern over many years, such as the role of the state, for example, by way of a government liquidator's office, the extent of unremunerated work that insolvency practitioners undertake, the poor returns to creditors from the system, the cost and complexity of the system, and problems for low and no asset businesses in accessing the system, as is evidenced by the large number of deregistered companies each year. The extent to which insolvency practitioners should continue to be the frontline investigators of insolvent companies, as stated by ASIC in its submission to this inquiry, is an important question for the integrity and efficacy of the insolvency system. In short, we say that we have an insolvency system that sets unrealistic and unachievable goals in a system that cannot afford to pay for the work that is currently required. We say that a greater role for the state is needed to address this gap. This is recognised in many other countries, including the UK, Singapore and New Zealand, with a government liquidator's office. It's been recognised here in Australia for more than 100 years in personal insolvency with the Government Bankruptcy Trustee's Office. It's important that we better understand what it is that insolvency practitioners are doing and what benefits their work produces so that we can properly evaluate what work should and shouldn't be undertaken in insolvency. There is, in our view, a compelling case for an overarching review of how insolvency law fits into our broader financial and legal system. Thank you. We're happy to take questions.
Thank you very much, Professor Harris. Can I just go to the concept of a root and branch review, which is, I think, what you were alluding to in not quite those terms?
Yes.
There's been some conjecture about whether that's required. I don't know if you've been following the evidence over the course of the day.
No, we haven't.
No, so you'll have a chance to have a look at some comments from Treasury and the Attorney Generals this morning, and we're getting a range of views that I think, in my view at this point of time, indicate that all's not well in the world, but that not everybody's seeing it in the same way.
Right.
So several submitters have suggested a root and branch review of Australia's insolvency laws in the style of the 1988 Australian Law Reform Commission, commonly known as the Harmer Review.
Yes.
Based on what you've said, could you give me your view about the value of a root and branch review, and would that be something that you would recommend?
Happy for me to take.
Thank you. I'd like to respond on that. Yes, we've heard a lot about that root and branch review. The view that we take, and which I think Professor Harris explained in the opening statement, is that we would see the insolvency laws operating within a certain system that involves certainly the liquidators and the trustees and the courts and the registries. And we're saying that ultimately within that regime within which the system operates, there's really not enough money floating around coming out of insolvent estates for the work that needs to be done properly. And that's where we're saying there needs to be a greater role of the state. So in my view, a root and branch review would start at that initial point. Now, there has been talk about what agency or other body might be enlisted to conduct that review. I'm a lawyer, so I speak from only that perspective, but I think it needs more than a legal perspective. I think it needs what I might call a systems-based perspective, or certainly a financial, economic perspective to just see how the system operates at present, and only then to see where the gaps and the issues that need attention lie. Would you then get into the solid root and branch review that I think people are talking about?
Okay. So just for clarity, in the break, I had a short discussion with the Secretariat, who provide invaluable advice to all of the inquiries that we undertake across all of the work that the Parliament does. And I think it was well observed by Mr. Bell and Dr. Turner that there could be a bit of confusion about a root and branch review. Is that just about dealing with the systemic gap between personal and corporate insolvency law and the separation there? But to do so would be sort of preempt whatever might come out of a root and branch review. Root and branch review is really right back to principles. What is the purpose of this? What principles underpin it? Why is it required? Does it deliver productivity and economic benefit to the country? Is the current historically inherited structure fit for purpose for a digital economy growing at a rapid pace in the 21st century? That's kind of a bit different from should we fuse the laws together. Is that more what you're thinking about in terms of root and branch?
If I may say what you just described there, and I must have a look at the transcript later, very well represented. I think what we're saying is required.
Okay.
You know, and that fusing of corporate and personal, that's only but one issue involved in the whole review.
Right, I think that's really helpful, and hopefully that's kind of a bit of a measuring stick for us with the committee to what does root and branch mean? It's more than do the two bits of laws need to fit together. It's is it working?
Yes.
And as I said earlier, it's not only one for the lawyers, it's one for certainly, people in Treasury I would have thought were the ones that might look most usefully at that sort of systemic, broad-based review of how what are the purposes and how it all fits together, rather than getting down, or before you get down to the detail of how the laws operate.
And it might be of interest to you to have a look at the statements of principles that were put on the record this morning by Treasury. That could be helpful for you to reflect on that and provide any response.
Chair?
Yes,
May I
please,
make a comment on that?
Professor Harris.
So one of the issues that we raised in our submission, and indeed a number of submissions have raised, is that the experience of insolvency reform in Australia really over the last 30 plus years has been, we might say, piecemeal in nature. So it's really been looking at particular issues that are raised, how do particular rules work, and can we make them work better? And we say, and many others are saying, that this is just adding to the complexity of our system, and that really what we need to do is not say, well, can we make insolvent trading work better, or can we make preferences work better? But actually, as you just said, Chair, very eloquently, how is the system working? What are the goals? What are we trying to achieve? And are we achieving them in the best way that we can? And we really haven't had that discussion since the early 1980s when the Harmer Committee was convened. So we say that the economy has fundamentally changed in that time, and that therefore this calls for a reconsideration of those fundamental goals. Because without that shared understanding of what is the system trying to achieve, is it actually achieving it, it's only once we understand that that we can then investigate the reform of particular rules, including issues such as, well, should we have one system or should we continue with two?
I'm just going to ask a couple more questions before I go to my colleagues. The ALRC has a current review on the complexity of corporations and financial services legislation underway. Have you got any insight to whether the review might address the complexity of insolvency law or not?
I have had a look at their interim reports and attended some of their functions where they've talked about the approach that they're taking. And what I quite like about that approach is that it is trying to look at the Corporations Act in its entirety and seeing how the different parts fit together. Now, they have a particular focus on Chapter 7, and that might be the most complex part of the Corporations Act. But what they're recommending in terms of particularly legislative drafting and legislative schemes going forward in corporate law, I think, would offer a lot of value to insolvency. Because at the moment, we certainly don't have that kind of hierarchical approach that they're recommending in terms of broad-based principles, thinking where the rules fit in, having an independent advisory committee that is basically looking for out-of-date provisions, anomalies, redundant provisions. So that would be very beneficial in insolvency because, a number of our rules date back to the 16th century.
Mr. Murray.
I might just say something on that just by way of qualification of my colleagues' comments, and I agree it's a very thorough and useful exercise. It's nevertheless a legal exercise, and I suppose what I'm saying, as I said earlier, we need to look at the law, but maybe before we look at the law, we need to look at the system within which the laws operate, and that is not necessarily only a legal exercise.
The whole ecosystem really is what we're talking about.
Yes.
Yeah. You've mentioned a couple of things about the unfunded nature of public insolvency work. If I can just take it right back to the bare bones, historically we have had put on the record this morning about the benefit of finalising a company and allowing people to move on, and it's been said a few times. But Australians are voting with their feet. They're not finalising the closure of a company. They're just going, well, that was good, it's finished. It might be a single event that they were coordinating. It could be a 25-year-old business and they just decide to stop. Somebody might have a heart attack and go, that's the end of that, I'm not going back. I'll just take what I've got and run. The end, walk away. If they pay their bills, good. If they don't, some people just go, well, that's the cost of doing business. They just write down the debt. But the majority of Australian businesses are having absolutely nothing to do with the law in Australia around insolvency, are they?
No.
And those that do engage find themselves not with a business advisor to basically take a debtor in possession role and restand the business up, but more likely, if they've had a trigger by the banking industry or the financial services industry more broadly, or at the tax office, the Australian Tax Office, they will engage then with highly skilled, very caring professionals in the insolvency industry who show up at the business's door. They're not business specialists, they're insolvency specialists, and processes kick in. Now, if it's a larger corporate entity, or it's got a significant amount of resources, like one of the examples from the Ombudsman, $1 million, 60,000 was the quote to wind the company up. It ended up being $500,000 worth in costs for the insolvency practitioner before any creditors saw any of the remaining $500,000. That's the ecosystem we're talking about, and it's operating with a current set of laws. So I'm asking you to sort of give me the scale. Is it $47 million a year that it's costing those insolvency practitioners to deal with the companies that they necessarily get caught up with? And is that creating a market failure and a distortion in the market where there's exploitation and, basically fleecing of a target that could be seen as having the capacity to pay? That's the shape of what I think I'm seeing. I'm interested in your expertise in that area.
Can I start on this one? Yeah. So, Senator, I would agree with much of what you've said just there. I do think that we have a case of market failure here, in that we have a profession who is expected to take on jobs in which perhaps 40% of those jobs they can expect to not get paid. So I would say that is a market failure, and that insolvency practitioners are doing a lot of unfunded work or underfunded work. Secondly,
do you know of any industry in continuation in Australia where 40% of the work you do as a business model you are unpaid for?
No.
And that has been pointed out also in England, where I think it's been said that the insolvency profession in there is the one profession where they are expected to work for no fee to a certain extent.
Chair, just on that. So are you seeing a shortfall in insolvency practitioners? Are there less people coming into the field?
There certainly has been a decline in the numbers of corporate insolvency practitioners over the last few years, whether that's because of the amount of unfunded work, or rather whether that's because of perhaps increasing regulation by way of the Insolvency Law Review Act, which came in 2017, and or the introduction of the ASIC's user pays model, where insolvency practitioners are basically charged not only annual fees, but are charged on a per appointment basis, and then particular forms that have to be lodged, they're charged again for those forms as a user pays model.
So I'm just trying to establish that, there's all this work that's not being paid for, and yet there seems to be a lot of insolvency practitioners to me.
Could I just respond on that? And
of course.
I take your point, and I've understood that to be the nature of your query. They nevertheless make money, and again, I'm not necessarily the person to speak to about this because I only have my legal perspective of it, but from what I understand, any industry that has a 40% write-off or whatever it might be has to accommodate that some way. And you accommodate that through raising your charge-out rates on estates that do have money in them to pay. Now, in many industries, I suppose there's always a write-off or a shrinkage or whatever it might be, and you factor that into your pricing. When you've got such a large write-off as we do seem to have in insolvency, there's quite a factoring in of that loss into your charge-out rates, and that's one way I think the system is funded, and that's one way that practitioners certainly earn probably a good living out of it.
We even have judges, for example, referring to the well-known principle of swings and roundabouts, that you might charge less on low-value jobs, you charge more on high-value jobs. And we would say, and I think we do say in our written submission, that is a tax on those high-value jobs.
I'm just trying to think of another business that doesn't have similar problems. I know plenty of small businesses that will have a higher rate for people who have the ability to pay versus ones that don't, whether that is in the health profession or anywhere else. Now, I understand the point you make. Sorry, I've got the call.
No, keep going. It's all interesting.
I mean, the proposition that the state pays, why should the taxpayer pay for someone else's failures? Now, I understand the concept around changing the legislation and doing a review and tightening that up and making that far more amenable to getting outcomes faster. But why should the taxpayer front?
Could I just raise a preliminary point there? And one thing we've said is lack of data, and Professor Harris has referred to the fact that we're grateful for the data that ASIC has now produced. And I think it shows, and I won't be quoted on this because I just don't remember the details, but ASIC did provide quite a large percentage of estates that in fact are what we call unfunded. But from my perspective in particular, I've been working in insolvency for a long time. We need more transparency in relation to this. It's sort of never been an issue much discussed in the past as far as I'm concerned. And Professor Harris and I have been raising this in our textbook for quite some time, and we're pleased to see that it's sort of coming a bit more to the fore. Not with a view to being critical about the profession in terms of the way they charge, but we just need to know how it all happens, how it all, as you say, how they make a living out of that discipline with such a large amount of write-off.
Can I ask a question that follows on from what you've just said? Because we don't want to increase costs to the public purse. But the question that sort of lingers is, why transfer the cost to businesses that can pay for the provision of services that are not wanted and not delivering what I can discern as a significant positive outcome for the public or private good by compliance with the paperwork that's necessary once you get engaged? Because is that what happens? As soon as you get engaged as an insolvency practitioner, if you want to keep your licence and your professional qualification, you have to follow the law, and ASIC is really significantly dictating what information has to be acquired.
Yes. And professional bodies like ARETA, who have very extensive expectations in terms of their code of professional conduct.
And that code of professional conduct is lined up with international standards, is it? Or is it national standards?
I don't know that I
We'll
can
find out
answer
about that. Okay.
Yeah, that might be a question for ARETA.
And the trigger for an insolvency practitioner to be engaged, can somebody come in and just have a look and then walk away? Or once they've engaged, they're required then to start the process and provide the information? What happens at that point?
There's certainly no requirement on an individual insolvency practitioner to take a job. But, I mean, depending on the size of the matter, sometimes there is what's commonly referred to as a beauty parade, where different firms are basically pitching for the work, and then the directors will select which firm they want to go with and which practitioners they want to go with. If it's even with a court appointment, there's no obligation on the practitioner to consent to it. So they are consenting to jobs usually before they have full information. So a common example is the directors might say, oh, look, you know, this is a circumstance. We've got X value in assets. Oh, we've got, you know, the ATO over here that we owe a lot of money to, or in dispute with this particular creditor. But there's not really many problems. We just want to deal with this, you know, reasonably efficiently. And then once the practitioner takes the appointment, they get access to all the books and records, and they can see actually that there's a lot of disputes involving this company, and it also turns out the company's been acting as a trustee. It hasn't been properly complying with environmental regulations, with work health and safety regulations. And so what might seem at the start to be a relatively simple job, well, we're here to put a plan with the ATO, see if it works. Then all of a sudden they're involved in litigation, and it's all the trust.
Can they turn around at any point and walk away? Or once they've seen that, are they required to report?
Very difficult for them to remove themselves at that point.
Why?
So if it's a court appointment, for example, they actually have to get released from the court.
Right.
If it's a voluntary, well, actually, why is it difficult for them? I mean,
I think as a matter of practice and culture, to give back an estate because it's too hard or involves too much work, I think would be not done.
Just as a cultural practice.
Yes.
What about if there's no assets? They find out there's no assets.
The expectation would be that they would finish the job.
Right.
They'd give
so
a
it's an
report to
assetless company, and they have to get together a report and they have to give it to ASIC.
Yep.
And they have to do that in 100% of cases if they take it on. Once they've started the job, they will continue.
That's the expectation, yes.
Right. So there's no risk weighting in terms of what is required by ASIC, whether it's an assetless or a highly asset-rich entity that's being investigated.
Not that I'm aware of. I mean, the obligations are the obligations in terms of preliminary investigations, filling out the regular reports, so the annual reports, the end of administration reports, liaising with creditors, reporting on potential offences, Those things.
So this aligns with what I understood I heard when I went to an insolvency practitioner forum. And it does go to that question of why create such a drag on resources that a cost has to be borne by another entity that could be, investing in the economy for productivity benefit.
Actually by creditors.
Yeah, and by credit. Yeah, exactly. So there's a range of possibilities that money could be better spent on. So
Paying their bills.
So bring it right back to TORS for me. Most Australian businesses that shut up shop have nothing to do with insolvency.
Yes.
What's the benefit of cleaning up your affairs and going through the process of insolvency? What's the public and the private good of that? Because that's the part I'm really starting to question. I understand the principle of it, but in terms of its practical machinations at this point of time, I don't understand that.
I think there's a range of factors that influence whether business people engage with the insolvency system. So in some circumstances, they might have no choice because it might be a creditor enforcement action and a court liquidation.
Yep.
In some cases, they might engage with the insolvency system because they perceive that there will be a benefit for them and perhaps for the business. For example, by entering voluntary administration, getting the benefit of a moratorium to try and do a deal. And maybe the deal doesn't work out and they end up in liquidation anyway. For some business people, and perhaps from some business people from particular communities, that there is very much a social obligation that they have to deal with their debt problems, that walking away would not be acceptable in those communities. There may well be other business reasons as to why they might want to do that. Perhaps they've engaged with their bank, but the bank will only deal with them if they're actually doing it through a formal insolvency process. I've heard from practitioners who say that it can be exceedingly difficult to deal with the tax office to try and resolve a dispute unless you're doing so through external administration. And there's a bit of a disconnect there where a good commercial deal can be done that will provide a good outcome, but the tax office will not compromise the debt unless you're doing so through a compulsory process. So you effectively have to spend money in order to get a concession out of the tax office.
Right. Okay, perhaps you might want to write a few questions for us to get to the taxation department on those matters, Professor Harris.
We'd be happy
I've
to.
got many more questions, but I'll go to
Could
my
I just add-
learned colleagues.
Oh, Chair,
Mr.
sorry,
Murray.
beg your pardon. Could I just add one comment, partly in response to Mr. Pitt's question?
Yep.
And I often find good parallels to be drawn with personal insolvency, where of course we do have a government trustee in bankruptcy. So if you are an individual debtor and you want to go bankrupt, you can go to a government service for free, so to speak, and we wouldn't have it otherwise. In other words, we wouldn't privatise or leave hanging those debtors who might have had to pay a trustee to go bankrupt. We wouldn't leave those debtors unable to go bankrupt in that sphere, in the personal insolvency sphere. And I suppose there's not that much difference between all of these companies in the corporate sphere, where we say there should be at least an opportunity for a director of an insolvent company to have their company wound up, even if they don't have the funds in order to enable them to do that. Now,
Because what good does that lead to?
well, this brings in the more elevated purposes of insolvency, that if there is an insolvent entity around in existence, and there may be unpaid employees, there may be unpaid creditors, there should be at least some finalisation or some, ending of their insolvent state for the benefit of those that have been dealing with them, for the better purposes of, corporate governance and corporate dealings. I mean,
So there's a technical dimension to that. But if there's no money and people get nothing,
yeah.
What's in it? What's in it for the public good?
Well, if I may mention, and I won't go to the page of our submission unless you need me to, but I've quoted from some UNCITRAL, the United Nations international trade body, which explains this in two ways, both positive and negative. If you allow all assetless companies simply to disappear because there doesn't seem to be much point, for one thing, in terms of what you might call corporate governance or corporate morality, how many of those might be assetless by design? In other words, the directors have just depleted the assets, moved on to another company, they've been phoenixed, or there might be some other untoward conduct. So there should be at least some scrutiny of those is one purpose. But then the positive purpose, and this is what I was just trying to explain there, is that if I'm a director of a company, I'm a compliant, law-abiding director, and I've had some hard times and my company has become insolvent, I myself don't have the funds to go to a liquidator to pay $10,000 or $15,000 to get my company wound up, but I nevertheless want that to happen. What UNCITRAL is saying is there should be some process, government funded or however, whereby that company can nevertheless be, its insolvent circumstances can be resolved through some formal process, at least to give some closure to those that have been dealing with it. The employees know where they stand, and for the sake of what it calls, better corporate governance, I suppose, is one way of putting it. Transparency.
Thank you. More questions from me on notice. We're going to run out of time. Mr. Pitt and then Senator Scarr.
Last one, because I'm sure Senator Scarr's got a long list. And this is a little bit off track. Director ID, how much difference do you think that will make, particularly around phoenixing?
I think a lot, in the sense that it's been around for quite a while as being a necessary issue, if only to know in corporate insolvency with whom one is dealing. I think the government is at the moment consulting on taking that transparency further in relation to trust arrangements, but that's another thing altogether. But certainly director ID, I think, is very important. One of our academic colleagues, Professor Helen Anderson, was very much at the forefront of explaining, certainly in the context of Phoenix activity, how important director identity numbers are to managing Phoenix misconduct.
It won't stop the straw director problem.
No.
But
because you just pay somebody else. Right?
Yes. But it will help.
Not for the record, not that I'm suggesting that, Chair.
We've got a business model there.
I have any number of.
Senator Scarr.
Thank you. I'll start on my long list of questions Mr. Pitt referred to. Good to see you again, gentlemen, and thank you for your submission and all the work you're doing in this space. It's greatly appreciated, and I think you've started to move the dial a bit. I refer to Treasury submission. Have you had a chance to have a look at Treasury submission yet?
I had a brief look at it, but if you might jog my memory.
Well, I just want to talk about the small business restructuring numbers and the so-called simplified liquidation numbers. So the small business restructuring numbers, and I was, of course, sitting in the Senate when this legislation came through, and the expectation was that it would provide a really valuable opportunity for small businesses to restructure without going down the insolvency path. And yet, when we look at the figures from March 21 through to September 22 quarters, there's only been 165 small businesses that have accessed the mechanism, albeit that in the last quarter there was an increase from 40 to 83. So first on the small business restructuring mechanism that was introduced, what do you make of those numbers, and what's that telling us about the efficacy or the simplicity of the system, and how can we improve this?
Yes. Thank you for your question. It's something I followed very closely. The small business restructuring regime is not fit for purpose. It fits a very limited purpose, and that's evidenced by the fact that there have been, I think, almost 200 appointments now. But that pales in comparison to, for example, when voluntary administration started in 1993. And in our written submission, we provide some statistics on that as a point of comparison. The small business restructuring regime is far too complicated, and the entry points in order to qualify for it are too difficult. As one example, you have to have all of your outstanding employee entitlements paid in full. That's very difficult for many small businesses, and so that automatically excludes them. Now, I was part of the Law Council's submission when those reforms were being proposed, and one of the points that we made was, why can't you make up employee entitlements in the restructuring plan? So if you have fallen a little bit behind in the super, for example, and you're using a restructuring plan to try and fix the business, why can't you make up the shortfall in the plan, as long as the shortfall is in fact made up? But that's not possible under the current regime. So
And just on that point, it
Yes.
could well be that a small business has some sort of repayment plan that it's entered into with the ATO
Yes.
with respect to repaying those outstanding, in particular superannuation contributions over time. But even if they have that sort of payment plan, if you like, with the ATO, they're still prevented from going down this path.
Because
Is
there's
that
still
correct?
an outstanding amount. It doesn't remove the debt. It's still outstanding. So it's too inflexible. Even if you get into the regime, the law is complete overkill. It's dozens and dozens of sections, more than 100 pages of legislation for a procedure in terms of restructuring before you get into the plan that is designed to go for 3 weeks. More than 100 pages of legislation for a 3-week procedure.
Okay, thank you. If we can move on to the simplified liquidation process, I note that there's only been 59 uses of the simplified liquidation process, which is a third of the small business restructuring processes. What do you say about the simplified liquidation process? Has it been simplified so much that it's impossible to use?
No, the problem is it's not simplified enough. That it's almost exactly what you have to do in a full creditors voluntary liquidation, but the timeframes are very tight, and there's not enough benefit to using the simplified restructuring. As an example, again with the entry points, there's various things that need to be certified as to the qualifications for the company to be eligible to use the process. And those things can be very difficult to certify in the timeframes that are available.
Okay. So to some extent, in terms of both these processes, we've had the opportunity to see how they're working in practice for over 12 months, nearly 24 months now.
Yes.
So in your view, neither of them are fit for purpose, is that correct?
Correct.
Do you think that they can be substantially amended, or are there tweaks that can be made that can make them fit for purpose? Or
Yes. I wrote a PhD thesis on that.
Oh, did you?
Which recommended that there are about a dozen
Treasury.
about a dozen changes to the SBR regime that I think would make it work better.
Okay.
And fit for purpose.
Okay. Could you maybe give us, and apologies if it's, I have read your paper, but if you can draw out some particular proposals for reform, maybe with respect to both processes, and even if you've had an opportunity perhaps to respond to some of the issues raised by RETA in this respect, the Law Council and also the Australian Small Business Ombudsman.
So is that taking a question on notice? And
if you could take that on notice,
yes,
and maybe if you could just give us a formal response to some of their suggestions, I think that would be useful.
We'd be happy to.
Could I just ask, Chair, if I may, or responding to that, we're happy to take questions on notice, and do we take that from the transcript, or is there a separate process?
The Secretariat will be in touch.
Thank you very much. Thank you.
Okay, so I have got some other detailed questions on the basis of your submissions, and I'm probably going to try and corral my questions into those areas where we haven't touched upon issues yet. Page 6 of your submission, you talk about a so-called regulatory blind spot of pre-insolvency advisors.
Yes.
Could you expand on what the issue is in that respect?
Certainly. So one problem, particularly for small business, is that they often don't have access to high quality advice and information. And so if they don't know who to turn to, then when perhaps the ATO takes an enforcement action, or another creditor takes enforcement action, what do? They go to Google. And the sort of firms that will then advertise on Google are some of the sorts of firms that will say, well, we can help you to avoid paying tax, engage our services. So that's what AFSA, for example, calls untrustworthy advisors. So the concern that we have is that is largely an unregulated space. So if, for example,
So who are these people? What are they?
Accountants? Are they professionals?
Some of them might be accountants, some of them might be lawyers, Some, we've heard, are struck off insolvency practitioners who refashion themselves as pre-insolvency advisors. You know,
Okay.
I understand the system. I can show you how to beat the system, basically.
Okay, so they can really, I mean, presumably if a small business, medium-sized business relies on someone in that respect, they can actually dig a deeper hole for themselves and
Yes.
and trip up on the various laws.
Correct.
So what's the remedy to that? How, as in our position, what do you think we should be?
That, they could also asset strip effectively those entities and not do damage to the business. And perhaps that's why they get engaged. Is that a possibility?
That's also a possibility, yes.
Okay, off you go. Thank you.
Yeah, sure. So what's the remedy to that?
So some form of licensing regime would assist there. And for example, as one example, if we take the safe harbour provisions that deal with insolvent trading, there's virtually no guidance about who an appropriately qualified entity is. So if we had more regulatory guidance, perhaps from ASIC, here are the sorts of qualifications you need to be a safe harbour master, that would be one way, not the only way, and it wouldn't cover the whole population, but that would be one way to try and reach that population.
Okay, so potentially a condition of taking advantage of the safe harbour protections would be
Yes.
that you seek advice from an appropriately qualified advisor,
Yes.
namely A, B, C, D or E.
Correct. Another way would be if we implemented what the Small Business Ombudsman recommended several years ago in terms of the government offering a small business viability review voucher. You could implement that in a way that would be, well, you have to go to, a list of accredited advisors.
Professor Harris, I really struggle with that, and I philosophically, people are free in this country to set up a small business, and I would expect that the onus is then on them.
Yes.
In order to determine, work up a business plan, make their own assessment with respect to cash flow, consider the risks, consider any risk management plan they need to have in place to mitigate those risks, and then away you go. Good luck. I hope you succeed. I hope you employ a lot of people and you're very successful. Playing the devil's advocate, why is it that the taxpayers of Australia should fund a voucher for that small business to be able to get advice?
So, Senator, I'd offer 2 points in response. The first one is an ounce of prevention is better than a pound of cure. And what the insolvency profession has been telling us for many years is that particularly small businesses leave it far too late before they seek help. So if we had a mechanism to try and encourage small business people to go out and get some hopefully good quality advice before they get to the terminal point of insolvency, then we might see more businesses saved. So that's one point. The second point that I would raise is that leaving it to the last minute and falling over into insolvency does have a real cost on the economy. So we're already paying for the result of that in terms of business failure, debts that are not being paid, employees that are not being paid, taxes that are not being paid. So again, if we could intervene earlier, if we could provide some assistance earlier, then maybe some of these businesses wouldn't fail in the first place.
But at the same by the same token, Mr. Murray, I'm interested in your views on this. How big would my voucher have to be able to tap into your services?
Very big.
Do you accept vouchers?
I'll respond in another respect shortly, but I think what is being talked about is a $5,000 amount, or that, as I recall, I shouldn't be speaking on behalf of the Ombudsman, but I think that was what was being discussed.
Sorry, how much?
5,000.
5,000, okay. All right.
Could I just make one point, if I may, Senator, just quickly? The phrase pre-insolvency advisor to me is a bit unfortunate because it's got a pejorative term in our industry. Except if I was on the brink or worried about going insolvent, I would want pre-insolvency advice very readily. And there's a lot of very, qualified people and well-meaning people who would give you that pre-insolvency advice. So I think to use the term pre-insolvency advisor as if it's a pejorative term overall is rather unfortunate.
Oh, I wasn't.
No,
I'm not
I know you
clarifying.
weren't, but it sort of comes across that way in certainly in this industry.
Well, it's in your submission, that's why.
Maybe it
business
needs to be
people know the
called
difference, though?
Prevent Insolvency Advisor.
That's a good term.
That might be a little
Well, it's
more
really a business
of interest.
advisor, isn't it?
Yeah.
It's,
Well,
it's
it
more
is.
because ultimately you're trying to give advice to the business as to how it
And
can be successful.
in another forum, we might have been talking about another concept of, in health, for example. You go along and get a regular health checkup, or a lot of us do. And small business might well take on that culture of having a regular health checkup in order to forestall what might be coming. Now, you might call that regular health checkup or regular insolvency checkup a pre-insolvency advice, and a very valid one indeed. I'd like to think your average suburban or city accountant could provide that, but from what I hear, it tends to be more specialised than what accountants are able to offer. Maybe lawyers as well.
There are a lot of those services out there already, though. I mean, for small business, there's any number of small business advisors across the country that people are able to access for either a subsidised amount or for free.
I think what Professor Harris is talking about, it's sometimes a bit difficult to distinguish the good from the bad. And that's where I think we're saying a licensing arrangement might assist.
Yeah, licensing arrangements always add cost and complexity. So, sorry, Senator Scarr.
Two more questions. And the first one, I'll be very impressed. Mr. Murray, if you can explain to me in simple terms what the issue is with respect to insolvencies in the trust space. So you have a corporate trustee, potentially you've got a trading trust, a corporate trustee, you've got trust assets. What's the issue at the moment in terms of making that all work efficiently and effectively in the insolvency space?
Did you want to answer that?
Yeah.
Might I pass to Professor Harris?
You can pass to him.
Who's a whiz-bang on trust law.
Okay, that's right.
I would say the most pressing issue in that space is the fact that the current law requires an insolvency practitioner who's been appointed over a company and then realises that that company has been acting as trustee over a trust fund, in most cases can't deal with the trust assets. They have to go off to court and get appointed as a receiver for sale so that they can deal with those trust assets. So that's an unnecessary cost on the system. And what we know is a number of insolvency practitioners might be appointed over a company. There's, say, $30,000 worth of assets in the trust fund. All of that is going to be covered by their right of indemnity. So they are entitled to that amount. And yet they still have to go off to court and spend $15,000 or $20,000 to confirm that.
So is the reason for that added protection to protect the beneficiaries? Because you've got the trustee, right, who has the legal title with respect to the assets, but then you've got the beneficiaries who have got the equitable interest in the trust assets. So you've got this conflict between the legal interests and the beneficial interests. Is that the reason why the process at the moment requires the application to court?
Basically, yes. It comes down to what is the property of the company and also the effective trust appointment instruments, which will often say that as soon as the trustee goes into insolvency, they're automatically removed from their position as trustee, which then means that they're only holding the assets as a bare trustee. So they actually can't do anything with them.
But the reason for that is to actually protect the beneficiaries, isn't it?
Notionally, yes. I mean, that's why the rule exists. But in all of these cases, we're talking about circumstances where the trustee company's right of indemnity is available and that in most cases will exhaust the funds regardless. So the beneficiaries are not going to get anything out of this on either outcome.
Okay, I understand. So that should be replaced ideally with some sort of administrative process. Is that correct from your perspective?
If we could amend the Corporations Act so that property of the company specifically includes property that's held on trust where the right of indemnity is open, and that's what the Harmer report recommended almost 4 years ago.
Where the right of indemnity is open.
Yes.
That's the key. Okay, got it. Excellent. Thank you for that. And then my last question is in relation to the ATO, and our friends from the ATO are coming along after you. And one of the things I've been considering is there's this tension between the fact that in the past the ATO was given preference in terms of repayment of debts, in terms of the cascading preference. That's been removed, but there are still practical measures the ATO can take and powers it has, which provide that it has this armoury, I think someone referred to it as, which almost gives them a preferential position. So there's this conflict between the reform that was made in the past to say the ATO should not be in a preferential position, but then there's all of these powers and this ATO armoury, which in effect can lead to them having a preferential position. Is that correct?
Well, essentially, and this happened, nearly 30 years ago when the Harmer reforms came in. Yes, the priority of the tax office in insolvencies was removed, but what was given in its place was broadly a right of claim directly against the directors of the particular company that was in default of its tax obligations. And that's where we have the director penalty notices, about which you may have heard, rights of garnishee and other such rights that, I suppose you might say in a de facto sense, give the ATO a priority, but not a formal priority such as existed in the past.
And is it your submission that some or all of those de facto, well, all of those elements, all of those powers that the ATO has some consideration should be given to their removal or amendment in certain cases to remove that de facto preference?
I think we would say that's exactly the sort of thing that a broad written branch review would look at, that what should be the role of the ATO? Are they just a creditor?
Yeah.
If they are, then why do they have all these other powers? But we certainly recognise it's also Commonwealth revenue that we're talking about, and that's quite important too. But that, it is quite a complex issue. What insolvency practitioners tell us is that they can find it very frustrating dealing with the ATO because often they can't seem to get a commercial outcome. So they tell us that often they're not acting as a commercial creditor. Sometimes they take very inconsistent positions when they're dealing with different tax offices. They find it exceedingly difficult to actually speak to people at the tax office. Often it's just a hotline that they're dealing with. And so insolvency practitioners, they're trying to salvage the business. It's that idea of the melting ice cube. They have to act quickly, but the way that the tax office operates, they can't act quickly. And that then leads to poorer outcomes.
They actually put the hairdryer on is what happens.
Right.
So, thank you for that evocative analogy, Mr. Hick. The one submission I've seen, I can't remember whose it was, it might have been a reader, said that the ATO should have an obligation to act as a model creditor.
Yes.
Would you agree with that submission?
I would.
Do we know what a model creditor is?
Did they say that, or a model litigant?
No, model creditor. They actually used
right.
the phrase model creditor. And the example I think they gave was the ATO should actually attend creditors' meetings, should actually do the things which a responsible creditor should do to assist the process moving along. Do you have a view with respect to that, Mr. Murray?
Yeah, I agree with that.
Yeah, it depends on how that's defined. I'm sorry, that's a legal answer, I know, but I mean, they've got to be commercial. We say that a lot of creditors don't take part in insolvency because there's no commercial outcome for them. If we're putting an overlay on the obligations of the Australian Taxation Office, it would be a public interest overlay as creditor, which may be what a reader is referring to. And having been a former Commonwealth public sector employee myself, I like the idea of public interest overlays, but to what extent it would then impact on their necessary commercial approach, you'd have to give that serious consideration.
No, well, I'm going to put it to the ATO. But Professor Harris, you have some sympathy for that view.
Absolutely.
Okay.
So what insolvency practitioners tell me is that they get frustrated with the ATO because it's just not clear that they can make some assumptions about how a bank is going to respond to things or how a landlord is going to respond to things. They understand the motivating factors. Okay. But, for example, during my doctoral work, some insolvency practitioners said, what is the ATO? Is it a commercial creditor or is it a policeman? Because sometimes it seems to be both in the same matter. So we're getting inconsistent messages from them.
Okay. All right. Thank you very much. Thank you, Chair.
Thank you. I believe Senator Pratt has a couple of questions. No.
Yes, I just wanted to follow up on the complexity of trust structures. Do we need better data around, for example, directors who have had a poor record, but with previous insolvencies, but indulge themselves in very complex company structures and trusts when they set up new companies, what can we be doing better in terms of looking at the record of directors? Is looking at the record of directors enough, or do we need to work out how we dive deeper into what's going on in some of these company structures? I asked this question largely in the context of the inquiry I participated in relation to the collapse of the Sterling Income Trust, and reading the insolvency reports that really didn't say much, because they said they couldn't because of the complex nature of the company structure. And I couldn't really work out what assets had gone where, although the insolvency practitioners seemed confident that there weren't any assets hidden anywhere from creditors or investors. But it didn't seem pretty definitive to me, because they pretty much said they hadn't had the capacity to look.
Mm-hmm. Can I start? Yeah.
Thank you.
Thanks very much, Senator, for the question. I would say transparency is a really important goal in this space, and one problem with trusts is that they're not transparent at all. So there are ways that we might say more sophisticated creditors can work out whether there is a trust involved in the arrangement that they're looking at entering into. But most trade creditors, for example, and that's not to say they're unsophisticated, but many trade creditors would not do that. And so they think they're dealing with the person that they're speaking to. Maybe they assume, well, it's a company, so I'm dealing with the company. What they don't realise is all the assets of the company aren't really the company's in a beneficial sense, because they're held on trust structures. So having some form of transparency mechanism so that creditors, before they enter into those dealings, can actually work out that it's a trust that they're dealing with. Now, of course, a trust is not a separate legal entity, but rather that the person that they're dealing with is involved as a trustee in some capacity. So whether that's requiring a register of trusts, or maybe a register of trading trusts, for example, so that before you sign up to give the credit, you can do a search and say, oh, hang on, that person's a trustee, or that company's a trustee.
Senator Pratt, you're on mute.
Thank you. My eyes have already glazed over in terms of my comprehension of the complexity of that. And it does really concern me. How would you provide that transparency? And surely people are going to go, oh,
too hard.
This is a trust, but I don't really know what that means. You know, how educated do we really need to be? And surely the answer is how we go about establishing greater transparency over trusts in general.
It's an excellent question. It is also, unfortunately, a complex question. So having some form of register where you have to register if you're engaging in a trust relationship, whether that's just trading trusts or commercial trusts or private trusts, however we want to set that would go a long way, because it would allow people to at least be aware. Perhaps we could have a provision in legislation that requires you to just actively disclose, aside from just being on a register. But the question that you're asking, I think, is really about complexity of business structures. I think that's very difficult to legislate for or against, aside from saying, well, you need to be transparent. You know, are you dealing through a company? Are you dealing through a trust? I'm not sure that we can say.
Well, naive investors in the case of Sterling were pretty much falsely led to believe that investing in a trust was a good thing, because it meant their assets were held in trust in a very traditional sense. And I'm inclined to think that there are a great many people who would think along those fairly simple lines. I know we can't mitigate against complexity, but I guess I'm trying to unpack what answers we might be able to provide here.
Yes, and maybe if I could suggest that we might draw a distinction between, say, general commercial creditors, trade creditors, who are dealing with the business that involves a trust in some capacity, versus investors who are investing in some sort of structure where assets are held on trust. Now, those types of custodial arrangements are very, very common in lots of different types of investment structures. So I'm not sure that we want to necessarily say, well,
holding assets on trust in these arrangements are necessarily a bad thing, as long as it is transparently explained to people. And maybe that's more a securities regulation, investor protection provision in terms of, ASIC, for example, sorry to jump around a little bit, but ASIC, a number of years ago, after the collapse of Banksia Securities, for example, in Victoria, they changed a lot of their regulatory guidance around how unlisted debentures were being marketed to retail investors. So that's the sort of thing where perhaps greater regulatory guidance could assist, perhaps by doing things like simple fact sheets that could be provided to people. Well, do you know you're not investing in a company, you're not like a shareholder. In fact, you're investing in something that's a trust structure and that has very different obligations. I would also just note for the committee that Dr Nunzio D'Angelo, who's head of banking at Norton Rose Fulbright, he did his PhD on the commercial use of trusts, and I know he's put in a submission. He's been writing for a long time about the need for investors to understand that difference between investing in a company and investing in a trust structure.
We're going to have to wind up. Senator Pratt.
No, I think that captures it. I guess I'm just trying to work out what we need to take away in the context of this inquiry on insolvency around where those issues need to go. You've touched on them briefly in terms of consumer education. Is there anything at a regulatory level you think we can do?
Well, I think the answer is disclosure, because people can vote with their feet. To coin a phrase from a well-known politician many years ago, if you don't understand it, don't vote for it. If you don't understand it, don't invest in it. So having better quality information about what it is that people are dealing with and what it is that people are investing with, I think is part of the answer.
I guess,
Okay,
of course,
thank you.
over the years we've heard evidence that the longer the PDO, the more trust people place in the person who puts it in front of them and the less likely they are to read it. So it sort of has a perverse impact on people's sense of trust. And the other challenge is the language. Like if you say a register of trust or even if actively disclosing trust, it would need to have that means that if...
Yes.
To lay out all the, the negative consequences so people could actually understand it, because there's so much there that people simply have never had experience of understanding. So there's a literacy dimension here that's critical as well.
And I would just like to say that the ATO, I think, has actually done a pretty good job of explaining different types of business structures. They've got a lot of videos on their website. If you're setting up a business, here's what it means to operate a trust, here's what it means to sole trader. So, there are ways to do this.
Yeah, and now that we have a more visually literate population and a less literally literate, perhaps that's one of the indicators that might need to be changed if there was to be a root and branch review. I've got a number of questions that we're just not going to get to that will come on notice to you. There's some from today. We would hope, if possible, to get a response by about the 20th of June to those, but the ones that are coming, 20th of January, sorry, for those ones. However, some additional questions may follow, and we'd look perhaps for the middle of February to those ones just to spread them out a little. So questions about official receiver, personal and corporate liabilities and the differences between those, the burden that's shared there, and also the responsibility. You indicate a shift of the personal insolvency from Attorney General to Treasury, the rationale for that. Okay.
Happy to respond to those.
Yes.
Wonderful. Thank you very much, Professor Harris and Mr Murray, for joining us today.
Thanks for the opportunity.
I now welcome representatives from the Australian Tax Office. When you're ready. Oh. Yes. That's okay. And representatives of the Australian Financial Security Authority. You can all come forward together. Thank you. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to the Senate committees has been provided to you.
Yes.
Thank you. For the Hansard record, will you please state your full name and the capacity in which you appear today? We'll start with Mr Montanez.
George Montanez. I'm an Assistant Commissioner responsible for Phoenix within the ATO, and I also chair the Phoenix Task Force Steering Committee.
Great.
Hi, Gillian Kitto, Assistant Commissioner in the Australian Taxation Office, Lodge and Pay Enforcement Branch.
Gary Busby, Senior Insolvency Administrator, Australian Taxation Office, Lodge and Pay Enforcement Branch.
Gavin McCosker, Deputy Chief Executive at the Australian Financial Security Authority.
Paul Shaw, National Manager Enforcement and Practitioner Supervision at the Australian Financial Security Authority.
Elise Harold-Woods, National Manager Government Business at the Australian Financial Security Authority.
Great, thank you. And having taken a bit of advice from colleagues, and we're running a little late, I'm asking if it's possible for you to stay with us until about 3:50. Is that possible?
Certainly.
Thank you very much. So that'll give senators an indication of time. We'll shorten Mr Whittaker's appearance so that we do conclude on time for people to make their transport arrangements. I guess it's time to invite you now to make an opening statement if you wish to do so.
Thank you, Chair.
Ms Kitto for the ATO.
Yes, please.
Thank
and
you.
Would you like me to bring a copy?
If you have a copy for tabling, that would be very helpful. And I'm sure Mr Bell will get copies to us as soon as he can. Thank you.
Thank you, Chair. And I'd like to thank the committee for the opportunity to provide some context on the ATO's role in insolvency. The Commissioner of Taxation plays two roles in the insolvency system. The first role is the actions we take as administrator of the tax and super systems to recover debts up to the point of insolvency. And the second is our post-insolvency involvement as a major creditor. As administrator of the tax and super systems, our approach to debt recovery and insolvency is always measured and cautious. Our overarching message is for businesses to please engage with us. The earlier the better, so we can work together on tailored solutions. However, for those who do not engage or respond, we may take firmer actions, such as garnishes or director penalty notices. Taking wind-up action is always a last resort. This is reserved for those companies who refuse to engage or who engage in high-risk behaviours such as fraud or evasion or illegal Phoenix behaviour. Wind-up actions initiated by the ATO have historically been low, around 1 in 6 or 15% in pre-COVID years. During the pandemic, we paused most of our debt recovery actions and initiated fewer than 1% of all corporate insolvencies. While the ATO is a minor initiator of insolvencies, we are a party to many. And once a company enters insolvency, the ATO's role largely shifts from administrator of the tax and super systems to that of an unsecured creditor. Historically, the ATO has been a creditor in 74% or around 3 in 4 company insolvencies. We are often the largest creditor, and sometimes we are the only creditor. We do anticipate that the number of insolvencies will increase over the coming years back to pre-COVID levels. We recognise that the ATO's resumption of firmer and stronger actions since November 2021 will be one driver, and we will continue to take a measured and cautious approach. We remain committed to supporting viable businesses to succeed by providing support wherever possible, assisting those who are not viable to exit with dignity, and ensuring integrity in the tax and super systems by addressing unfair financial advantage and high-risk behaviours. Thank you.
Thank you very much, Ms Kitto. And do we have an opening statement?
Yes, Senator. Thank you,
by
Gavin,
ASPA.
from Gavin McCosker.
Thank you, Mr McCosker.
So the Australian Financial Security Authority is an executive agency of the Attorney-General's portfolio. AFSA is responsible for Australia's personal insolvency and personal property security systems. We are an insolvency system stakeholder, practitioner and regulator. AFSA's Chief Executive, Mr Tim Beresford, is appointed as Inspector General in Bankruptcy and Registrar of Personal Property Securities. Officials within AFSA also fulfil the roles of official trustee and official receiver in bankruptcy. There are three main forms of personal insolvency: bankruptcy, and this is the most equivalent to liquidation in a corporate context. Unsecured creditor returns in bankruptcy are on average between 1 and 2 cents in the dollar. Debt agreements, which are more akin to a regulated debt repayment plan, and in the last financial year, the average return to creditors was 55 cents in the dollar. Then there is a very small number of personal insolvency agreements generally each year, and they are generally used for personal insolvencies that have a much higher level of assets and liabilities. At AFSA, we contribute to Australia's economic and social prosperity and play an important role in the economy and the credit system. In the last financial year, we had active regulatory oversight of $18 billion in liabilities in the personal insolvency system. Of this, $11 billion was business-related debt, with $10 billion addressed through the bankruptcy form of personal insolvency I mentioned previously. Business-related bankruptcies have accounted for close to 38% of all bankruptcies since 2007. For context, this has ranged from around 6,000 to 9,000 business-related bankruptcies each year in the decade or so prior to the impacts of COVID. We estimate that the potential value of the Personal Property Securities Register supports around $400 billion, or over 20% of Australia's GDP. We provide Australian consumers and businesses with tools to manage their financial risk, contribute to investor and business confidence, and provide enhanced access to finance within the economy. We are committed to being a visible, modern and contemporary regulator, delivering world-class services to deliver firm and fair outcomes for individuals with unmanageable debt and for those who are owed money. We are constantly surveying the credit system through our regulatory programs and act decisively when we identify system vulnerabilities, inefficiencies and misuse. The personal insolvency system includes individuals and business-related insolvencies such as sole traders and partnerships, and may include company directors who have given personal guarantees. Personal insolvency provides a remedy for those who are owed money, but also a safety net for people with unmanageable debt. The Personal Property Securities Regime, which includes the PPS Register, or PPSR, provides protection and peace of mind to consumers and businesses, while also making access to credit easier and wider. And just noting earlier questions asked by the committee regarding some of the history of why personal and corporate insolvency are separate in Australia, I can provide some insights. That bankruptcy was previously a courts-based process and relies on a federal head of power under the Constitution, whereas corporate insolvency relies on referred powers from the states under the Corporations Act regime, and that's just one of the historical factors leading to the current situation. And we are open for questions. Thank you.
Senator Scarr, do you want to kick off?
Sure. Just in relation, Mr. McCosker, to that difference, does it really just come to that? That the difference is just a result of, or has its genesis in the fact of constitutional powers and where they lay, and the fact the states were running with the corporations aspects of insolvency in the federal government with the personal? Is that all it comes down to, really?
History says so, Senator, and obviously there's been a number of reviews over time about whether they should be merged, as you've been hearing throughout the day and through the course of your review. You'll hear that, but that's where history has started. And it's really just a matter of whether and if there will ever be a time whether they should merge based on the other factors that would be considered.
Sure. So can I put it, the corollary of that is in countries, say the United Kingdom, where you don't have this demarcation between state responsibilities and federal responsibilities, is that one of the reasons why it all falls within the same ambit or the same legislation?
I couldn't say I've studied the history of why and how it would operate in as such in the UK, for Senator, but it may well be the case.
Okay. All right. Thank you. I've got some questions for the ATO. Have you had an opportunity to read the ARETA submission? You probably haven't, Ms Kitto.
I haven't read ARETA in full, but I think my colleague Mr Busby may have.
Okay.
Yes, I have read it. So yes, it's more
All
of a
right.
skim read, but I have gone through the
Okay,
whole
no,
document.
that's okay. That's all right. I just want to, and feel free to take anything on notice which you would like to take on notice, because I am interested in terms of the ATO's response, in particular to some of the recommendations which Arita makes. So if I can run through some of those, if I just have a find where they are.
Do you want me to come back to you? Because Mr Pitt's got a couple of questions ready.
Oh,
to
sure,
ask.
if you want to. Yeah, go on.
Mr Pitt.
Thanks very much. Mr McCosker to start with, and I apologise if I missed this in the opening statement. So you said there's bankruptcy debt agreements and then personal insolvency agreements. What would be the average size of those for each area? I mean, how much are we talking about? Are people going out the back door in bankruptcy for $5,000? Is it an average of a 500?
There's a significant variation, Senator. I don't know that I could give a specific answer to that off the top of my head. We do see that. Sorry, Senator, just looking at the tables of information I do have here.
Just to be clear, the MP bit means I'm a member of Parliament. The senators are on the other side.
Oh, sorry.
It's quite all right.
Mr Pitt, sorry, apologies. Yes, I was
Not at all.
People take the distinction to heart.
We offer him the chance to be elevated alongside us, but he
It's
just
only for the
rejects it at
benefit
every
of my
turn.
Apologies,
colleagues
Mr. Pitt,
from
I
the
was
other
wondering.
place.
Mr. Pitt, could I start, please?
Yes, of course.
Just to note the thresholds for personal insolvency, bankruptcy, it was $5,000. It was raised as a consequence of the COVID measures to $20,000 during the period of COVID, and it's reverted now back to $10,000. So there's that threshold requirement amount.
Okay.
Creditor initiated.
Yep.
And sorry, Mr Pitt, apologies, but just to clarify though, we do see about 9% of personal insolvencies or bankruptcies be creditor initiated, 91% therefore being debtor initiated processes.
Yeah. Okay. Well, maybe you can come back to me to give us an indication. I just think it's important to know what level we're talking about. The other questions are for the ATO, if that's all right, Ms Kiddo. In your submission, it says it's not been possible to accurately estimate how many appointments of liquidators are indirectly triggered following issues of DPNs, so director penalty notices. Why not? I mean, why wouldn't you know how many businesses have become insolvent that have a DPN?
So the information that we are collecting at the moment, and I'm happy to provide this to the committee on notice once we're able to get it in its entirety, is we're able to determine obviously the number of DPNs, direct penalty notices, that we issue, and the additional information that we're just gathering at the moment is of those directors of those companies, how many of those companies subsequently became insolvent. So we can, that is a quantitative figure that we can certainly provide. What will take a little bit more analysis, I think, is working out the actual trigger for those insolvencies. So we can't necessarily at this stage, hand on heart, say that the result of those insolvencies was the issuing of the DPN, but we can certainly provide the figures.
I understand the tax office not wanting to say it was all our fault and we've created every single one of them. But I guess my experience is no one wants to talk to the tax office. So just in terms of that trigger threshold, at what point you get advised or what point you take action, do you have a watching brief at a particular point on companies who have unpaid tax obligations? Does it get to a value? How does that work?
Yeah, so at the moment, in this calendar year, so 2022, we have restarted our firmer and stronger action approach. And part of that approach, as I mentioned in my opening statement, is about being measured and cautious. So we are not going for a big bang type approach of just turning all our actions back on. And one of the best examples I can give of that measured and cautious approach is that we've started off with awareness campaigns. So for director penalties, for example, in between March and September of this year, we issued 45,678 director penalty notice awareness letters.
Sorry, could you just say that again? In what period?
Between March and September of this calendar year.
45,678.
awareness letters.
In half a year?
Yes.
Right.
So to bring that back to your question around how do we identify those clients, it would be purely a systematic analysis of those companies that have debts to a certain point and have not complied with those debts within a certain time frame.
That's debts to you, exclusively to the ATO?
It would be, in particular, pay-as-you-go withholding debts, GST debts and superannuation guarantee charge debts.
But what's the threshold for action?
I don't have that number on me, but I am happy to take that on notice to provide that.
And is it case by case? Is it a value? I mean, just where does it sit in terms of the response? That's very helpful.
Certainly.
How much is lost per year by the ATO in insolvencies that are owed money? So it's, how much is out there on average in a 12-month period that is never provided to the ATO because the business went insolvent?
Again, if I could take that question on notice.
Of course. Thank you.
Thank you.
Back to you, Senator Scott.
Thank you. Ms Kiddo, you referred to awareness letter. So
Yes.
what is an awareness letter?
Certainly. So the purpose of the awareness letter is to remind the director of their obligations and explain what they need to do to avoid being issued with a director penalty notice. So this obviously differs from a director penalty notice itself, which will notify the director of personal liability of the taxes that I previously mentioned. And if they do not take certain steps within a 21-day period, such as paying the debt in full or entering into an acceptable payment arrangement, or appointing an administrator, liquidator or small business restructuring practitioner, they will be made personally liable for those company debts. So
Right. So you can see if you're a director and you receive an awareness letter, that's going to focus you pretty quickly on that within that 21-day period as to whether or not you appoint an administrator in order to avoid the personal liability, or whether or not you can come up with some sort of workable arrangement with the ATO. Isn't that correct?
just to clarify, the 21-day period relates to if a director penalty notice itself is issued, not the awareness letter. So the awareness letter is merely to advise the director that the company that they are a director for has a debt and that they need to take action. They need to contact the ATO and take steps to bring their debt under control, or be made aware of what the next steps may be, which could include us then issuing a director penalty notice if no steps are taken after receiving the awareness letter.
Okay.
Can I ask a numbers question there?
Sure.
Of the
Yes.
45,678 awareness letters sent between March and September 2022, how many responses did you receive?
So, as a subset of the 45,678 awareness letters, we then, this is between March and September, we contacted 24,140 clients.
In addition to the letters, you contacted them by what means?
As a subset, so by phone call.
Right.
So the letters were obviously, so 24,140 clients contacted with total debts at that point of approximately 4.3 billion. To date, or to the end of September 2022, nearly 30,000 clients have taken action to bring their debts under control. 68% of the debts that related to the awareness letters, totalling 2.9 billion, are now under control. 3,601 clients paid in full, which was approximately $235 million. Nearly 15,000 clients entered into payment arrangements over debts of approximately $2.2 billion. And 1,068 clients have notified us of insolvency or that they are no longer in business, which represented approximately $363 million in debts.
Thank you. I'll have some more questions, but back to you, Senator Scarr.
So this is a very interesting piece of data. The 15,000 clients have entered into a payment arrangement with the ATO once they receive that awareness letter. We've received evidence earlier today that one of the obstacles with respect to small businesses accessing the Small Business Restructure Scheme is that based on the conditions upon which it can be accessed, it cannot be accessed if you've got a payment arrangement in place with the ATO. So there's potentially 15,000 small business clients there that could not access the small business restructure arrangements in the Corporations Act as a result of the fact they're in a payment arrangement with the ATO. Is that correct? Are you aware of that issue?
I'm not aware of that issue, Senator, but it's not a condition of entering into a small business restructuring that you can't be under a payment plan. That's not a restriction at all.
Well, sorry, we've heard evidence today, unless I misheard it, that if you're in a payment arrangement with the ATO, so there are unpaid, in particular I think it might be if it's with respect to superannuation maybe, unpaid superannuation entitlements, that if you're in a payment arrangement with the ATO, you can't access the small business restructure regime.
Okay, look, I understand that now. Look, it is a requirement that any due superannuation has to be paid as a precondition to enter into a small business restructuring. So in that respect, that would be right.
We've further defined, we've defined the class. So how many of the 15,000 would include unpaid superannuation? Any detail on that?
I don't have that level of detail.
Could you find out? Could you take that on notice? Because it'd be very interesting to find that out. Because if it's thousands, these are thousands potentially of small businesses that are prevented from going down the small business restructure route because they've already got a payment arrangement to repay the superannuation, and from the ATO's perspective, almost by definition, if they meet the arrangement, that's at least reasonably satisfactory, but they're prevented from going down the small business restructuring path because of that. So if you could take that on notice, thank you. So, Mr Busby, going through some of the ARETA recommendations, and this is pages 77 to 80 of their submission, and feel obliged, be happy to take on notice if you want to take some of these on notice, but I'll put them to you, and we'll see, and Ms Kiddo, what your view is. Recommendation 30, this is a reader. The committee should recommend that the ATO should not be given any greater priority of payment over other unsecured creditors, especially noting their increased knowledge of the solvency of a business, end quote. And it appears what they're talking about there is the fact that with director penalty notices, garnishee orders, etc., even though the priority which had previously been given to the ATO has been removed, there's some level of de facto priority because the ATO has those additional tools within its armoury. So I'm interested in your response to that.
Well, in respect of DPNs, that becomes a parallel liability between the director and the company. So if the company is insolvent and unable to pay, and it's a lockdown DPN, there is the opportunity to recover it against the director. In terms of garnishees, yes, they are a tool that is available as part of the debt collection process, and they are used from time to time. And where they are used, that will give priority to the asset that's subject to the garnishee.
Right. So why should the asset that's subject to the garnishee have preference in terms of the ranking of creditors?
Right. Look, I think.
What's the theory behind that?
Look, I don't think I actually have the information to tell you the theory behind that.
Okay. Another point they raise is the ATO can offset amounts, and unlike other entities wanting to do a set-off, are not limited by the requirements for mutuality and not knowing that the company was insolvent at the time of extending or receiving credit, end quote. Are you aware of that issue in terms of the ATO being able to offset amounts?
There is an automatic set-off under the Tax Act where there are credits and debits.
All right. So can that in effect give the ATO priority over other creditors in practice in that respect?
Look, I think that's probably arguable because a normal creditor has the right to set off mutual debts so long as they don't have notice of the insolvency.
Okay.
I would just add, if I could, Senator, to that, to say that it's not merely an ability for the Commissioner to offset credits and debts, it's actually a legal requirement under the Taxation Administration Act.
Oh, and I'm not saying these are things being done at the discretion of the ATO.
Yes.
We're looking at the system.
Yes.
And to the extent there are legal requirements which have the effect of giving a de facto priority to the ATO, the question at least I'm asking myself, is whether or not that's fair and reasonable in terms of equity, looking at different creditors. The concept that the ATO should act as a model creditor, I'm interested in your views in relation to that, Ms Kiddo, and what the ATO's thoughts are in relation to that. And feel free to ask me what a model creditor is.
Oh, look, if you have any further information as to what you are anticipating or what a reader are anticipating in making that suggestion, we'd be...
Okay, I'll give you a list. This is what a reader says on page 78. So maybe you take this on notice and let me know whether or not what the ATO's approach is in this regard. But what they list is, in our view, some of the characteristics of a model creditor include not abstain from voting at meetings, right? Attending all meetings, whether by sending a staff member or by providing a proxy to the chair. Supporting resolutions in relation to appointee remuneration wherever it is for the necessary work properly performed. Not taking advantage of external administrators who have insufficient resources to pursue a claim against it. Not seeking to prioritise the ATO's position above other ordinary unsecured creditors. Ensuring requests for information made in accordance with creditors' rights are reasonable. Reporting potential breaches of the law, and that's about it. So maybe take that on notice, but do you have any immediate reaction to that concept and some of those matters?
I might just add some high-level observations.
Sure.
And then invite my colleague, Mr Busby, to add anything further. I would say that there is already a broad framework that the ATO operates within. So we're already bound to comply with our model litigant obligations, which includes principles such as promptness, avoiding unnecessary litigation, consistency and being cost effective. So these principles we abide by as our role as the administrator of the tax and super systems. We certainly don't stop abiding by those principles when we're sort of wearing a different hat as a creditor. The other principles that we abide by are contained in our Law Administration Practice Statement 2011/16 regarding insolvency, provides guidance to ATO officers and the public as to how we vote in creditors' meetings and the type of things we take into account. And then I would also add that we're bound by the broader Taxpayers Charter, which is about treating taxpayers fairly, reasonably and as being honest, as well as the requirement of our officers to act in accordance with the APS Code of Conduct, to behave honestly with integrity and treat everyone with respect. So there is a broad framework, as I said already, and we do, in principle, already do some of those things that you have listed, and I'll invite Mr Busby to add a commentary to that as well. But I would just say, while it's not the role of the ATO to necessarily comment on the appropriateness of whether such guidelines should be introduced, from our perspective, as I said, we do largely abide with those principles in our day-to-day work anyway. So such guidelines, I don't think, would be inconsistent with the principles and practices that our staff already comply with.
Sure. Mr Busby?
Yes, I'll just add to that as an informed and engaged creditor, the ATO is aware of the influence it can have in terms of its presence at creditors' meetings and the way we vote and how it can affect the outcomes of that. So we do have regard to the practice statement law administration that Assistant Commissioner Kitto referred to early on, and that sets out a range of factors that we take into account when we are considering alternative arrangements to bankruptcy and liquidation. And so that would include dealing with deeds of company arrangements through voluntary administration processes. While the practice statement doesn't currently cover small business restructuring, we do, as a matter of practice, follow the principles of that when we assess restructuring plans as well.
Okay. There was some testimony given to the committee about the experience of practitioners, insolvency practitioners dealing with the ATO and in an insolvency context, and sometimes being frustrated that perhaps the individuals they're dealing with don't have adequate knowledge with respect to insolvency law and the issues they're dealing with, and that they find it hard in some cases to get the assistance, for want of a better word, they need from the ATO. Does the ATO have any programs or training in place to assist staff to understand the insolvency process and protocols for assisting insolvency practitioners, registered liquidators, etc., to try and achieve the best economic, most efficient outcome for the individuals concerned, but also for the larger community accreditors?
Look, there is training that is provided to tax officers, and we do have some specialist teams that deal with insolvency matters. So where it may be something that might be outside the scope of the training of a tax officer, it will be escalated internally to one of the insolvency specialists. And we do undertake quite a broad program of engaging with practitioners. You know, that has proved quite successful in terms of, you know, getting good outcomes from deeds of company arrangements and small business restructuring. We do participate in various technical forums for the insolvency industry, and we do write articles for the industry journals. So we do continue to engage that way.
Mr Busby, are you aware of this feedback? Is the ATO aware of this feedback? And I'll just quote from a reader's submission. I quote, "While some staff at the ATO are highly trained and knowledgeable, and no doubt we have staff here today who, of course, meet that criteria, this is not consistent across the relevant parts of the ATO's workforce. We recommend that there be more focus by the ATO on substantially increasing its staff's knowledge of insolvency law so that the ATO can be an active, informed creditor in insolvency processes," end quote. Do you have any response to that?
I would probably just add to say that we do get a range of feedback.
Right.
So while we have heard at some ends of the spectrum that we need to invest in more training, then we also hear very positive feedback that, you know, our staff are very knowledgeable and very good to deal with.
Well, I think this is a mixed bag itself. I mean, it's saying that in some cases very knowledgeable, in other cases it would be good if there were more training. So maybe you could just take that on notice and reflect on it. So this is an opportunity for us to exchange feedback and to let you know what various stakeholders are saying in this regard. Mr Montanez, I want to give you an opportunity.
A numbers question there.
Sure.
How many people do you have operating in the tax department tax office across the country who you would consider are insolvency specialised?
I think that's probably one we'd need to take on notice.
So where are they distributed? How accessible are they? What are your protocols around a business ringing in? Do they get a different person every time? Are there file notes taken? How extensive are they? I'm trying to really see about the interface, because in addition to the comments from Arita, that's what we often get from small businesses that interact with us, and it's certainly what we've got in evidence from other witnesses today, that it's patchy and that there's no clarity about who you could speak to. And I just think from a mental health point of view, by the time you're in trouble with your business, if you're engaging with somebody in the same way as if you're engaging with a mental health professional, every time you have to tell your story to another person is just another layer of shame. Not necessarily guilt, made a mistake, shame in terms of embarrassment and the emotional stuff that's dealt with that. So while we're talking about money, we are talking about people embedded in this process. So what seamless, high-quality support are you going to give people when they contact the ATO at a vulnerable point? Because if that's not managed well, the flow-on effect is a cost in health, the flow-on effect is a cost to the economy, to productivity. It seems to me a critical juncture. So I'd like to understand the shape of your workforce, how permanent it is, where it's located, how many seconded staff you may have moving in and out of from other departments, how many contractors you might have in that space, how that's gone up and down over time. So I understand exactly what's going on with response to insolvency. Thank you.
Take that on notice. Thank you, Chair.
Senator Scott.
Now, I've got some questions on lawful phoenixing, Mr Montanez, but just before I get to those, I just want to tidy up this one issue. AREDA says or recommends in relation to simplified liquidations, and I quote, they're suggesting remove the requirement to obtain clearance from the ATO prior to a dividend being declared and for proof of debts to be lodged for claims of less than $10,000. Creditors would retain the right to judicial determination of a rejection of their claim. This would not be captured by the prohibition on litigation. End quote. So it seems that in the context of the current mechanism for simplified liquidations, we've heard evidence that isn't being used hardly at all at the moment, which is defeating the legislative intent, that one of the hurdles is the requirement to obtain clearance from the ATO prior to a dividend being declared. Any response to that? Feel free to take it on notice if you like.
Happy to take on notice, but I probably would just highlight that it is a requirement for a liquidator, if they are going to pay a dividend to unsecured creditors, that they do receive a tax clearance, and that involves ensuring that any outstanding lodgements are made and sufficient money is set aside to deal with any tax debt that arises from that. So
I guess the issue is if there are lodgements that haven't been made, there's hardly any money left, then the whole concept of obtaining clearance from the ATO adds another administrative burden which is never going to be met. Therefore, why have that as an additional burden when you're talking about claims of less than $10,000? Do you appreciate the point?
Yes, I do appreciate the point, yes.
Okay, all right. Well, if you've got anything to add on that, feel free. On unlawful phoenixing, so Mr Montanez, have you had a chance to read the AREDA submission at all?
Not in detail.
Okay, so I just want to put a few recommendations there put to us, to you, to get your feedback. Again, feel free to take on notice if you want to take any of these on notice. Recommendation 9, the committee should recommend that the law be amended to create a definition of and offences relating to illegal phoenixing that should be applicable to all parties involved, including advisors, end quote. So the issue they're raising is that there could be greater definition of what the offences are in the illegal phoenixing legislation. So interested in your view with respect to that. Is there uncertainty with respect to what's covered?
The issue that you've raised is a matter of policy.
Sure.
So I'll have to refer you to my colleagues in Treasury.
Sure.
But what I can say is
if you could just give us an indication of your practical experience in terms of, are there any, I don't want to take you into policy areas, but are there any practical difficulties or roadblocks in terms of effectively applying the law at the moment as it is on the books, especially considering the recent amendments which have been made?
So on our website, we publish some broad indicators of what we think illegal phoenixing in. Usually the deliberate and serial liquidation of a company, inappropriately transferring assets to a third party, for those sorts of things. Yeah. And also the fact that illegal phoenixing comes in a number of forms. It's not that easy to say this is illegal phoenixing, because some use it as a business model to try to extract wealth and use it as a competitive advantage. Others are more opportunistic. They get themselves into trouble and they see maybe moving the assets into a new business so they can start up again as a way of taking an advantage. There is also some instances where it's defined or or a person thinks it's illegal phoenixing activity, but it may not necessarily be. This might be where someone's in business, they liquidate in a lawful manner, and then they start a new business up in the industry that they were in. Now, they've actually haven't done anything wrong. They haven't shifted assets. They've gone through the process. But generally speaking, the person might be in a particular industry, that's their skill and expertise, and then they move on. And they've had a business failure, but they never repeat that. And that we get a lot of complaints about those sorts of instances, but they are just lawful business restructures, and they're in terms of the economy, allowing people to respectfully shut down a business and then move on with their lives, I see as totally appropriate.
So the issue there is third parties who perceive what a business owner has done to be illegal phoenixing, when in fact they've lawfully discharged their relevant obligations. Is that correct?
That's right.
Okay.
So it's very broad.
Right. So how does the ATO address that? What do you do when someone contacts you in that regard?
We have a look at it.
Right.
If we have the the Tax Integrity Centre hotline. Right. People will come in and give us tips.
Yeah.
We'll look at it. We'll look for the risk factors, including previous liquidations.
Yep.
You know, the sort of debt they have, and then make a judgment call whether this is a legal phoenix. And I think a point needs to be made that most Australian businesses are honest. And, you know, it's a very small percentage that get involved in illegal phoenix activity.
Yeah, good point. Thank you, Chair.
Thank you very much. Could I just go to some evidence we received a little earlier today? And I know that ASFA have been here for quite a bit. Perhaps you didn't hear this. But it was put to us that banks are more predictable than the ATO in how they interact with businesses that are caught up in the insolvency process. And that there's some tension between whether the ATO acts as a commercial creditor or a policeman. I think in your evidence this afternoon you've indicated there's a point of transition where you switch from being there to recover tax and superannuation to a post-insolvency phase. How is that determined? How is it managed? And how many entities do you engage with that shift into that position per annum?
So that's correct, Chair. When I mentioned in my opening statement that we do see our involvement in the broader insolvency regime as being pre-insolvency and post-insolvency. At all times, we are still the Commissioner of Taxation as the administrator of the tax and super systems. It's just that our role largely shifts, as you pointed out, from that of focusing on the recovery of debts to participating as a major creditor in creditors' meetings, voting on arrangements and so forth. So would you mind repeating the question for me just on...
I asked such terrible questions I could never repeat them. But I'm sure it's on the record. That's exactly, because I'm kind of... We're in the realm of so much complexity. It's trying to just check knowledge before you ask the question. You went through a bit of a discussion about DPN and giving the awareness letters to 45,678 businesses, contacting 24,000 of those, 24,100 and...
140, 24,140.
By phone?
Yes.
Was that on a risk-based assessment or it was just random?
I would have to take that on notice just to make sure I provide the correct answer on that, Chair.
So 30,000 have taken action, or you've taken action? Who's taken action?
The clients have actually taken action. So what we mean by that is they may have paid in full, They may have entered into a payment arrangement, which they may have done by self-serving via our online systems. So they can actually enter into payment arrangements online up to the value of $100,000 of debt. Beyond that, they do need to contact us to actually allow us to consider their circumstances and their financial capacity to pay.
Okay. So the 15,678 that remain, what's the story with them?
So of the remainder, as I said, some have paid in full. So 3,601 have paid in full. And I'll have to check my maths add up here, but a further 1,068 clients, as I mentioned, have notified us of insolvency. And of the remainder, and I think we did mention this in our submission as well, so following the awareness campaign, we have then moved into the director penalty, issuing of director penalty notices, my apologies.
And I'll come to that now.
So of that subset, we have issued 7,523 DPNs following the initial awareness campaign of 45,000.
Okay.
Just on that line of question,
Yes.
Chair. You said earlier that there was some 4.3 billion outstanding around that 45,000 odd number. What's that? What's your total tax take for a year? Just to give us some context.
I would have to take that on notice. My apologies.
Okay.
Of the 1,068 that have got caught up in insolvency, because that's what this inquiry is about, so we're trying to get the sense of the scale here. Is there any overlap with those 1,068, which involve $363 million, with the director penalty notice to the 7,523? Is there any overlap there, or are they two completely separate cohorts?
I would have to double check whether they are separate. I believe they are, but I would need to confirm that for the record.
Okay, if you could do that, that would be great. Of that 1,068, what's happened? And what's happened with the 363 million?
Yes, so of the 1,068 that have notified us of insolvency or that they are no longer in business, so that
So are those two things the same in your view, or?
Well, they may, not necessarily. If they've notified us of insolvency, that means they will have come through the system and actually notified us through our processes. I would have to dig a little bit further as to just no longer in business. I am assuming that that means that they have not separately notified us, but we may have, as part of contacting them, discovered that information. But what I would say is that those clients would now have what we would call an insolvency accounting treatment or insolvency indicator applied to their accounts. And the point at which we do that is where the clients have notified us that they have either appointed an administrator or a liquidator or a small business restructuring practitioner, or put the company into voluntary administration. So they have entered the insolvency, they've reached the point of insolvency and they've notified us of that.
Okay, what about the ones that have just stopped using their ABN and have been struck off by ASIC?
So I'm not sure if you're referring particularly to the 1,068 or more broadly.
Are there any in that 1,068 that are businesses that are just no longer in business, as opposed to formally insolvent?
I'm not 100% certain if it is the subset there. I can confirm that for you. But there would be businesses of those type that have either, that are no longer trading, that are no longer in business, and that either are not engaging with us or we have been unable to contact them. They would potentially receive or form part of the next stage of the firmer action in this place, being the issuing of the director penalty notice. But really that just forms part of our continuous debt recovery procedures until we can no longer identify them. Then they may be escalated for non-pursuit of debt, for example, if they are uneconomical to pursue debts. But it really becomes a matter of priority.
Okay, so I certainly have concerns that there are business entities in a range of forms that are engaged with the taxation department that find themselves at a point where they can't pay particular instalments to you. There's a trigger, which is the DPN notices, or there might be a communication and there might be a recommendation that they talk to an insolvency practitioner. They may or may not take that. I can't see any clarity about where the decision making is made, whether it's worth not pursuing them because there's no money there. Because my understanding is that there are insolvency practitioners who can't see what's going on in the businesses, or do see the distress that's in businesses and go in and, for a cost to themselves, do the paperwork to make them insolvent to fit into your system, do the paperwork that's required of them for them to comply, to continue their registration as insolvency practitioners and comply with all the ASIC 100%, tell us what's going on paperwork. I don't know about you, Ms Kiddo, but this looks incredibly complex. The data isn't transparent. It's really difficult for us to see what's going on. On top of everything that I've said, you sort of put another layer on top with personal bankruptcy, and then you've got a small business, micro business with 3 employees, 2 are directors, husband and wife. Officially, that's corporate, which is the historical reality that you've been talking. But to the layperson, I hope I'm conveying how completely untidy and difficult such a prospect is to consider, even if you're in the best of mental health with robust financial health behind you. So I'm seeking your response to that complex reality. I've got no doubts about you doing your jobs within the requirements that you've been asked to undertake. The question is that meeting in any productive way the reality of Australian small businesses, medium businesses, corporate or not? Do you have a response for me, Mr McCosker, to that question?
Senator, I don't think we can give a very informed response. We know that obviously we deal with, through our wonderful people at the AFSA Service Centre, deal with people in financial distress every day, and they do a great job in doing so. And some of those, as I mentioned the numbers before.
So the sorts of concerns that I've just raised, are they the sorts of concerns that are being put to you as people contact you and get caught up in this system?
We do know that there are some people who are unclear about which path to take and whether they should approach the corporate insolvency process or the personal insolvency process. Senator, yes, we are aware of that type of a circumstance.
Do you think that's a literacy problem or a design problem?
I think I couldn't really, conjecture on that response to that, Senator. I think it'd have to come down to the individual circumstance. We do know that financial literacy, and we work a lot, in fact, with our ASIC and now Treasury colleagues on financial capability and literacy. We know that that's an area of significant need and continuing focus, for a range of people through the Australian community, and in particular the vulnerable cohorts. And we do certainly know that people are very vulnerable when they are in straitened circumstances, and we have some wonderful officers dealing directly with people in those circumstances, certainly.
And Chair, if I may.
Thank you, Ms Harold Woods.
I'll also reflect on comments that were made by Treasury this morning that a lot of people find themselves in the personal insolvency system through no fault of their own. Financial literacy is a really important component of the credit system. So as Mr Dixon this morning noted, insolvency is kind of the point of no return. But the credit system as a whole has quite a significant lead up to where insolvency may come into play, and financial literacy and support for people who may be experiencing different types of vulnerabilities and financial understanding and business acumen is definitely a part of that. And as Mr McCosker just noted, there are a number of other vulnerabilities that may be at play around financial abuse, domestic violence, and other circumstances, natural disasters, all those sorts of things that just mean that by the time someone comes to the insolvency part of the system, they may already be at the more vulnerable end, and we have a framework to be able to work very closely with those clients, irrespective of the reasons why they are coming through the insolvency system. But that is probably something we don't have a huge amount of data on, is the specifics for why people are going through insolvency. That's not what our part of the system looks at. We just work with the people who come to us.
So the key words are the point of no return. I guess that's the conjecture point, isn't it? At what point is a business declared insolvent to a point of no return? And one of the questions that seems to be coming forward to me is the ATO, I think you indicated that you're a creditor in 74% of the cases, or around 3 and 4 company insolvencies, often the largest creditor, sometimes the only creditor. Is it possible, is there any data to dispute the fact that the driver of insolvencies could be the ATO action that sets in train insolvency when a business really could trade out with more flexibility?
So,
are you constructing the point of no return, I guess is my question.
So with the actions that we take, as I mentioned,
Ms Kitto.
As I mentioned earlier, Chair, thank you. Our approach is very measured and cautious, and it is not jumping straight into insolvency or wind-up actions. So we touched on the awareness campaigns before we then jump into firmer or stronger actions such as DPNs, garnishees. It is only at that point where we are still unable to get engagement with the client, or where that client is engaging in high-risk behaviours such as Phoenix, that they are really the triggers from an ATO perspective to go down the insolvency path.
So
it is not about...
what if a business can't get any consistency in terms of who they're speaking to? What if there's no... this is what we get from businesses, that they can't speak to somebody, that accountants can't even speak to somebody in a consistent way and get clear messages. And it hits a point where, it just becomes so hard. Action's taken, insolvency is triggered, without a sense of whether the cost of going through that insolvency process is actually going to cost even more than what's in there to recover. What's going on in that part of the equation? Like how much observation of that part does the ATO have?
So an observation that I would just add to your comment is around the ATO's approach to vulnerable clients. So if clients are engaging with us and do express vulnerability, we do have existing processes in place to assist those clients. During the pandemic, we set up what we call our High Client Impact Action Framework, which guides our staff when making decisions that, as the name suggests, would have a high impact on the client. And these are things like garnishees, DPNs, or a decision to initiate legal recovery, such as a statutory demand under Section 459E, the Corporations Act. In addition to that, it is now mandatory for all frontline staff to complete training on managing and assisting vulnerable clients. For those matters where the staff member has identified extreme vulnerability, so they've reached a point where they don't feel that they can adequately assist the client within their own control, they can then escalate that to the specialised client support team.
How many of them are there?
How many? I would have to take that on notice.
Are there hundreds of them for the 2.5 million businesses?
I couldn't tell you off the top of my head, Chair. I would have to take that on notice.
Okay. I would put it to you that perhaps the ones who do not communicate with you are in fact the most vulnerable. and that I haven't heard anything about a process to actually interact with such people outside of them fitting the system.
And I think this goes to the complexity of the point you made earlier around the different roles that the ATO plays. And I think it is an important point to note that the ATO is not the regulator or the administrator of insolvencies. Obviously, when it comes to corporate insolvencies, it is ASIC. When it comes to personal insolvencies, it's our colleagues in AFSA. The Commissioner of Taxation is also the registrar. And so there is some responsibility there around the registration of ABNs and so forth. But I think there is a level of complexity there between the different agencies, and the ATO's role really in this space that we're talking about is that creditor involvement. It is not about managing clients necessarily in or out of the system at that point.
Look, thank you for your answer. I think we're right at the heart of why we need to have a really good look at what's going on. And a number of suggestions have been that there needs to be a root and branch review. You can't give me an opinion on this, but have you done any work in terms of system change with other agencies? Is there any work going on, perhaps arising out of the Whittaker review?
Senator,
Mr McCosker.
Yeah, we work very closely with our ASIC colleagues in regards to the insolvency system, and have a an ongoing close relationship with them to look at the harmonisation of practices where it's possible. There was the Insolvency Law Reform Act of a couple of years ago. I'd have to get the exact year. Mr. Shaw may be able to add to this. So we work very closely with them on the practice. We do have a common set of practitioners. About 80% of our registered trustees in bankruptcy are also registered by ASIC as insolvency practitioners as well. And we have a very common sort of a cohort, I guess, and role in the credit system and credit infrastructure for the country to be able to do that. You mentioned the personal property securities regime. We work across the board with both federal and state bodies to be able to really try to raise awareness and to be able to ensure that we're able to increase the efficiency of the processes that within the existing legal framework we're able to do so administratively for access to the personal property securities register and regime as well.
And I just want to come to that in a second, but can I ask if one of the people that Ms Kiddo was just speaking about who has not engaged at all, right, it sets in train a series of events without any communications, and then a company, it might not be a company, it might be just a sole trader, gets involved with the ATO. What do you do then?
Well, first of all, we have a vulnerability framework that Ms Errol Woods mentioned before, and we attempt to, and it is very difficult, but because, as you rightly mentioned, Chair, many people don't disclose vulnerability at the outset of an engagement in the process there. So we try to find indicators of vulnerability at an early stage, and we encourage all people who, prior to entering the formal insolvency system, to be able to go and negotiate with their creditors, to get support to do that. We refer them to insolvency practitioners who we regulate, and financial counselling services to be able to actually get advice, to be able to actually support making an informed decision that's best for their circumstances.
So there's some suggestion in the evidence we've received today that insolvency practitioner might not be the best person to talk to a business that's in distress in terms of the capacity to help change it around, because the knowledge set is a different, involves a different mindset, a different set of skills. Do you have a view about that?
Senator, I think it really is dependent upon the circumstances who might be best to provide business advice. It's not something I think we can provide a general answer to, because I think there are a range of options.
Let's take it to the point where an insolvency action begins, whether the person's conscious or not, or whether they've exposed their vulnerability, but insolvency is on. The insolvency practitioner goes in, or what do we hear about some pre-insolvency practitioners who are deregistered insolvency practitioners who I could go and look up on the internet, they come in and then they interact with my business.
Yes.
Do you have any view about that observation of that?
Yes, I'll defer to Mr. Shaw to be able to respond more fully, but we do refer to this cohort as a untrustworthy advisor cohort. Mr. Murray, in evidence prior to us, made, I think, a very cogent comment that not all pre-insolvency advisors are untrustworthy, and there is certainly a need for distinction there. But I might hand to Mr. Shaw to make further comments.
Yes, thank you, Chair. In terms of untrustworthy advisors, we see that cohort as a real potential harm to the insolvency system, and there's a strong correlation between their adverse impact in the personal insolvency system to the corporate insolvency system. For instance, we are a member of the Phoenix Task Force, reflective of that crossover of interest in relation to managing untrustworthy advisors, because of course they can operate in the personal insolvency system and the corporate insolvency system.
It doesn't matter to them that they're two separately managed entities and that historically they're two separate sets of legislation with two different administrative bodies.
Indeed, and at the heart they may be seeking to protect personal interests and personal property of a particular person who sits behind a corporation, for instance. Senator, AFSA prepared a detailed report in relation to untrustworthy advisors that we published this year.
I definitely haven't seen that. You might want to table that.
I have a copy here,
Thank
Senator,
you.
and that was published in July this year. And importantly, Senator, it identifies actions that all stakeholders in the insolvency system can take to disrupt untrustworthy advisors. And I think it's reflective of the fact that sometimes there's not always a legal solution that's readily available, that there's perhaps action that we can take outside of the legislative framework to disrupt untrustworthy advisors. And a key component of that is getting information out to people so that they can make informed decisions at a time that is stressful for them, that they know where to go for reliable information. Often it is AFSA's website or ASIC's website that can provide useful information, financial counsellors, of course. There's a raft of different options for people to explore if they're able to identify them. And linked to that, Senator, we're very keen to work with creditors because we believe creditors are even best placed to see the warning signs of insolvency. So to try and bring that decision making forward, and many creditors, particularly if I can call them sophisticated creditors, are concerned about things that we've discussed here now in terms of vulnerability and how to manage those issues. So there's a lot of potential partnerships to try and address some of these risks.
You've got a question? Yep.
Yeah, just on this line of questioning. So what's the difference between that and a lawyer who is providing lawful advice about how to protect their assets? Because, well, let's be frank, that's what they're going to be doing. They'll go and talk to someone to say, what do I do here? So what's the difference between these advisors and a lawyer?
Well, these advisors are not abiding by the law. They'll seek to not be open in terms of the opportunities that people have to get free advice or to complete their form. If they're applying for bankruptcy, to apply online at no cost through AFSA's website. So you think the lawyer's advice is to go and get free advice from someone else? Well, of course, a lawyer registered
no offence to our legal learned friend at the end of the term.
A registered legal practitioner is, of course, registered, so there's controls in relation to their professional conduct, which could be through the relevant law societies. What we're really talking about. Indeed, and in terms of untrustworthy advisors, that's what we're particularly focused on, is the unregulated, the unregistered operators who are seeking to exploit and take advantage of. And often it can be a financial advantage in terms of getting money from someone who's in difficulty, as I said, or it runs right to the extreme in terms of creating fictitious creditors and trying to influence the outcome of an insolvency process.
So that would be part of a root and branch review if one were to exist. Well, that would look at that problem. Let's just move along a couple of steps. So they go to an insolvency practitioner who is actually registered and somebody is doing the right thing. We've heard evidence, or we've received evidence that in 2013 the estimated cost of providing insolvency services that are in alignment with the requirements of ASIC to keep your licence as an insolvency practitioner alive and do the right thing is in the order of $43 million per annum. And that there is market failure in the provision of insolvency services, and that there is the cross-subsidising of the public good of insolvency advice to people who can't pay. by the spotting of opportunities to really significantly ramp up the costs to cover the cost of doing business overall. Now, there was a bit of philosophical debate about whether that's just, good business or whether there is a cost to the public good by having that money allocated to that task rather than allowing that capital to do something else. So do you have a view about that record that's been put to us as fact of the cross-subsidising that occurs in this industry?
Senator, we're aware. I mean, we heard Professor Harris use the term swings and roundabouts. And this is
that was a judge that he was referring to.
I think he did say that that's even in judgments, but it's also used more commonly. We're aware of that term. We're aware of that is how many of the insolvency practitioners feel that their system operates as well. I'll again refer to Mr. Paul Shaw here, who we've also produced a report, actually a year prior to the report that Mr. Shaw just touched on in regards to remuneration in her personal insolvency system. And one of the key findings or the key points made is that there should be fair pay for appropriate work undertaken of any profession, and the insolvency profession certainly being the one that we all focused on in this particular case.
In each instance, because that leads to transparency and the real cost of the service being identified.
So the way the full system is funded is certainly something that's beyond our scope of operations. Obviously, we have a funding mechanism for AFSA as an agency, which is different to the funding mechanism of ASIC, for example, in the way that operates. With the realisations charge on assets that are realised through an insolvency proceeding as a part of our funding model, amongst other charges there as well. But Mr. Shaw may wish to add further about the remuneration situation of personal insolvency practitioners.
If I can just briefly, Chair, please. So as Mr. McCosker said, we prepared a detailed report in relation to registered trustee remuneration. That was done in 2020. And I'll just note one aspect of that report. It identifies that this was in the 2018-2019 year, for example. In that year, 63% of bankruptcies administered by registered trustees, no remuneration was recovered at all. Analysis done for that year showed that 69% of registered trustees' bankruptcies that were finalised in that year had remuneration drawn in 1 or more years.
Explain that last bit to me. What does that mean?
Well, in terms of a bankruptcy administration can take some years, and so it's just when they're finalised, Senator. So it does show the variation that can occur in terms of the remuneration. It shows that
63% no remuneration recovered
in that year of that where bankruptcies were administered by registered trustees. So it does show the variable nature of the remuneration that flows through to practitioners, that it might all not come through at the year that they're actually working on the particular administration, that it can take some years in effect to recover the remuneration for the administration of the estate.
Do you think the creditors would consider it swings and roundabouts to be having exorbitant charges for some particular sections and others have none?
Mr. Pitt, the remuneration paid in a particular administration is limited to that particular administration, and creditors ultimately will approve remuneration for the registered trustees. The alternative is if creditors are not engaging with the registered trustee, the registered trustee can apply to AFSA to get a remuneration determination. But notwithstanding that process, there still is a mechanism by which the bankrupt or creditors can apply to the Inspector General for a review of the remuneration. And in fact, the Inspector General can conduct a review of remuneration of his own volition.
But I mean, clearly, if you've got 60% with no remuneration and they're making up the operational costs and the other 40, well, they're paying overs.
Mr. Pitt, I'm not going against what was said before in terms of the swings and roundabouts. It's different language, perhaps not language I would use, but there is that cross-subsidisation.
So there are many more questions that I think we'll probably need to put on notice. For the ATO, can I just indicate that had a line of questioning around the government implementation of recommendations of your review of the Personal Property Securities Act.
No, that's the Attorney
Sorry,
General's Department.
the Attorney General's Department.
A RETA.
Oh, that's right.
Just feedback in relation to those RETA recommendations. If you could just take that on notice, it'd be helpful. Yep.
And some material that we've had from ASBFAO with regard to assumptions of deliberate non-compliance by insolvent businesses, despite the ATO's commitment to treat clients as being honest. I'd like to understand how frequently you interact with ASBFAO and what changes you've implemented as a result of advocacy from the Ombudsman with regard to that. And ASFA, there's further questions on notice for you too. I hope that you've got a bit of a sense of the flavour of what this committee is seeking to do. We're mindful of the framework that we're asking these questions in terms of the economy right now. In a post-COVID period, we've had rising inflation, we've got, policy settings from the RBA that's impacting on business and the cost of credit, etc. Australians need to understand what's going to happen with their businesses when there are so many who are involved in it with such varying degrees of literacy, yet fantastic outcomes in employing, many, many people right across this country. So we are very keen to have your insights as we consider what might be pressure points that could need us to do something more substantial than perhaps even this committee can do. At the moment, I feel like we're just getting a documentation of some of the pressure points that are in the system. It'd be good to get the fill of what the pressure points are and to understand that. And I know that you're all proud of your agencies and that, there's a degree of defence that's involved in standing up for the team that you're a part of. But we're all here as servants of the public. And I really want to get the truth of what you're hearing from people on the ground, because you have even a higher level of engagement with Australian citizens in this situation than we do as representatives. So that is the goal of the questions that I've put to you today, and colleagues as well. I hope you concur with that. And certainly there'll be more questions trying to get that from you. Thank you very much for coming today.
Thank you, Sandra.
Thank you.
Cancelled to Sydney. Are you on Qantas or Virgin?
Yeah, I'm on Qantas at 7.
They just shifted you up slightly earlier.
Oh, yeah, I've got to do a hearing for policy consultation. So, I now welcome Mr Bruce Whitaker via video conference. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
Thank you, Madam Chair. My name is Bruce Whitaker. I'm a school at the University of Melbourne, but I'm appearing in a personal capacity today.
I'm sorry, Mr Whitaker, you just had a little dropout right in the middle of your declaration of where you're coming from. Would you like to try again?
Yes, I apologise. Yes, certainly I will. I'm a senior fellow in the law school at the university, but appearing in a personal capacity.
Same spot, was it the University of Melbourne?
And I fear our link is somewhat unstable.
It is indeed. I'm just looking to broadcasting. Should we ask Mr Whitaker to log out and log back in? Will that assist us, or do we just need to just phone in?
Yep. We can give him the phone number and he can call in.
Yes, please. Thanks.
Or if I stop my video, perhaps.
The committee will suspend for 5 minutes while we just restore the link to Mr Whittaker. Oh, he's back. All right, let's try again. Mr Whittaker, can you give your full name and the capacity in which you appear today? I don't believe he can hear us broadcasting at this stage. Here we go, we've got some sound. Mr Whittaker, can you hear us?
Certainly. Madam Chair, Bruce Whittaker, I'm a senior fellow in the law school at the University of Melbourne, appearing in a... Yes, I can hear you.
It's a pretty patchy line.
We can get him the phone conference details.
So let's suspend for 5 minutes and we'll give Mr Whittaker the phone line so that we have a more stable interaction. Thank you. Good. This time, Mr Whittaker, expect a call with a telephone number to get you to dial in so that we can have the stability of a teleconference. But let's try. So your name and the role in which you appear.
Yeah, I am actually... yes, hopefully third time lucky. My name's Bruce Whittaker. I'm a senior fellow in the law school at the University of Melbourne, but I'm appearing today in a personal capacity.
Thank you. I'll go straight to Senator Scarr for questions.
Oh, he's gone.
The details for joining the phone call are on his voicemail at the moment.
So, Mr Whittaker, while you've got us, can you go to the details in your phone on a message and ring that number because the video conference is not satisfactory? We'll take evidence by voice.
I believe I will have over the phone, Madam Chair.
Okay.
Mr Whittaker.
Yes, hello.
Ah, now you sound like a real person rather than a half robot, half person. That was what we were getting before. So thank you very much for persevering and coming through on the voice. Could you please state your full name and the capacity in which you're appearing today?
Certainly. My name is Bruce Whittaker. I'm a senior fellow in the law school at the University of Melbourne, but appearing today in a personal capacity.
Thank you very much, and I'll go straight to Senator Scarr for questions.
Thank you very much, Chair, and thank you, Mr Whittaker, for joining us. And perhaps just in relation to your background, Mr Whittaker, prior to your full-time academic position, what was your profession?
I was for many years a partner in the banking and finance practice of a large commercial law firm, Ashurst, with a particular focus on secured transactions.
Okay, thank you very much. And could you please advise the committee the role you undertook in relation to a review of the Personal Property Securities Act?
Certainly. I was invited or asked in 2014 by the then Attorney General to undertake a review of the Personal Property Securities Act. The Act itself contemplated that a review be undertaken within 3 years of it coming into force, but also there'd been a lot of discussion within the industry pretty much since the day the Act went into force, raising questions about its operation. So I was invited to undertake that review. It's been mentioned a number of times already today, and I delivered the review in, I think it was February of 2015.
And in the course of undertaking that review, Mr Whittaker, was there extensive consultation with stakeholders?
Yes, there was. We had in total, I think, 5 separate rounds of consultations with stakeholders. The first round of consultations focused in particular on the impact that the legislation had had on small business, and then later rounds of consultation focused on many of the more technical issues relating to the content of the Act.
Excellent. Thank you very much. And your review culminated in the making of a number of recommendations, correct?
That is correct. I think 394 was the final number, so a large number of recommendations, some substantive in nature, others of a more technical drafting nature.
Is it possible for you to just in short form give us an appreciation of the categories of recommendations that were made, to just give us an appreciation of the issues which were identified in the course of your review?
Certainly. There were probably two overarching themes to the recommendations. The first of the two, and by far the more important, was the need to simplify the legislation. We're not the first country to have adopted legislation of this type, but our Act is at least twice as long as the corresponding legislation in the other jurisdictions and contains a very substantial amount of complexity that many commentators thought, and I also believed, wasn't necessary, and if anything, made the Act much more difficult to work with, which in turn was preventing the Act from achieving its desired objectives. So many of my recommendations went to finding ways to simplify the operation of the Act, and in particular to simplify the operation of the register that is set up under the Act. The second of the two overarching themes was to have the Act better reflect the way things actually work in real life in Australia in the financial marketplace. The legislation that we adopted was based fairly heavily on legislation from other jurisdictions where commercial practices are at times very different, but those differences weren't reflected in the way the Act was drafted. So many of my recommendations go to reshaping the Act so that it better reflects the way life works on the ground here in Australia.
Okay, thank you very much. Is it possible for you to draw out from those two categories you gave, the first, the need to simplify the legislation, the second, to better reflect commercial practice on the ground in Australia, is it possible, extrapolating further from those two categories, to provide examples of the sorts of issues that may impact in particular small business in the context of a corporate insolvency, in the context of their protecting their rights?
Yes, certainly. And perhaps a good example of that is, again, to talk about the register. The rules for registering on the PPS register are very technical. They rely heavily on complex definitions that are contained in the body of the Act, and the procedures that you need to follow to make an effective registration are at times quite counterintuitive. So it's very difficult for people, it's even difficult even for people who do have extensive legal training sometimes to know how to make an effective registration. But for small businesses that don't have legal training and don't necessarily have legal advice on hand to help them, it can be very difficult for them to make registrations in a way that can leave them confident that they've done it correctly. And one of the downsides of not making an effective registration is that if your counterparty becomes insolvent, then under Section 267 of the Act, you effectively lose your interest. So if, for example, you are a small business that is selling goods on retention of title terms to a company, you need to make a registration on the PPS register to ensure that your retention of title clause works effectively. But if you don't do it correctly and your buyer becomes insolvent, you lose your retention of title rights and the goods vest in the buyer and you're left to simply claim as an unsecured creditor.
Okay, so I want to put to you some of the commentary in a number of the submissions that we've received. The Australian Small Business and Family Enterprise Ombudsman has provided some feedback in relation to this issue, and in their recommendation 6, they recommend simplifying the Personal Property Securities Act and Personal Property Securities Register, and they then refer to some issues which they find. I just want to quote something to you to see if this accorded with the findings of your review. Quote, "The recent work of the Behavioural Economics team of the Australian Government to improve accuracy in PPSR registrations highlights this complexity. The review found that 22.3% of PPSR transactions made by users who completed the original form were incorrect, and 12.8% of the transactions were inaccurate after behavioural interventions, end quote. So is that evidence of the sort of issues which you found during the course of your review?
Yes, it is. Absolutely.
Okay, and those mistakes have serious consequences, in particular for small business, because they can lose their right as secured creditors with respect to property, correct?
That is correct, yes.
The Australian Small Business and Family Enterprise Ombudsman also gives an example in the case of One Steel Manufacturing Pty Limited, administrators appointed, and again to quote, which highlights the severe consequences that may follow from seemingly innocuous mistakes made when registering security interests. The error that gave rise to the proceeding was the use of an ABN instead of an ACN to identify the grantor in the financing statement, end quote. So is it correct to say that an issue which on the face of it would seem to be extraordinarily pedantic and easy to make can lead to catastrophic circumstances under the existing regime in relation to enforcing a small business enforcing its rights over property?
That is correct, and that's a good example of a circumstance where even a large business didn't quite understand the rules correctly and as a result made a registration that was incorrect. And yes, you are right that the rules are quite technical, particularly as they relate to describing who the borrower is.
Okay. And then the Ombudsman goes on, quote, simplifying the PPSR will make it easier and more accessible for small businesses, ensuring a greater level of protection in the event of an insolvency, end quote. Do you agree with that submission?
Absolutely, yes I do.
Okay, thank you. One more issue which the Ombudsman raised, which I wanted to put to you and ascertain whether or not this came out in your review, was the Ombudsman proposed a duty on applicants to remove their registration over a security interest in a timely manner, or a timely way I should say, would avoid asset financiers using the PPSR as a lead generation vehicle when a business might seek equipment finance in the future, end quote. Is that an issue, Mr Whittaker, you looked at in the context of your review?
I didn't look at the question of lead generation, but this issue did come up in two contexts. There is a section in the Act at the moment that requires a secured party to remove a registration once the financing is finished, but that is limited to consumers, not to corporate borrowers. There is, though, also a mechanism in the Act that allows a borrower to require that a registration be removed from the register once the financing is complete, but that's quite a long and technical set of provisions that can be difficult to apply. And one of the recommendations I made in the review was to dramatically simplify that mechanism so that it's much easier for a borrower to require that a registration be removed once the financing has been completed.
Okay, thank you. I'd like to move to ARETA's submission and section 5.6 of their submission, pages 51 and 52 onwards, provide some commentary in relation to this matter. They also give the example of the administration of the Hastie Group, where, and I quote, there were 995 registrations noted against the group's companies in the PPS register. The administrators were able to identify approximately $2 million worth of assets, but the end result was 77% of the total number of items of plant and equipment remained unclaimed. This necessitated court intervention and directions to allow the administrators to sell the assets despite the PPS interests, end quote. Is that a manifestation, a real-life example or manifestation of the issues that the current regime presents in an insolvency capacity?
It is to some extent, yes. This case certainly attracted a lot of interest amongst the legal community, as you might imagine, when it came out. And it certainly is a good example of the complexity of the issues that liquidators can face. One thing I think gets forgotten a little bit in this context, though, is that it would have been even more difficult for the liquidator if the PPSA had not been in force, because pre-PPSA there could have been lessors and vendors of equipment, and there would have been no way for the liquidator to even know who they were, let alone ask them to provide evidence of their claims. So the PPSA had improved the liquidator's position beyond where it would have been had the PPSA not been in force, but it certainly does highlight the challenges that the liquidators are going to face even with a PPSA-style regime.
Okay, thank you. I want to put to you a recommendation or suggestion which a reader has made to get your feedback if you're able to provide it. Feel free to take it on notice if you want to reflect upon it. I'll quote from a reader's submission. We suggest that insolvency law allow an external administrator, whether in a liquidation or voluntary administration, to give notice to claimants on the PPS register to verify their claims within a set period, say 15 business days, failing which their claims will be treated as unsecured or not at all, end quote. Could I have your feedback in relation to that recommendation?
Certainly, this is a proposition that a reader also puts to me through the course of the review. It's not a topic that I ended up making a recommendation on because it seemed to me to be more a question of corporations law policy than personal property securities policy, but I understand where they're coming from, and certainly from a secure transactions law perspective, I see no real impediments to that type of principle being applied. There may be some practical difficulties. For example, if a secured creditor has only a contingent claim, they may not yet be able to quantify what their claim is. But as a matter of principle, I don't have a difficulty with what they're proposing.
Okay, thank you. The last submission I'd like to take you to and obtain your feedback on was made by Mr. Michael Murray and Dr. Jason Harris. And I go to page 10 of their submission, and they note the review that you undertook, and they provide a number of what they refer to as small measures, which would be beneficial in corporate insolvency. So I'd just like to put each of these to you and just get your feedback on each of these. First, repealing sections 588FL and 588FM of the Corporations Act and leaving the vested of unperfected security interests as a matter for the Personal Property Securities Act itself. End quote.
Yep. They were recommendations that I also made in my review, so I agree with those propositions.
Okay, thank you. Their second recommendation is implementing your recommendations. So I think that's pretty straightforward. They do refer to, and I'll quote this, to reform the system of amendment demands so that asset sales and insolvency are not held up by frivolous and vexatious registrations that are not based on perfected security interests, end quote. Is that an issue you came across in the course of your review? And if so, do you have any comments in relation to that?
Yes, it is. And this, whilst it's expressed in different words, is the same point as I think Arita made about, the Ombudsman made about the need to reform the system so that it's easier for people to cleanse the register of out-of-date registrations, and that's through the amendment demand process. And as I mentioned a few minutes ago, I did make recommendations that would substantially simplify the way that process works.
Okay, thank you. And I've just read ahead the third and fourth recommendation. I think we've probably covered those in the course of the testimony you've given during your time with us. So with that, I'd like to, if I can just personally thank you, Mr. Whittaker, for attending today and for the work you've done in this space. I think this inquiry has given hopefully a bit of an added push with respect to the consideration of the recommendations made in your review. So thank you very much. Over to you, Chair.
Thank you. Mr. Whittaker, in the interest of time, I do have a number of questions, but I'll put them on notice. Thank you very much for the provision of your thoughtful report, and the committee is very engaged in following through with the considerations that you've offered there.
Thank you, Chair, and I apologise for the IT difficulties. It's the subject of a separate inquiry, but I live in regional Victoria and the internet does drop out from time to time.
Mr Whittaker, we could have a whole inquiry. I'm absolutely devastated by the reality of the lag on the economy before the failed NBN delivery from the previous government. Now, that was a totally partisan finish on what's otherwise been a great day. But the frustration that businesses are feeling and individuals it's very real. Anyway, there's work on the way to try and keep us competitive, which is an important thing.
Thank you, Chair, and thank you for the invitation to speak.
Thank you, Mr Whittaker. That concludes today's hearing. Thank you to all our witnesses who appeared and to Hansard and Broadcasting for their assistance. There were some times of trial and as usual you rose to the challenge. Thank you very much. A response to questions on notice should be provided by the 20th of January 2023. Thank you, Senator Pratt, for being online all the way from Western Australia. Thank you. Thank you, Jasper. Yes, and I think we had an appearance of the cat at one point of time. Thank you, Senator Scarr, Mr Pitt and Dr Molino for participation in the inquiry today. That ends the day. The committee stands adjourned.